All right, we are now live.
Thank you, Bryce.
Yeah.
Good evening and welcome to the City Council Conference of July 28th, 2020. We have one item on tonight's agenda, which is a discussion related to public safety bargaining units in Norman and Oklahoma generally. I'd like to recognize our city attorney, Ms. Catherine Walker, to start the presentation.
Thank you. I've got the easy job here tonight. We've got Rick Knighton here from our office, who's going to talk to you about local issues and local contracts with our bargaining units. And we've also got Kathy Terry on the call as well. She's a great attorney out of Oklahoma City who does this kind of work all over the state, and she does a great job for the city as well. So I'll turn it over to Rick. I think he's going to get us started, and then they'll tag team the presentation.
Okay, I'm going to share my screen with you guys. And it's the information that we're going to talk about today's conference. As Catherine said, I'm an assistant city attorney for about 22 years. The majority of the time I've been here, I've done labor stuff, either labor union stuff or employment discrimination type cases. And as she said, we have with us Catherine Terry. Catherine does a lot of similar work for other municipalities in this area, and we thought that it might be helpful to get her perspective with regard to how other cities may be dealing with similar issues. This was really initiated by an email or a request that the city manager received from one of our citizens. And she wanted to initiate an independent and public review of factors, what she characterized as limiting transparency and accountability in the Norman Police Department. And then a little bit more specifically to talk about legal, structural, cultural barriers that she believes have prevented from this staff from properly informing the public of incidents of misconduct, excessive force, and evidence of racism. So we're going to try to give you a little bit of why it is we have labor unions and how those are set up, which hopefully will give you a better discussion basis, so to speak, with regard to the issues that were raised by that request. We're going to talk about the Fire and Police Arbitration Act, which is found in 7 OS section 51101 through 51113. We're going to talk a little bit about the Open Records Act, specifically to the extent that it applies to personnel records that may be in the possession of the city. And then finally, we're going to talk a little bit, and Kathy's going to talk a little bit about her experience with regard to other municipalities. And she's been doing our labor arbitration since about 13. So she has a good basis for comparing what we do to what other entities in the metro area may do. All right. So first about the Police, Fire, and Arbitration Act. Police, Fire, and Arbitration Act was originally enacted in 1971. We'll talk a little bit more in detail about what we believe to be the impetus for legislature to enact that provision, which is found in 51 OS section 101 or 5111 OS section 51-101, became effective. What's in the fire and arbitration as it relates to the city is essentially the public policy. That act is set in 51-101A. And as you see there, it talks about the protection of the public health and safety. Essentially what the legislature has done is, whereas other labor unions, one of the tools in their arsenal, if they're having difficulty with regard to negotiations, is to actually go on strike. In this provision in Title 11, the legislature has effectively precluded or prohibited permanent members of any fire department or police department. The legislature has precluded them from going on strike or engaging in any kind of a work stoppage. So in essence, whereas a private labor union has that in their arsenal, public labor unions do not. They are prohibited by law from going on strike. There's another provision in Title 11, essentially that provides for a fine of $100 per day for each incident or for each person that would be engaging in a strike or a work stoppage. So effectively, if a public safety employee were to either go on strike or engage in a work stoppage or slowdown, they would be subject to criminal penalties, with the penalty being a fine of up to $100 per day. The second sentence in there is really important. It talks about although you can't or engage in work stoppage, in exchange for that, the legislature allows public safety employees to collectively bargain. And again, it goes on, as you see there in that sentence, talk about how important that is with regard to them bargaining for their wages, hours, and other terms and conditions of employment. And that statutory provision goes on to say you can engage in collective bargaining. When you come to an agreement, that agreement has to have a provision for grievance arbitration. And in this case that you see in that second paragraph, the City of Bethany versus Public Employees Relation Board, which is a 1995 Oklahoma Supreme Court case, that case says the legislature explicitly balanced the requirement that CBAs contain a no strike provision with the rights to grievance arbitration. And it goes on to say invalidating grievance arbitration would destroy this vital conscious public policy decision. So the legislature has said they can't strike, but they can collectively bargain, and you have to provide for grievance arbitration. And the courts have told us that invalidating this provision would destroy the conscious policy decision that's made by the legislature. And that case goes on to say that any dispute over the interpretation or application of any provision of a collective bargaining agreement is subject to grievance arbitration, and that neither side can bargain to exclude certain contractual provisions from grievance arbitration. And what that means is we go into negotiations, we don't think FOP should be up to instances where an officer engaged in excessive force. Well, under the FPAA, that would be.
I'm sorry. Is he cutting out to anybody else? Is anybody else having trouble hearing him, or is it just my computer?
I thought it was just me, but yeah, you are cutting out significantly audio.
Yes, he is cutting out.
I'm not noticing it.
And I think somebody needs to mute that's not talking.
Let's see if we can fix that. All right, what about now? Any better? Okay. Kind of going back to that last paragraph, talking about any dispute over the interpretation of or application of any provision of the CBA is subject to grievance arbitration, and neither side, so neither the city nor FOP, can bargain to exclude provisions from grievance arbitration. And the example that I was given is there was a movement, maybe within the last 2 or 3 years, by the legislature to try to exclude instances of excessive force by police officers from grievance arbitration. That failed at the legislature. So this provision, essentially, we can't go to the bargaining table and try to bargain a provision with FOP that would prohibit certain subjects from grievance arbitration. That would be an unfair labor practice, and there are criminal penalties also associated with engaging in unfair labor practices. All right, as that applies to our FOP contract, Article 10 of our FOP contract sets forth the provision with regard to discipline. It also sets forth the provision with regard to arbitrations, and Section 2 talks about any dispute between the employer and the FOP or any employee concerning the interpretation or application of this agreement or the actions of the parties under the agreement, or dismissal, demotion, or other discipline of an employee shall be handled in the following manner. Steps 1, 2 through 3 primarily are a grievance is filed, the chief has to respond to it. It has such a certain time period. If the union and or the grievant is not satisfied with the chief's response, they can escalate the grievance to the city manager. The city manager has 10 business days from the receipt of that grievance to issue his decision. And then there, as you see in bold, if the city manager and the grievant have not settled the grievance within that time, the FOP may notify the city attorney's office in writing of the FOP's intent to arbitrate the grievance within 20 calendar days from the city manager's response. So Article 10, Section 2, Step 4 is the provision that the FPAA requires with regard to our collective bargaining agreement with FOP. If you remember, they get to bargain. The collective bargaining has to have a provision that provides for grievance arbitration. And this is where in Article 10, you see where in our FOP contract, it does provide for grievance arbitration as required by the FPAA. The other provision that goes along with that is pursuant to the FPAA, the award of the arbitrator shall be final and binding on the parties to the agreement. We have had a couple of instances where there's some exceptions to that final and binding language. Usually it's if the arbitrator has exceeded the scope of his or her authority. We have litigated some cases in district court where we have argued, and I think appropriately, that an arbitrator exceeded the scope of his or her authority. And although we've had some success at the district court level, we have not had much success at the appellate court level. They appear to be very sold on the concept of grievance arbitration, and more likely than not are going to ultimately rule that whatever the arbitrators decided that the city is stuck with. And we've had some ones in the past that we thought were pretty egregious, but again, once you get to the Supreme Court level, once they make their decision, there really isn't any other place to go beyond the Oklahoma Supreme Court, and you're kind of stuck with whatever the arbitrator has ruled in that particular case. Kind of going back and focusing a little bit on what the original request was for, is has the FPAA prevented the city from disciplining officers? I think the answer to that question really is there have been occasions when discipline imposed by the chief of police and the fire chief, because this also would apply to our firefighters, has been amended or vacated by an arbitrator, and we weren't necessarily happy with the arbitrator's decision. But the question of whether that has prevented the city from disciplining officers really depends upon what the alternatives are. Again, right now we have under the FPAA, it allows for collective bargaining. It allows for binding interest arbitration, and interest arbitration is the process whereby the contract is resolved. For example, the negotiation process probably starts sometime in January. There are time limits under the FPAA as to when the unions have to notify the city of their intent to bargain. And a lot of times it starts in January, and depending upon the specific circumstances, you'd like to be finished with collective bargaining before the beginning of the fiscal year on July 1, but often it goes beyond July 1 and sometimes even into November, December before there's an actual agreement. However, at some point in the process, one of the parties could declare impasse, and then you would create your last best offer, the union would create their last best offer. Those last best offers would be submitted to an arbitrator, and the arbitrator would ultimately decide which last best offer to select, and his selection essentially becomes the collective bargaining agreement for that particular year. So the FPAA provides for binding interest arbitration. It also provides for binding grievance arbitration, which again, grievances being usually over interpretations of the contract, including but not limited to the level of discipline that may have been imposed on someone. And then of course, importantly, it also goes to the issue of the FPAA prohibits public safety employees from actually striking. So then the question becomes, if we took away the FPAA, again, would be an issue that would have to be resolved by the legislature. Because that is a statute, we don't really have the ability to change the statute. It would have to be done by the legislature. So let's say we were able to get the legislature to repeal the FPAA, we would then fall back to our city charter, because our city charter allows non-supervisory employees to collectively bargain. So under our charter provision, and there are some ordinances that go along with our charter provision that flesh out the mechanics of how this bargaining under our charter works, allows for collective bargaining. The significant difference in our charter and ordinances is our our interest arbitration under our charter and ordinances is not binding. So this primarily applies to AFSCME, and that's American Federation of State, County, and Municipal Employees. Their interest arbitration isn't binding. you can have an interest arbitration, but the city does not have to accept the decision made by the arbitrator. It could choose to enter a contract on what it believed was appropriate without having that issue from the arbitrator being binding. But it does provide for binding grievance arbitration. And again, those are the issues over interpretation of the particular collective bargaining agreement. And then also our city charter provision also provides that those employees cannot go on strike. So if we didn't have the FPAA, we fall back to the city charter, the only real difference being interest arbitration under our city charter is not binding. Assuming that we got rid of our city charter provision, the Oklahoma police and fire pension system is also set forth in Title 11. For the police, it starts at section 50-101. The Oklahoma police pension system requires a civil service board of review for municipalities that have not negotiated a CBA to hear appeals concerning the discharge of members. So even if we didn't have FOP, either under the FPAA or under our charter provision, police officers and firefighters in Norman would still be entitled to some level of review if they were terminated. And the other significant part about the Civil Service Board is the courts have held that that provision creates a property interest and creates due process rights and continued employment, which is significant specifically when you start talking about alleged violations of the federal constitution and the ability to go to federal court and sue the city for a due process violation because we failed to comply with the provisions of the police pension system and provide officers with a hearing if we intended to discharge them. Under 51 OS section 50-123 for the Civil Service Board, it specifically designates who can serve on that board. And the members are the mayor, 2 police officers, a lawyer, and a physician. Not really a difficulty with the police officers, the lawyer, and the physician. The problem comes in with regard to the mayors being required to be on that board because Article 3, Section 6 of our charter prohibits the mayor and council members from being involved either directly or indirectly in the appointment or removal of anyone subordinate to the city manager. So it's arguably if the mayor was required to serve on that civil service board under the police pension system, she would be, or he would be being involved in the appointment or removal of someone subordinate to the city manager. And the penalty for a violation of Article 2, 3, Section 6 of the charter is removal from office. So if we didn't have the FPAA and if we didn't have the city's charter provisions regarding labor unions, if we had to fall back on the pension system statutes, that might be a little bit difficult for us, specifically with regard to it requiring that the mayor serve on that civil service board. I've talked a little bit about the strike issue. And if you remember, the first FPAA or the first bargaining provisions in Oklahoma were enacted in 1971. On October 17th of 1969, the police officers and firefighters in Montreal, Canada went on strike for 16 hours. During that 16-hour time period, there were 6 bank robberies, 100 shops were looted, 12 fires were set, 40 carloads of storefront glass were broken, and $3 million in property damage was inflicted. And if I adjust that $3 million figure for inflation today, that would total about almost $22 million in damages during that 16-hour time period when the Montreal fire and police officers went on strike. Based on what I can tell, specifically that 2 years later, Oklahoma wasn't the only state to actually enact provisions that prohibit public safety officers from striking. And I suspect that it was probably based on this incident that occurred in Montreal a couple of years earlier, where obviously things got really, really out of control as a result of the police officers and firefighters going on strike. And what the legislature was intending to do was to prohibit those types of instances by prohibiting firefighters and police officers from going on strike. And of course, the the quid pro quo, so to speak, with regard to the public safety officers were they were allowed to collectively bargain, and then also those collective bargaining agreements had to have a provision in there for binding arbitration, and expressly as it relates to disciplinary issues. So if I go back to kind of how our agenda topic was originally submitted, and we were looking at impediments to the Norman Police Department's ability to hold officers accountable for violation of department policies or procedures. I'm really not clear on how the term independent review is being defined. Some people probably would argue that the arbitration process is an independent review. Arbitrators are typically selected from a panel that you would get from either the American Arbitration Association or the Federal Mediation and Conciliation Service. So essentially the way that process works is they send you a list of 5 arbitrators drawn at random, and each side gets to strike 2 arbitrators. So we get five names. The union would strike 1, the city would strike 1, the union would strike their second one, the city would strike their second one, and the person that remained would be the person that served as the arbitrator in that particular case. And again, some people would say that's independent. Some people would have some issues with it. But again, not really knowing how that's being defined, it's really difficult to tell whether or not that process satisfies the independent review part of that topic description. I would say that binding arbitration does impact the police department's ability to discipline officers, but the extent to which it's ineffective or doesn't hold officers accountable, in my opinion, really depends greatly on what the alternatives are. And we'll talk about that in a little bit after we talk about the Open Records Act issue. And it kind of goes back to the issue of, if you didn't have the FPAA, you didn't have binding grievance arbitration under the FPAA, you'd have it under the charter. If you didn't have it under the charter, you'd have something similar to that under the police pension system. And even if you didn't have any of those, that would not prohibit someone from actually filing an action in district court alleging whatever it is that they believe that they can allege in terms of their termination in an attempt to get their job back. There are cases in Oklahoma where police officers under certain circumstances have sued after they've been terminated or after they've been disciplined and have been able to get the courts to reverse the discipline.
Can I ask a question?
Sure.
How are the officers' performances currently reviewed beyond, like, there's been somebody shot to death or some major event? Do we have like a regular employee, like their performance ranked between, you're doing great, you're doing terrible, you're late all the time? How is that currently
Line level
documented?
Line level officers or patrol officers, their immediate supervisor are the lieutenants, and the lieutenants are responsible for performance evaluation. Every officer performance is evaluated yearly, but they also have to meet with their subordinates quarterly to go over any issues that may have come up during that specific quarter. And there's actually every quarter there's an evaluation form that the lieutenant would fill out, go over with his subordinate, and then at the end of the year, when they're evaluated for their yearly evaluation, and the yearly evaluation is what determines whether you get your merit increase. We pay our police officers a step rate system, and if you successfully pass your evaluation, then you would get a merit increase. So all those quarterly evaluations are then taken and used for the year-end evaluation. The year-end evaluation goes into your personnel file, and I believe you get to keep the quarterly evaluations. My understanding as part of that process also is supervisors are supposed to audit body cam video from their officers. They'll go in and pick a random sample of body cam video to review those to find out whether the officer appears to be acting appropriately. There's also a provision in our internal affairs review system. And the internal affairs review system, the way that that software is set up is if an officer is getting essentially a high number of complaints during a specific time period, that software system will send the IA lieutenant an alert telling him, hey, this particular officer is receiving a significant number of complaints. Maybe that needs to be reviewed. So that can give both the IA officer and that officer's supervisors the abilities to kind of look through those complaints to see if there is a pattern of something that the person is doing wrong. You know, maybe it's just something that can be easily corrected. Maybe it's something that requires some sort of remedial training. So there are multiple ways that officers' conduct is reviewed. And again, part of it has to do with the performance evaluation. Part of it has to do with the audit with regard to body cams. And then there's another provision that allows the internal affairs officer to get an alert if there's something appears to be, if that officer is receiving a significant number of complaints during the period defined in that software.
Okay, thank you, Rick. Can I ask one more question or add, is
Sure.
it legal for us, or would there be a way for the community to be able to rate or review an officer? Because I think that's where I don't want to speak for the person who emailed you, but I do think that that's where the community gets left out of this conversation a little bit. So I'm wondering if there's a way for public input on the officers other than a complaint. System. It just seems like there should be a two-way communication. First of all, I feel like our community wants to know who the bad apples are, and I understand some of the problems there, but they also want to, I think it would be good for our community to see the good things that our officers are doing, not just the PR type things, but this officer responded on 5,000 calls, and in those 5,000 calls, not one bad incident has happened, those kinds of things. Is there any of that happens?
Well, other than what you mentioned, one, there is the complaint process that if someone believes that an officer acted inappropriately, can file a complaint through the Internal Affairs Division. I do know that people routinely send letters of appreciation fairly frequently that goes in those officers' personnel files. Number three, we do have the police has his Citizens Advisory Committee, and that's one of the things I would talk about here in a little bit. That brings together a group of citizens, and they go over completed internal affairs investigations to give the chief some feedback with regard to the incidents that are submitted, with the hope that, obviously citizens see things a little bit differently than police officers. And, sometimes, if you're in a particular profession, you can become a bit myopic in terms of how you're looking at things. And it takes somebody looking at it from a different perspective to kind of help potentially to resolve some problems. So right now, there really isn't anything specifically with regard to public input into reviewing a particular officer, but I'm making a note of that so that we can talk about that issue. All right,
Mr. Knighton, but yeah, let's continue and see if we can save our questions till the end, because I have a feeling these all intertwine together.
No problem. All right, so let's talk a little bit about, we talked about whether you think that the FPAA is an impediment. That's really not for me to decide. I can just tell you that it's there, and I can tell you why it's there. And I can tell you that the place that it would have to be resolved would be at the legislature, because again, that is a state statute. And the unfair labor practice language talks about how the city has an obligation, or any of our public labor unions, in good faith. And again, it would be an unfair labor practice charge for us not to bargain with them in good faith. And again, per the statute, that collective bargaining agreement has to have a provision for grievance arbitration. So let's talk a little bit about the issue of transparency and making information available to the public. The Open Records Act is set forth in Title 51. It's 24A.1 through I think 24A point maybe 17. 24A.7 specifically deals with personnel records. And subsection A says the public body may keep personnel records confidential. One has some specifics in there that include demotion, discipline, or resignation. Number two has some provisions in there to talk about employee evaluations, payroll deductions, employment applications submitted by persons not hired, transcripts from higher education institution, and personnel files of certified public employees. Now, from a lawyer perspective, usually we read that term may to mean it's discretionary, which means the city would have the discretion to either keep it confidential or to make it public if the municipality thought that that was appropriate under the circumstances. However, in this Oklahoma Supreme Court case, which is Oklahoma Public Employees Association versus the Office of Personnel Management, which is a 2011 Oklahoma Supreme Court case, there the Supreme Court held that the examples given in A2 are per se prohibited from disclosure. And that was the personnel evaluations, the applications for people that did not get public employment, so on and so forth. Well, what that tells us when we're looking at subsection 1, which involves demotion, discipline, or resignation, if the examples in A2 are per se prohibited from disclosure, arguably the examples given A1 are also per se prohibited from disclosure. And again, that's the provision. 1 is the subsection that included documents or records regarding demotion, discipline, or resignation. In addition to the internal personnel investigations and so on and so forth. But 51 OS section 24A.7B contains exceptions to the confidentiality provision in subsection A. In particular, for our purposes, B4 says records that involve disciplinary action resulting in loss of pay, suspension, demotion of position, or termination are not subject to the confidentiality provisions in subsection A. But when I'm reading this statute, it tells me, well, in A, it says records regarding certain discipline are confidential, but in B, it tells me there's an exemption for disciplinary records that result in loss of pay, suspension, demotion of position, or termination. As that applies to our FOP contract, and the same again is true for our firefighters, Article 6 governs discipline or discharge. And of course, it goes on to say to define discharge to mean written reprimand, suspension, probation, demotion, and discharge. So what those differences in colors illustrate is, remember in A, we said certain discipline has to remain confidential. Well, for our contractual purposes, those two provisions, that provision would apply to written reprimands and probation. Because in subsection B, it says suspension, demotion, and discharge or termination are not subject to the confidentiality provisions in subsection A. So that's kind of how we've made our decisions when these issues come up. And again, the agenda topic for discussion was properly informing the public of when known incidents of misconduct, excessive force, and or evidence of racism emerge. For us, the issue would be if at the end of the day, the discipline that was imposed for any of those instances, if it resulted in suspension, demotion, or discharge or termination, it would be available, the final disciplinary action would be made available for public inspection and copying. If the discipline that was imposed resulted in a written reprimand or probation, again, unless the legislature changes the language in 24A.7 or the Oklahoma Supreme Court overrules its opinion in the Oklahoma Public Employees Association case, the legal staff's advice will continue to be that the city is prohibited from disclosing written reprimands and probation to the public. Now, how that fits into whether something is or isn't proper, I mean, I don't know that that's necessarily for me to decide, But what the issue is on those occasions when the discipline has resulted in something that was above a written reprimand or probation, that information has been made available for public inspection and copying. When it hasn't been, when it's been either a written reprimand or probation, that's been kept confidential. And again, I think that case, that Oklahoma Supreme Court case and Oklahoma Public Employees Association requires, at least at this point in the process, that we keep that information confidential. There is a case that currently is before the Oklahoma Supreme Court that has some of those issues before it. So the Supreme Court may, in this hopefully near future, give us some clarity with regard to what it meant in Oklahoma Public Employees Association. Again, as I mentioned earlier, usually we read the term may to mean discretionary, but in that particular case, the court seems to be construing the term may to mean mandatory. And again, our issue in terms of potential civil liability would be if the court meant what it said in Oklahoma Public Employees Association and we make public some discipline that we shouldn't have made public, that potentially gives that employee a cause of action against the city for a violation of his or her privacy rights. So that's why we've been really, really careful trying to make sure that we stay abreast of those cases and to also try to be a little bit conservative in terms of our advice about when something should or should not be released. I probably would be a little bit remiss in that respect without mentioning the open data portal information that the police department does make available. It's at that website that you see there, and the data sets include not only Norman demographics, but the complaints and inquiries filed against police officers, our use of force complaints, the number of contacts that the police department makes, the community engagement that they engage in, and also instances of hate crimes. And they have been participating in that program since 2016. So if you go to that web address, you can get information with regard to all of those data sets that go back to 2016. And then the other thing that got mentioned a little bit earlier had to do with our Citizens Advisory Board. Again, that is the board that was set up to provide the chief with some feedback with regard to critical incidences, and also, how the department goes about investigating police officer misconduct issues. And again, just providing an opportunity for the public to have some input with regard to how the police department goes about policing itself, so to speak. If I'm clear, I read on there, though the members on that board rotate the members, their membership or their appointment to those boards rotates. It's staggered, but they're currently accepting applications for anyone that wants to try to replace someone that's currently on the advisory board. And if you see that link, the link that says apply to be a member of the NCAB, that's the link that you would go to, the drop-down menu that you would go to get an application to submit to the police department to try to become a member of that Citizens Advisory Board. With that, I'm going to turn it over to Kathy and let her talk a little bit about her experience with regard to some of these issues, not just in the city of Norman, but also in the metro area.
Before we dive into other cities, if it's all right, I think, can we take a few questions now for any Norman specifics? I can't see everybody. So anybody want to jump in with Norman specific questions?
I have a question.
Is that Councilmember Perry?
It is.
Okay, proceed.
I understood that once we went through negotiations with the fire department and police department in the past, and we went through arbitration, if city council was not prepared to accept that arbitration, we could go to a vote of the people. Is that correct?
That is correct.
Okay.
The FDA, the interest arbitration provision provides that after the arbitrator issues his or her decision, if the decision is in the favor of the labor union, then the governing body of the municipality has the option of sending the election to a vote of the people. Since I've been here for 22 years, we have actually never had an election. There was one time when we threatened the unions with having an election, but after the arbitrator ruled in their favor, the mayor at that time got 4 other council members instead of going with what they had taken the position during that bargaining process that if won, we would send it to an election, but once they won, we didn't. There was another instance where there was one year we didn't have a contract because the process is if the municipality has indicated it's going to send it to the arbitrator has to approve the ballot language. And the statute with regard to the ballot title requires that you put the total contract last best offer on the ballot. IFF construed that to mean the difference between the last best offers from both parties. The city construed that to mean the total cost for the entire contract. And the arbitrator ruled in IFF for their ballot language. We actually challenged that judicially. We actually prevailed on that issue. By the time the decision was rendered, we were beyond that this year, come and gone for the next year. So we essentially just didn't have a contract for that particular year. But that is possible, but there's still some, the issue of timing, because obviously you have to get that vote done before July 1 of the next year, or you essentially don't have a contract. So it's really important under those circumstances to try to move that bargaining process along, sooner than later, as opposed to waiting. I mean, the reason behind waiting has a lot to do with the finance director's projection. You can imagine if the finance director is projecting 1% increase over the next year, and IFF comes in with their labor finance person and is projecting a 4%. The longer IFF waits during that next fiscal year, they're going to start getting information from those tax returns or from those sales tax revenue to be able to make it, at least in their opinion, to make a better determination as to whether we're going to have a 2% increase or a 4% increase. So sometimes labor unions can kind of sort of drag their feet because they're waiting for type of information before ultimately deciding what they are willing to accept. But that is a possibility under the FPA.
Councilmember Patron also has a question.
Okay.
Real quick, what was the caption on the case that you were saying is before the Supreme Court right now?
I don't know the name of that case. I believe it's out of Owasso.
Okay.
But I don't know the style of it.
Okay. If in the future, can you shoot me an email just so that I'd like to keep track of that? That sounds interesting. And then on the internal affairs investigation, are the results of those made public since they go to NCAB?
When you say the results of those are made available on the open data portal, but they don't include any specific identification information. In other words, it doesn't tell you the name of the officer and it doesn't tell you the name of the company. But the demographic information is available on that open data portal.
Okay, is the open data portal the same information that goes to NCAB?
When you say NCAB, the answer is yes and no. NCAB would review probably more in detail the investigation, but they are not provided with the names of either the complainant or the subject officer. But the important thing about it is NCAB, those meetings are confidential per their governing documents. The information that those individuals receive meetings or during their participation in that process are confidential. And the only person that can speak for that board is the chairman And the chairman can issue a letter to the chief of police regarding whatever issues the board thought whatever issues the board thought should be forwarded to him. But those individuals are not, their provisions do not allow them to make public statements with regard to the cases that they actually reviewed.
Okay, and does the mayor appoint those board members?
No, that is a chief of police board. So that the members on that board are appointed by the police.
Okay, so is there a public board that's representative of the citizens?
Well, the people that are on that board are citizens, I mean, are public citizens. So if the question is there a board that is appointed by the mayor or council to address those issues? The answer is no. And one of the difficulties with that has a lot to do with the issue of confidentiality, because our council has a resolution that requires that all of its committees comply with the Open Meetings Act. And because some issues that you would talk about in the context of reviewing internal affairs information, you probably would have to keep confidential. There isn't, under the Open Meetings Act, there really is a reason to allow a advisory board to go into executive session to review information with regard to internal affairs investigation. So that was what we were talking about, how the Citizens Advisory Board was to be made up and who was to appoint it. That one of the issues that we did talk about was there probably does need to be some confidentiality. And what also goes along with that is because our boards, by council's resolution, required to comply with the Open Meetings Act, that wasn't possible with regard to this particular committee.
Okay, and is it possible to, on the city's end, and if not the city, then I know that we can ask another elected official, but to get an AG opinion on that subsection A1?
In terms of what?
Since you imply that the subsection A2 or whatever it was on that statute is no longer a permissive, but the may becomes a must or cannot. Is it possible for city legal to ask for an AG opinion on their interpretation of the employee record?
No, the Attorney General's office issues opinions and legislators. This is an issue of political science.
It's cut now.
It's Brenda, I think it's because your mic's on.
It's not that.
Sorry, and I said Brenda, and I didn't mean it. Came up.
Yeah, but it's not that.
Okay, so I know that if the city legal can't do it, we can ask our state rep or a state senator to do that, though, correct?
You could.
Okay, and then how often has or do you know of any internal affair investigations that have resulted in a finding of actual misconduct on the part of officers? I mean, does that happen very often?
Well, if you go to the open data portal, and every time you see an investigation and it says sustained, that would be an instance when IA has conducted an investigation and come to the conclusion that the officer violated whatever policy was alleged to have been violated. So that happens, yes, I would say. I can't give you the exact numbers, but it's not unusual for the Internal Affairs Division to come to the conclusion that an officer violated policy.
Okay, thank you, Mr. Knighton. I'm going to pass the floor.
All right, let's continue on with our guest, please.
Councilmember Foreman has a question.
Okay,
Sorry.
Councilmember Foreman.
Just a quick question. So if it's not available to the public to know what happened, the person who filed the complaint, what's the process for them in learning the outcome of that complaint?
The person who filed the complaint is advised of what the outcome was. Now, whether they're involved, they would be advised of whether a complaint was sustained or not sustained, or whatever the disposition was. Again, and unless the discipline results in suspension, demotion, termination, if the discipline results in suspension, demotion, or termination, they would also know what the discipline that was imposed. If it were a written reprimand or probation, they would not be advised of that level of discipline.
Okay, thank you.
All right, let's proceed.
Hi, well, I want to thank you for inviting me to join you tonight and talk about some of my experiences with other departments, both police and fire, and provide a little bit of insight about how Norman compares to some of the other things that I'm seeing in the other areas. I do want to follow up on the previous question real quick. We did have, with the city of Norman several years ago, an instance in which a complaint was made about a police officer. It triggered an IA investigation. The IA investigation sustained the complaint. The police officer was disciplined. The police officer and the union proceeded to pursue that grievance all the way through arbitration. And as Rick explained, I've been doing the city of Norman's labor arbitrations since 2013. And this was one of the ones that proceeded all the way to arbitration, which is when I get involved. In that instance, councilperson, the citizen actually came and testified. So while there are instances in which a complaint about a police officer or any other union member at the city of Norman may be made by a citizen, and the citizen may be told, your complaint was sustained, disciplinary action has been taken, responsive action has been taken, and the citizen may not know the exact what happened. They may not know whether it was a written reprimand or probation or something like that, but they would know that discipline action was taken. If it proceeds to arbitration, it is very likely that we will bring the citizen in to testify at arbitration, which, as many of you likely know, is sort of like an informal or casual trial, but does take evidence. In those cases, this case in particular that I'm thinking of, the citizen was, not happy about spending his day testifying, but certainly believed in the validity of his complaint and how important it was, and was very helpful in that process. And that has been my experience both with the city of Norman and with other municipalities, that oftentimes citizens, if it goes to arbitration, are involved. And in those cases, of course, because they're testifying, they do know the exact outcome. They would know, for instance, an officer received probation or was suspended or was terminated, and I'm being asked to testify. They know the outcomes in those cases. So, as Rick mentioned, I've been practicing law for almost 25 years now. A lot of my practice has focused on public safety, police and fire issues all across the state. In the last decade or so, I've really narrowed my practice here to the metro area. Not only do I work on labor and employment issues with the city of Norman, and that's across all three of the city of Norman unions, police, fire, and ASME. But I also work with several other metro area municipalities. And three in particular, I do quite a bit of work for. I have not worked with the city of Oklahoma City, but I have worked with some other departments. I'm happy to tell you that I've worked with Edmond, I work with Midwest City, and I work with Moore. And at any given time, I probably have 1 or 2 projects going for each of those cities. And I not only do I do the labor side, and when I am on the labor side, with very few exceptions, and occasionally there are exceptions, but with very few exceptions, I'm always on management side. It's always representing the municipality on that side of it. The other part of my practice, I do defend law enforcement officers in excessive force cases. And in those cases, in the past decade or so, that practice has also narrowed a little bit. I am almost always representing the individual officer and I work in conjunction with usually another law firm or an in-house attorney like Rick, who would be representing the city or the corporate municipality. And so, as you might imagine, in those circumstances, it's not uncommon for the interests of the officers versus the city itself to be slightly, very slightly divergent. But because there is that slight potential for divergent, we have separate counsel. And so that is to say that sometimes I'm representing municipalities, sometimes I'm representing officers or individual public safety officers, including firefighters and other folks who may be involved. And they dovetail a little bit. But here we're talking about the union and the labor and employment issues and how that sort of stacks up with those other departments. So those three departments, the other three departments I mentioned, Edmond, Midwest City, and more, are the ones that I've done the most work with besides Norman over the past decade or so. And I can talk a little bit more conversantly about them. I will obviously not give you any specifics for some of the issues that Rick has raised about any particular issues I'm dealing with at those departments, but I can talk to you about how they do things internally and how it compares. And the first bullet point here is the police department in Norman, their internal investigations department is quite effective, and it has very detailed procedures and documentation management. And I have worked through the years on various issues with Lieutenant Wishon, who is no longer in that department, but some of his investigations are still coming through the pipeline, and Scott Fennell. And recently, Stacy Clement has joined that department, and I have not worked with her yet, but I'm sure that I will. And Norman's procedures are more detailed, and their document management system is quite good. It varies across the other departments that I work with. One in particular is comparable to Norman. The other two struggle a little bit more in that area. The way that Norman documents its interviews, the way it documents its records, the way it uses summaries and tracks the incidents is very effective. And when we get to arbitrations that are the result of an internal affairs investigation, we do not find ourselves sort of missing documentation as it relates to the police department. And so you guys are ahead of the curve among your local peers here. And that is a benefit to us, of course, when we're heading into adjudicative proceedings. I talked about this with Rick, and he knows we've been working together for several years now, and he knows, but it is not uncommon for city attorneys' offices to know this, that the union leadership is really, in my opinion, the key factor in trying to determine how many arbitrations are we having, how many issues are we having, how collaborative is the environment. Of course, on the management side, on the city side, you may have someone who's resistant, but I find more often than not, whether there are a lot of grievances that proceed to full-on arbitration, a lot of disciplinary events in which those disciplinary actions in this case, we're talking about a police department, would be challenged, really depends a lot on who the union, frankly, president is. There is an ebb and flow to that. As you know, union presidents sometimes can be very aggressive, and we're going to challenge every decision that's made by management without our consultation. We're going to challenge every disciplinary action. If we don't challenge the disciplinary action, the union member will get mad at us for not representing him or her, and therefore we'll be in trouble with our membership. So we are going to challenge, even though in our heart of hearts we don't believe that disciplinary action is unwarranted. That is a prevailing thought that shows up in some union leadership. When when unions have more collaborative presidents that can work through issues with HR, the city attorney's office, and of course, department management, those grievances tend to wind down. And of course, as the grievances tend to wind down, so do the arbitrations, the full-on arbitration, which if you haven't figured this out, I apologize. The grievances proceed administratively, and then the last result is typically the arbitration where you have this mini trial, so to speak. So union leadership is key. For instance, there's been in years past in Edmond, some of the union leadership was very aggressive. Now it's less aggressive and more collaborative and trying to work through issues before just running off and filing a grievance or proceeding to arbitration. And some leadership in Moore right now is incredibly collaborative and working proactively on all sorts of new issues. And some of your, there in Norman, some of your union leadership is more aggressive as opposed to others. And so you might see more grievances and more arbitrations in one department as opposed to another. And of course it also depends. And so one of the challenges, as you might imagine, for all of your management is to collaborate with union leadership. So if you are ever looking at your numbers and the data on the data portal and you're thinking, why am I seeing this many arbitrations or this many grievances, or you're talking to the city attorney's office, that is a big factor. It is an unfair labor practice for the city to interfere with the union's election and selection of its officers. So we've just noted that. One of the things that came up in the way that the inquiry was provided to each of you was what if an independent review would look like. And there's been some questions on that as well. Rick talked a little bit about the chief's citizens advisory board, where the chief appoints the members. And that process is very similar to what Oklahoma City was using at one point. And here in 2020, I'm not sure if that board still exists in Oklahoma City, but it has existed in the past 5 years or so. And there was some controversy about it because much of it is private. And what are the challenges of having a citizens advisory board if what they're doing is behind closed doors? But Rick shared with you why our state laws sometimes mandate that. I have seen in my career over the past 20 years or so, there is a sort of ebb and flow to these citizens advisory boards, and sometimes they're called citizens oversight boards. And in my perfect lawyer world, I would like to see, I see those two things as sort of at the either end of a spectrum, and I'd like to see some sort of way to get a mishmash of those two things. When we talk about citizens advisory boards, what usually comes in is the chief of police saying, here's my admitted struggles, here's my strengths, these are the things I would like for my department. Here, look at our data, you tell me if you agree. And oftentimes on a citizen advisory board, the response might be, yes, chief, good job, we agree. On the other side of the coin, or the other end of the spectrum, excuse me, would be in an oversight board. And those oversight boards tend to come in with the opposite perspective. There's problems here, we're gonna fix, we're gonna challenge. And so when folks come in, depending on how the board is structured and to whom it reports, they end up reaffirming their mandate in my mind and in my experience, rather than really sort of working collaboratively towards change. So if there's some way to hybrid that, if you as a city council and city leadership are looking at that, I would encourage you to sort of look at what an oversight board is, look at what an advisory board is, and try and take the best of both of those. And of course, work closely with Rick and Catherine about how to deal with the Open Meetings Act and whether even such an animal is possible, because to date, no one's really sort of successfully figured that out, where you can have true, good oversight and advisory collaboration and yet do it within respecting the Open Meetings Act and the Open Records Act. I will tell you that creating an independent entity to do investigations, we don't have any such entity around here. The FBI and the OSBI, they come in when there's criminal implications for, if we're talking about a police officer's conduct, when there's criminal implications of it, the OSBI or the FBI would get involved. But short of that, there might not be. And I'm not saying that conduct is only serious if it's criminal. That's not true. You can have constitutional violations that may not rise to a criminal level, but are very, very serious. And so short of that, where do you find someone to do an independent investigation? And if you guys figure that out, let me know, because that would be a valuable tool for me. A part of my practice is occasionally I will be hired to conduct an investigation. And it takes a long time because, of course, I can't stop my entire practice and only do an investigation. So when I get hired, the investigation protracts, and that's very frustrating for the department and the subjects of the investigation, but it's just sort of the nature of the beast. And the other trick is that I advise municipalities. So when the municipality is hiring me, a union member who might be the subject of the investigation, or the union itself, may think, well, she can't be objective. She works for management. And so a lot of my priority is demonstrating and showing that in the fact-finding phase, I really am about fact-finding. I really am about investigating. And once I've put that role to bed, I may transition to give legal advice, but it will be done so very carefully and within the bounds of the ethical rules. And certainly, the fact-finding part of my phase would be over. So I have done that in the past. It's protracted. It's not ideal. I am in the middle of an investigation right now that has been expanded longer, even because of the current public health crisis and not being able to interview folks. As you might imagine, that was pretty difficult for a while. So finding an independent agency to do that, a full-on factual investigation, as opposed to an internal affairs department, is very unusual and very tricky. Does anyone have any questions about what the other departments are doing?
Mayor Clark, I've got a question.
Sure.
First of all, I just want to say, I don't know that I've ever been in a room with 3 Catherines, with Catherine spelled exactly the same way. So feeling a little personal pride there. But I do have a question. So are disciplinary records or complaints confidential even to other city departments or staff? Because one of the reason I ask is because one of the conversations that I've been having with some members of the community who are deeply invested in this issue is a recognition that there are many people out here who have either had themselves so many bad experiences with police officers, or have had family or friends or, a family history of that they don't even feel comfortable making complaints directly to the police department. So one of the things that we were talking about is a reporting system that is hosted outside of the police department that still sends a copy of the complaint to the police department, but also to another city department. Of course, we were thinking something like city legal or the city manager's office, so that there is just that first, the communication isn't going directly to the police department, which may encourage citizens who have had these bad experiences to reach out more often maybe than they do, but to also give another layer of oversight, hopefully kind of under that shield of confidentiality, so that either the city attorney or the city manager also is able to kind of monitor the buildup of complaints and, maybe recognize that, wow, this particular officer is getting a whole lot of complaints about it, and then can kind of work internally with the chief of police and internal affairs to see what exactly can be done about it. So I just didn't know if you had any thoughts on that.
I do, but certainly Catherine and Rick, if you would like to go first, you're welcome to.
Yes. Our ordinances provide for certain employees that are confidential. Specifically in section 12-105, it does talk about employees of the city attorney's office being confidential. So the example to that is obviously in the context of, number one, usually during an investigation, if the internal affairs lieutenant has some questions, legal questions about what's going on, he's probably going to come to me and ask me those questions. So I'm going to have some sort of an idea. I don't keep track of every complaint that's filed. I'm not involved in every investigation, but I do get involved when they've got questions about legal issues. I also get notification of, when discipline has been, when I get notification when an investigation is completed and there's a sustained finding such that the employee would be entitled to a pre-disciplinary meeting. I attend most of the pre-disciplinary meetings. I can't necessarily get to all of them. So the city attorney's office is one of those entities as defined by our ordinances that provide for confidential employees. The other departments specifically mentioned is the personnel department or the human resources department. And the city manager can designate other department heads as being confidential, but if you can imagine, if you were to get outside of probably legal and HR in terms of that designation as it relates to police departments, I'm fairly certain you probably would get a grievance from the labor union with regard to that, because that would appear to be outside the scope of, who really needs to be involved in those matters. So yes, there are confidential employees over and above those in the internal affairs division of the police department.
Okay, so it kind of sounds like city legal would be a place where those complaints could also be directed, or maybe hosted on the city legal side of the website, and copies still going to the police department and internal affairs. It's just recognizing that there are individuals who have bad experiences with police officers who don't necessarily feel comfortable going to the police department to address those. So I appreciate knowing that, because that's kind of what I was thinking.
Yes, and council person, I absolutely, city legal, and depending on the nature of the complaint, HR. And if it's a police officer was rude, a police officer, told me something that wasn't true, I know it wasn't true, that sort of thing. And none of that is good. And I don't want to downplay that, but that's probably an HR type thing. If it's and Rick would know that if he got it in legal, he would probably involve HR as well. And of course, if we're talking about constitutional rights, civil rights, all the things that are prevalent in the news right now, then of course that would probably be right to city legal. Yes. And I will tell you that we have the case that I mentioned earlier with the city of Norman and the citizen who made the complaint. He did not make the complaint to the police department, as you might imagine. He called a council person, and the council person went straight to city legal and to HR. And it worked its way through the channels just as smoothly as you would hope.
Well, I like all of that. That sounds very promising. I think that that's kind of a gesture that we can make to the communities who have been trying to tell us that, they have concerns with the way things have been done. And so I excuse me, I appreciate the clarification of that, because I certainly didn't want to get too excited about it or try and proceed down that path until I knew whether or not it was viable. So.
All right, before we go much further, I have a correction I need to make. Our Citizens Advisory Board, they actually select their own members. Initially, the initial board was selected, but when someone goes off the board, they solicit applications and they actually pick the replacement for the person that's leaving. So the police chief does not have any input or any role with regard to selecting the members of that board.
So that's a little bit closer to maybe a hybrid. One of the things I think I might also mention, as far as comparing municipalities, because one of the questions addressed talked about union contract terms. And the FOP contract at the city of Norman is very detailed with regard to its grievance procedure and grievance resolution and proceeding to arbitration. And that's in all matters of discipline, from written reprimands all the way up to termination. That is not the case in the other union contracts that I see. Edmonds is quite detailed. Midwest Cities and Moores are not that detailed. I have not, someone might think, well, great, if it's not as detailed, then that leaves more flexibility for management and city legal and HR to take responsive action and quicker action. That has not proven to be the case in my practice. In the cities where the collective bargaining agreements are simpler and shorter and don't have as much rigidity with regard to, in particular, the grievance and arbitration proceedings, I tend to find what we end up doing is fighting about what the process is, and that slows it down a lot. And then at the end of the road, you may not even agree. Oftentimes we found ourselves going, okay, well, we can fight about the art process, but this is the way we're going. And at the end, if you don't like the outcome, then you can bring up the process. So we'll go all the way through, we'll get to an outcome, and we may then find someone saying, okay, well, now I didn't like the process I told you before. And so, and the fact that your legal department through the years has worked with your union, all three of your unions, by the way, and the processes are slightly different in each of the 3 collective bargaining agreements. But the fact that City Legal has worked with each of the unions through the years, just this living and breathing document that keeps moving and keeps moving. And there's a real detailed procedure in there. When you read that, I hope that you won't go, oh, this is crazy. This is a nightmare. It actually goes very quickly, very smoothly. It's built in, and it eliminates a lot of the procedural quagmire that I have in some of the other departments.
Can I ask a question?
Yes, of course.
Yep. Mayor, I don't know if you're able to see the hands or not. Okay, so at the end of the day, Ms. Terry, okay, as heated of emotions as might be surrounding this topic, both in the country and in our community right now, where everyone 100% agrees is if there are bad apples, we need to be able to get rid of them, because it's, you know, it's not good for department morale to get pulled down by the actions of a few. And at the same time, it's not good for the community to feel like the police department is, you know, everyone's acting in the same way as these few bad apples. And as we know, a few bad apples can spoil the whole bunch. And that's what they mean by that. So how do we do it? If what I'm hearing from Mr. Knighton is, well, this is just kind of the way it is, and nobody can know what happens at the police department, and the union could have a representative that no matter what they do, you're not going to get rid of them. If you're sitting in our position and this is where 99.99% of the population agrees, how do we institute that policy here to where it's, when it comes to officer discipline and getting rid of those few bad apples to make everybody safer, how do we do that?
Well, it's difficult. You're not wrong. One of the things that Rick was addressing is the collective bargaining agreement, is the fact that there is a union contract in place, an impediment to discipline. In my experience, I don't believe it's impediment to the fact of discipline, but I have had many conversations with many department heads, not only in public safety, but in all union environments, including private unions, you know, private sector unions as opposed to public sector unions. And the existence of the collective bargaining agreement, I think, makes management less likely to discipline as severely as they would hope. Meaning, if I terminate this employee, I am definitely going to get a grievance. They're going to go all the way to arbitration. The employee will have nothing to lose. The employee will definitely challenge to get their job back. But if I suspend for 2 days and probation for 6 months, maybe that employee will not grieve. So there is a hesitance to pull back, I think, on the level of discipline because of the availability of a grievance procedure and arbitration. But I will say this, the concept of discipline is designed to correct behavior. It's really not designed to be punitive. And so in that regard, that's part of the sort of baked in policy into the grievance procedures and into the reasons legislatures let public safety officials have collective bargaining and have grievance procedures for discipline, is because the idea is not to terminate someone. The idea is to correct behavior for performance. And so it is sort of incentivized to something short of termination. Your point about the really bad actor and what do you do? The lawyer in me, she has said to probably 6 clients through the years, if you know you have a problem employee, and this isn't going to be the last time you have this employee. Oftentimes I will say, discipline appropriately. If the appropriate discipline is termination, terminate and let this work its way through the grievance proceeding, and hopefully we'll win at arbitration. And if we don't win at arbitration, we will negotiate to end the job. And that's expensive for municipalities, but that is often the case, because negotiating to sever employment from a lawyer's perspective is often less expensive than negotiating to reinstate employment after a grievance. So that is a conversation that I have a lot. So what can you as council persons and as the mayor do is to work closely with city legal, and city legal reports directly to city manager in Norman. So Rick and Catherine would talk to the city manager first about the personnel issues, and at some point then they would come and report to you about the personnel decisions that have been made, but some understanding of from the elected officials and your body about why sometimes we just settled a case or entered into a severance agreement with an employee who was a problem. Why did we do that? That's the answer. And so oftentimes that is the only available resolution. And transparency is ideal. I don't think anyone really disagrees with that, but it is difficult in the environment within the constraints of both the Fire and Police Arbitration Act, but also the Open Meetings and Open Records Act. It's very difficult in the state of Oklahoma.
Okay, if I can ask a follow-up.
Sure.
It's going to be a very short one. We are now at 6:30 p.m.
Okay, really quickly, what FOP contract points for discipline are negotiable for the city standpoint? I mean, I understand they have a right to grievance procedure, but what can we say as far as when it comes to XYZ, we're not willing to negotiate on this type of thing? Like, is there any part of the disciplinary procedure for the FOP contract that council can say, we're not negotiating on that point? And also, is it proper to incentivize the good apples to report?
For clarification, the difficulty with regard to council being involved in the negotiation process for CBAs is the charter provision that prohibits council from being involved in.
Okay, strike that to city legal. Sorry. My point is there any part, I don't really care who the person is that's doing it. My point is it possible to say we're not negotiating for this area? Yes, you have a right to grievance, whatever, you go ahead and make a grievance and you'll have your day in arbitration. But when it comes to if our city manager decides that, or city legal or whatever, that you're abusing your privileges that you have through your job, this is one area where the city isn't dealing with union contract per se. We're dealing internally, and if you want to decide to file a grievance, that's fine. You can file it. And again, can we incentivize the good apples to report on the bad apples?
The trick here is, if I hear what you're saying, is there isn't a part of the collective bargaining agreement that says, okay, this area is outside of collective bargaining and management has unfettered discretion in this area. There is a clause in the collective bargaining agreement. If you read it, Article 2 says management rights. These are management's rights, but then it always says and when it comes to discipline, it will say subject to the grievance procedures. And so that's already baked in, and backtracking from that to change the terms of the collective bargaining agreement to accept something out could, one, violate the Fire and Police Arbitration Act, but two, even if the union, and that's even if the union was on board, but very likely the union would not be on board, and it definitely couldn't be done except within the confines of the collective bargaining agreement negotiation, which means when the agreement came out for renewal, the union would have its negotiator, the city would have its negotiator, and they would try and agree on terms of the new collective bargaining agreement. As you might imagine, sort of building in something like that would be resistant by the union. But even if you could get the union's buy-in, it would probably violate the Police and Fire Arbitration Act.
Assuming it didn't violate, can't we send it to a vote of the people?
Well,
City charter?
if it doesn't violate, I mean, you could go all the way through, send it to the vote of the people, and then have a court challenge on it. And then the resolution could go, in theory, all the way to the Oklahoma Supreme Court, about whether, even though the city citizens voted on this provision or voted to reject this provision or accept this provision, either way, the Supreme Court could still say it violated the act, and probably would say it violated the act. Probably, depending on the circumstances. Of course, I can't predict what type of provision you're talking about, but it would likely, what you've given me in general, I think would likely end up violating the FPAA.
Okay.
And can you incentivize?
Okay,
Yeah.
we're gonna have to wrap it up, you guys. I'm sorry, we've gone over and we have 42 people on this call ready to get to the meeting. So if you would be interested in continuing this conversation, because it's obviously very detailed, we can definitely request us doing so in a study session or council conference going forward. But I appreciate Ms. Terry being here today. Your expertise has been very helpful. Clearly, we have a lot of questions and it is complicated. So council members, I apologize, but we are already 5 minutes behind. And I know that we need to take a break before we dive in. So with that, Mr. Knighton, thank you. We will be in touch, I'm sure, to talk about the next steps going forward. But for now, please go ahead and turn off your video and mute your audio, and we will be back at 6:40.
Good night, everyone.
Bye,
Thank
Kathy.
you.
Thank you.
All right, Ms. Esri, it looks like I see 8 council members here. Let me know when we are ready to go, please.
That's what I got at home. Okay, you want me to go ahead and call the roll, Mayor?
We'll get to that in just a moment.
Okay.
Okay. Good evening and welcome to the City Council, Norman Utilities Authority, Norman Municipal Authority, and Norman Tax Increment Finance Authority meeting of July 28th, 2020. Madam Clerk, will you please call the roll?
Councilmember Bierman,
Here.
Councilmember Perry,
Here.
Councilmember Patron,
Present.
Councilmember Hall,
Here.
Councilmember Wilson,
Here.
Councilmember Foreman,
Present.
Councilmember Holman,
Here.
Councilmember Peacock,
Here.
Mayor Clark.
Here. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag
Of the
United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Item 3, approval of the City Council study session minutes of March 3rd, 2020, City Council conference minutes of March 10th, 2020, City Council special session minutes of June 23rd, 2020, City Council, Norman Utilities Authority, Norman Municipal Authority, Norman Tax Increment Finance Authority minutes of June 23rd, 2020, excuse me, and City Council special session minutes of July 7th, 2020. I need a motion to approve the minutes.
So moved.
Second.
The motion on the floor is to approve the minutes. Madam Clerk, will you please call the roll?
Councilmember Bierman,
Aye.
Councilmember Perry,
Aye.
Councilmember Patron,
Aye.
Councilmember Hall,
Aye.
Councilmember Wilson,
Yes.
Councilmember Foreman,
Aye.
Councilmember Holman,
Yes.
Councilmember Peacock,
Yes.
Mayor Clark.
Yes. Item
It was
4.
approved unanimously. I'm sorry. Sorry about that.
We will get through this. It's okay. Item 4, Resolution 2021-25, recognizing and commemorating the 30th anniversary of the Americans with Disabilities Act. I'll entertain a motion to acknowledge receipt of the proclamation.
So moved.
Second.
The motion on the floor is to adopt or reject the resolution. Madam Clerk, will you please call the roll?
Councilmember Bierman, Councilmember Perry.
Aye.
Bierman. Did you answer Bierman?
Aye.
Okay. Councilmember Perry,
Aye.
Councilmember Patron,
Aye.
Councilmember Hall,
Aye.
Councilmember Wilson,
Yes.
Councilmember Foreman,
Aye.
Councilmember Holman,
Yes.
Councilmember Peacock,
Yes.
Mayor Clark.
Yes.
The resolution's adopted unanimously.
Thank you. A resolution of the Council of the City of Norman, Oklahoma, recognizing and commemorating the 30th anniversary of the Americans with Disabilities Act. Whereas July 26, 2020 marks the 30th anniversary of the enactment of the Americans with Disabilities Act of 1990, the ADA. And whereas prior to the enactment of the ADA, people with disabilities were often segregated and denied equality of opportunity based on fear, ignorance, prejudice, stereotypes, labels, and pernicious mythologies. And whereas the ADA rejects these precepts and instead embraces the precept that disability is a natural and normal part of the human experience that in no way diminishes a person's right to fully participate in all aspects of society. And whereas the ADA has been referred to as the 20th century Emancipation Proclamation for people with disabilities, and whereas the goals of the ADA include equality of opportunity, full participation, economic self-sufficiency, and independent living. And whereas the ADA has played a historic role in enabling people with disabilities to fully participate in all aspects of society by removing barriers to employment, public services, public accommodations, public and private transportation, and telework. Whereas state and local governments and businesses recognize the public interest in extending civil rights protections to all people, including people with disabilities. And now therefore be it resolved by the Council of the City of Norman, Oklahoma, that the City of Norman recognizes and commemorates the 30th anniversary of the Americans with Disabilities Act of 1990 and encourages agencies, businesses, and all members of the public to celebrate the advancement of the American dreams for all made possible by the enactment of the ADA. Item 5 is the consent docket. This item is placed on the agenda so that the City Council, by unanimous consent, can designate those routine agenda items that they wish to be approved or acknowledged by one motion. I need a motion to place items 6 through 14, excluding item 13, which has been withdrawn on the consent docket.
So moved.
Do I have a second?
Second.
The motion on the floor is to place items 6 through 14, excluding item 13, which has been withdrawn on the consent docket. Madam Clerk, will you please call the roll?
Councilmember Bierman,
Aye.
Councilmember Perry,
Aye.
Councilmember Petrone, Councilmember Petrone,
Sorry, aye.
Councilmember Hall,
Aye.
Councilmember Wilson,
Yes.
Councilmember Foreman,
Aye.
Councilmember Holman,
Yes.
Councilmember Peacock,
Yes.
Mayor Clark.
Yes.
The consent docket placing has passed unanimously.
Thank you. Item 6A, ordinance 2021-6 upon first reading. Adding Article 5, creating the position of municipal auditor to be appointed and removed by the City Council, and renumbering article designations set forth in the charter after Article 5 accordingly. Item 6B, ordinance 2021-7 upon first reading. Authorizing a special election in the City of Norman on the 3rd day of November 2020 for the purpose of submitting to the registered voters the question of approving or rejecting ordinance 2021-6, proposing to add Article 5, creating the position of municipal auditor to be appointed and removed by the City Council, and renumbering article designations set forth in the charter after Article 5 accordingly. Item 6C, Mayor's appointment of Liz Barfield to the Public Art Board. Item 7, submission of the Finance Director's investment report as of June 30, 2020. Item 8, submission of the monthly departmental reports for the month of June 2020. Item 9, submission of the annual report of the Norman 2025 Land Use and Transportation Plan. Item 10, acceptance of a grant in the amount of $5,000 from the Blue Green Alliance Foundation on behalf of Healthy Babies, Bright Futures and the Mayor's Innovation Project to be used for a Healthy Babies Initiative Community Access Pop-Up Spots, or CAPS, in conjunction with the Cleveland County Health Department and other community agency partners. Approval of contract 2021-32 and budget appropriation. Item 11, contract 1920-139, a memorandum of understanding with the Trey Young Foundation Incorporated, establishing a mutual commitment to a long-term relationship and furtherance of indoor youth sport activities in Norman. Item 12, contract 2021-26, project agreement with the Oklahoma Department of Transportation in the amount of $574,279 for the Legacy Trail Multimodal Path Extension Project along 24th Avenue Northwest and 36th Avenue Northwest. Resolution 2021-17, budget appropriation from the capital fund balance and budget transfer between project accounts. Item 14, Resolution 2021-28, authorizing the acquisition of real property within the City of Norman for the purpose of the Porter Avenue and Acres intersection bond project, declaring the necessity for acquiring said property for roadway purposes, and authorizing initiation of eminent domain proceedings for the purpose. I need a motion to approve or reject the consent docket.
So moved.
Second.
I would like to read a statement from Ray Young regarding the memorandum of understanding with the Trey Young Foundation in item 11. Our family is extremely excited to partner with the city for the Norman Forward Multi-Sport and Aquatics Project, and this will be a world-class facility Norman youth deserve. We believe a project like this will change the landscape for all families in Norman. Having 3 kids compete in multiple sports in Norman, as well as 1 younger son, we know the potential sports have to improve the lives of Norman's youth. Our children, Trey, Caitlin, and Cameron, all grew up playing basketball and volleyball at the Norman Recreation Centers and the Cleveland County YMCA. These were truly great experiences as they were able to meet lifelong friends and establish great relationships in the community. But now we can offer our youngest son, Timothy, and other young boys and girls in Norman even better opportunities. We envision a facility that will change the way indoor youth sports are played in Norman and across the state. Instead of Norman families driving to basketball and volleyball events in communities hours away, as our families so often did with Trey, Caitlin, and Cameron, people will now travel to Norman, Oklahoma to play these indoor sports. Also, experience our hotels, restaurants, and shopping, among other things that make this city what it is. It's also very important to note that while this facility will be recognized nationally, our family feels that the continued growth of the City of Norman youth sports will remain a top priority in this facility. We understand that a majority of kids would rather play locally and focus on just the recreation side of sports instead of playing in national events. The Norman Forward Multi-Sport Complex will provide that opportunity as well for these kids. Part of our multi-million-dollar donation will create a scholarship program to ensure that no child will be excluded based on their family's income. That young athlete will be provided with all the equipment, jerseys, and everything necessary to ensure they have an equal opportunity to play sports. Another goal is to incentivize every kid that does well in school a chance to play in leagues for free based on grades and school attendance. Last but not least is the importance that all kids in Norman can have fun, make memories, and have the essential experiences everyone should have growing up. We can't believe it has already been 16 years since our family moved to Norman. Trey was only 6 years old and attended Jackson Elementary with his 2 sisters. Since that time, we have raised our family here, become a part of the community, and want to continue to invest in this great city. We are honored to have this opportunity to make Norman an even better place to live, play, and call home. Thank you, Norman. The Young family, Rayford, Candace, Trey, Caitlin, Cameron, and Timothy. I want to take a moment and say thank you right back for such a generous donation. I believe, it's my understanding, and staff, correct me if I'm wrong, this is the largest donation to the City of Norman in the history of our community, one that will be paid out over several years and will touch countless lives, as we all knew that youth sports can do. I'm very excited to be a part of this. And it's, again, a historic moment for our community. And I'm excited to see what it can do to help bring the vision of our Norman Forward project, specifically the 2 in question here, to what we had originally visioned. And again, not just that, but provide the opportunities through scholarships that I don't think we could have provided without such generosity. So with that, are there any comments from council regarding any item on the consent docket? Again, please raise your hand if you have any comment.
Councilmember Patrone has a question.
Okay, Councilmember Patrone.
Well, I actually think that was up from the prior meeting, but I do have a question on the consent, related to the consent docket, is whether or not we own the land yet for this particular project, or if we've identified it or anything.
As you all know, we do have a contract that sets forth some purchase terms for 12 acres of that property that was approved by council last November. We have developed a site plan based on the current design. Of course, that depends on whether or not the bond issue in August passed. The size of the project will vary. But we do have that legal description and that land identified, and we are talking with UTC representatives about the purchase price for additional acreage that would be needed. That was contemplated in the agreement, and I think we'll be able to come to an agreement fairly quickly.
So are you saying, so we don't have the land yet?
We have the contract that you all approved last November for the 12 acres that set forth the purchase price. That contract said that we would identify the site together. We've done that. And so we're going to finalize a purchase and sale agreement that I think will include an option for additional land should the bond issue in August pass and we need additional land to build the facility that bond issue will fund. And we anticipate bringing that forward to council in the next month or so.
Okay, will we see to be able to talk to our constituents about the bond, will we be able to show them the land that the city owns, like where it is, what parcel?
Yes, yes, I think we'll have the site plan in time for those discussions. We've identified the land, as I said, so I think that can be done.
Thank you.
And thank you for mentioning the GEO bond election coming up on August 25th. For everyone watching, I want to remind you to mark your calendars. And tonight's acceptance of this donation pretty much launches our Go Norman campaign to make sure we work hard together to educate the community and get a yes vote on August 25th. Councilmember Wilson, did I see your hand go up?
Yeah, question about the Trey Young donation. What happens to that money if this bond doesn't pass? Is there language in there that talks about that, or do we know?
Yes, it is contingent on the successful vote in August on the bond package.
Thank you.
Any other comments from council regarding any item on the consent agenda?
Councilmember Holman has a question.
Just really a statement. I just wanted to extend a thank you to the Young family for stepping up and contributing in this way. In a lot of communities I've noticed around the country, to do some type of projects like these and others, they often have to have some sort of local family or someone that grew up there that happens to be wealthy that steps forward and helps get it done, at least, if not funding the entire thing sometimes. So I'm just thankful that in Norman we do have a family that whose kids have grown up here and are willing to give back in this significant way. So I'm looking forward to that project and all the other ones that are involved with Norman Forward and trying to get them done the way that the public expects them. So thank you.
Well said, Councilmember. Are there any other comments from council regarding any item on the consent agenda?
I don't see any.
All right, seeing none, the motion on the floor is to approve the consent docket. Madam Clerk, will you please call the roll?
Councilmember
Aye.
Councilmember Perry,
Aye.
Councilmember Patron,
Aye.
Councilmember Hall,
Aye.
Councilmember Wilson,
Yes.
Councilmember Foreman,
Aye.
Councilmember Holman,
Yes.
Councilmember Peacock,
Yes.
Mayor Clark.
Very enthusiastic.
The consent docket is approved unanimously.
Thank you. We'll now move to off consent. Item 15, Resolution 1920-117, declaring final costs associated with the Ruby Grant Water Line Payback Project and authorizing the Utilities Director or his designee to release properties as assessments are paid. I'll entertain a motion to adopt or reject the resolution.
So moved.
Second.
Thank you. I'd like to recognize Nathan Madenwald, Capital Projects Engineer, to make a presentation.
Thank you, Madam Mayor and council members. So I'll pull up my presentation. Okay, can everyone see that? Okay. So this is just a brief presentation regarding our Ruby Grant Water Line Payback Project. So before we go into the details for this specific project, a little background on the payback process and ordinances. So Ordinance 9697-30 was adopted in February of 1997. Allows for a payback on capital costs. I'm sorry. Okay. Allows for a payback associated with water and sewer improvements. Developers for land benefiting are required to pay back those adjusted cost of improvements, and we get to charge back engineering, easements, and the construction costs. And for sewer projects, we calculate the proportionate share of payback based on estimated wastewater flow. For water improvements, we do that based on the street frontage. And I'll talk a little bit more about that in detail when we bring up the map. So To date, we've done 9 payback projects for water or sewer. I won't go through this list because you can see them on the screen there. So for the payback development process, the first step is we do an initial resolution to declare a project. And with that, we have estimated cost and properties that would be benefited by the proposed improvement. Project is approved as a payback project and then constructed. And then we do a future resolution, which is actually the item that we're doing here tonight, where we declare final cost and properties to be that were benefited and what their proportionate share of the costs are. Currently developed properties are not included to the payback. Since they've already been developed, we don't charge them. Properties that are undeveloped, they're charged a proportionate share and they're required to pay that back before they develop. And we track this using the city GIS system. So for the cost requirements, residential development, we require payback at the time of platting. For non-residential development, we do that at the time of permitting, such as earth change or building permit. We increase costs or inflate costs to current dollars based on industry standards, which is the engineering news record cost and cost of construction inflation. So we do that based on the bid date of the project, and then we increase it at the time of to what it is at the time of payment. And for projects that don't pay on the initial inception, we charge them an administrative fee of 2%. And then we release the properties by filing a lien at the county once paid. So for this specific project, for the Ruby Grant water line, what you can see on the map here is the dashed blue line is the water line that was constructed for this project. So that was a 12-inch water line constructed from 36th Avenue Northwest, east about 1,600 feet along the south side of Franklin Road. 3 properties are benefited by this project. Parcel 1 is the Ruby Grant Park. Parcel 2 is a piece of property owned by Raven Investments. And parcel 3 is a property owned by the Baskets. So as we discussed earlier, water line payback projects are calculated based on the frontage of the property abutting the water line. So the entire frontage abutting the water line is shown as 1,563 feet for the Ruby Grant parcel. So for parcel 2 is essentially the entire frontage of that property because it abuts the whole thing and abuts the water line. And then you can see for parcel 3, just a portion of that property is abutting the water line, which is shown there as 173 feet. So we utilize what's the total frontage there with the total cost for the project, and we come up with what's their proportionate share to be paid back. So as I said earlier, this is for the final resolution. The initial resolution was approved by council in December 2019, 1920-15. The project was approximately 50-50 split between Parks and Indian UA, just based on the frontage of the properties. Benefiting property owners have been notified of what their share for this project is. And that was calculated based on the frontages we just showed, and we'll show in the detail or show in the table to come. And so this resolution 1920-117 will finalize costs for this payback project. The total amount for the project for 1,570 feet of 12-inch water line is $97,541. Work was completed by H&H Plumbing and Utilities under general contractor of Crossland Construction. So the total frontage of the property is 3,126 feet. The uninflated payback amount, dividing that footage of frontage into the total cost, is $31.20 per foot. We'll inflate that at a rate of 3.67% annually from the time that the project was bid. And the project has a 20-year payback period, so it will expire in July 28th, 2040. So we showed the footages before on that map briefly. You can see them here in the table. So column 1 is showing the respective parcel. Column 2 is showing the frontage for each parcel. Column 3 is showing what's their final share for the project, and then in percentage, and then column 4 is showing it in dollars. One specific item to note with this is Parks paid for their proportion of the project through construction of the water line since they funded it, and then utilities funded a portion back to them. So parcels 2 and 3 will be the only parcels still remaining to pay back for this project, and that will be something collected over 20 years as those properties develop. I feel like I went through that really fast, but at this time I'd be happy to answer any questions that you may have.
I'm not seeing any.
All right. Thank you so much for that presentation. Any other council questions? Seeing none, this is an opportunity for members of the public to make comments regarding this item. Are there any public comments?
Not here.
Seeing none, the motion, are there any final comments from council regarding this item? Seeing none, the motion on the floor is to adopt the resolution. Madam Clerk, will you please call the roll?
Councilmember Bierman,
Aye.
Councilmember Perry,
Aye.
Councilmember Patron,
Aye.
Councilmember Hall,
Aye.
Councilmember Wilson,
Yes.
Councilmember Foreman,
Aye.
Councilmember Holman,
Yes.
Councilmember Peacock,
Yes.
Mayor Clark.
Yes,
The resolution's adopted unanimously.
thank you. Item 16, ordinance 1920-55, amending the planned unit development approved in ordinance 0203-2, amended by 0506-9, replaced by 0607-13, and amended by 1415-45, 1516-24, 1819-12, and 1819-37 to amend the setbacks and landscaping requirements to allow construction of an office complex for 2.7857 acres of property on the east side of 24th Avenue Northwest and north of Corporate Center Drive. I'll entertain a motion to adopt or reject the ordinance on second reading, section by section.
So moved.
Second.
I'd like to recognize Sean Rieger to make a presentation.
Okay. All right. Thank you, Madam Mayor. So this is, let me start the share screen if I may, please. And this is this item the hospital item, Mayor?
I was gonna say, Sean, I think this
Yeah.
was actually Terry Haynes.
Yeah, I believe this is Terry Haynes, Mayor. I apologize. Yes.
Oh no, that was a test and you passed. Well
Okay.
done. Terry
Had me
Haynes.
confused for a moment. Thank you.
Muted.
Okay, I am not, he is unmuted, but I can't find him. Are you there, Terry? I've got a message I can send him.
This is Sean Rieger, Madam Mayor. We have texted him just now and hopefully he will.
Okay. Because it shows him unmuted, so. Yeah, Terry? Well, Sean?
Yeah, this is Sean Rieger. I'm sorry, I don't have this item, so I would be limping through this one, but Terry is on the call, I know, and we're texting him right now. If we could, Madam Mayor, just wait a moment.
Yes, I was going to suggest, why doesn't he exit out and try and get back in?
I
Hopefully
think
that will
he's
work.
doing that, I think. But he didn't come up yet.
He just texted me and said, I'm on, but can't be heard. So I don't know.
Don't do that. Don't do that. Don't.
I didn't do anything.
You were going to end the meeting.
No, no, I wasn't.
Could it be Bluetooth earbuds are nearby that his computer is picking up, thinking that he should be talking into a mic that's connected to Bluetooth? If so, you just
If
shut
I
off the
can find
Bluetooth.
him on here.
Maybe you could text to let him know to shut the Bluetooth off on his computer.
Okay.
I've lost him. Yeah,
you
oh wait, here he is, here he is. Okay. Terry, are you there? Well, I haven't muted him, so. Oh, there he is muted. Okay, Terry. Terry? Oh. Going back to the top. There he is. It does. Terry, can you hear me? How do I do that? Oh.
I'm sorry, everybody. Can you hear me now?
Yes.
Oh, my goodness. Big apologies to everyone. Madam Mayor, Honorable Council, please accept my apology. It's the technology.
Uh-oh. He just went.
He's still there, but it says he's muted.
I've got to find him again. There he is. Okay, we got you. Come on.
All right, then. Well, let's see if I can share the screen.
I don't know. Willie, okay, cool.
All right. Good afternoon, everyone. I am so sorry to put a delay on this meeting this afternoon. My name is Terrence Haynes with SMC Consulting Engineers, 815 West Main, here on behalf of University North Park LLC. We're asking for an amendment to the University North Park PUD that's before you today. The project location is located on the north end of the University North Park off of 24th Avenue Northwest, which you can see along the west side of the project location. Tecumseh Road is just to the north, and I've pointed out a couple of other existing businesses around the Switzer's Locker Room, shops at Tecumseh, Max Westheimer Airport, of course, directly to the east. The site is really a continuation of the existing office complex that's located along 24th Avenue. This is an unusually shaped piece of ground, but is also a continuation of the office complex. Premier Pediatrics is located directly north. What we're asking for is to reduce the landscape buffer, the building setback requirements, which is very similar to what was allowed to the north, part of the office complex. And the reason for that really is to be able to develop this land to its full potential for offices, and to also to meet the emergency vehicle access and parking requirements. A similar PUD amendment was passed on July 28th of 2015 for the 5 lots that are directly north of the site. So to give you a visual of what we're requesting is a continuation of the 25-foot building setback line, which is highlighted in blue across the frontage, and then the 10-foot landscape setback, which is highlighted in green. The client, Mr. Ben Graves, who is developing the parcel, actually has a vision to add quite a bit of landscape and green space along its frontage. And you can see by the outline, the black outline of the parking lot, that there is quite a bit of area outside and beyond the landscape setback for trees, shrubs, and landscaping along the frontage of the property. It will be a Class A development. And that's it in a nutshell. I'm here to answer any questions you might have. And again, I apologize for the delay. Let's move on then.
All right. Are there any questions from council regarding this item?
Councilmember Holman has a question.
Thank you. So just to clarify, there is one driveway off of 24th coming into this, and then it connects to the existing office. Does it connect to the? Yeah, it looks like
sir.
it. Yeah.
Yes, sir. There is one driveway that's requested as part of the site plan. We're limited by the amount of driveways we can safely put in along 24th Avenue, but it is interconnected with the existing parking lot and of the pediatrics office and the other office buildings to the north.
And I assume that these buildings are probably going to look very similar to those buildings in aesthetic and height as well.
Yes, sir.
Okay. I do kind of remember the 2015 when we approved the projects to the north of there. So, okay, that's the only questions I have at the moment. Thank you.
Thank you.
Councilmember Peacock has a question.
All right.
Yeah, I don't see any on-site detention. Can you just speak briefly to the stormwater solutions you guys have proposed?
Yes, sir. The on-site, there is no on-site detention because that's been taken care of in previous developments around this site, including the detention area located right up here by the shops at Tecumseh and Tecumseh Crossing. This is all part of the detention requirements that were put in when the first office park was constructed. There's also a detention area located just on the airport property, just south of Tecumseh Road, right here. But the pediatrics and this location, they generally flow through a storm sewer conveyance pipe across this property and into the detention that's between the shops at Tecumseh and Tecumseh Crossing.
Thank you.
You're welcome.
Any other questions from council regarding this item?
Councilmember Patron.
Hi. Okay, so along the lines of Councilmember Holman's question about the building specs and it closely mirroring the Premier Pediatrics, is that built into this PUD?
It is. There are design standards that are built into the PUD for the University of North.
Okay, so what is, I understand you said an office complex, but can you tell us, like, is it medical offices or is it, what is this?
Part of it is an extension of the pediatrics. You can see on the north end that we've extended their parking as part to facilitate additional parking for the pediatrics. The rest of it is yet to be determined as to the end users by the developer of the property. But it will be in the line of those that occupy the buildings to the north as far as the occupancy.
So it won't be limited to medical, it could be anything?
Yes, there's a specific standards that are set in the PUD, allowable uses that are set in the existing PUD. We're not asking for any changes in those uses.
Okay, so this what you're pretty much asking council though, I mean, this could be anything. We're just talking about setbacks, and then the setbacks are going to stay with whatever this is. The PUD isn't, my understanding that the PUD language, it said, applicant asserts that this PUD amendment will allow the applicant to develop this irregular shaped parcel, but didn't say exactly what would be developed within it.
Right. We're not asking for a change of uses as allowed by the PUD. We were just asking for the continuation of the 25-foot setback, building setback, to allow us to develop it as you see on the screen. But more importantly, with the emergency access, where we have the cross access with the parking lots and the office complex to the north, being able to make that route around these buildings.
Okay, well, I guess my question is, what about the parcel that's even further to the south of this one? Is the developer going to come back and continue asking for these setbacks? Because my concern here is that if this is really supposed to be bikeable, walkable, all the things that we had envisioned for the UMP area, but we continue taking away that buffer zone, it becomes dangerous to live, work, play, bike, all of that.
Completely understand the question. That parcel to the south is owned by University of North Park LLC. As you can see, it's a much larger parcel, and which would be more in line with the other parcels that are developed along 24th Avenue, which has the greater setbacks requirements. So there are no plans as of this moment that I'm aware of for development of the parcel south of this one. But given that a little more land to work with as far as the frontages along 24th Avenue and Corporate Center Drive, as far as making it walkable, there is more room to work with down there. You'll also see on this drawing in front of you that we've extended the 10-foot wide pedestrian bike path meandering along the frontage that would match what is currently constructed on the Premier Pediatrics track. And eventually, and I believe that this portion right here is also already built, and we've extended that 10-foot wide sidewalk along its frontage as well.
Okay, that makes me feel better about that. And then my other question was for city legal. I was reading in the I think it was before the planning commission. Anyway, it was talking about this getting permission from the airport because this property abuts the airport area, and the city has land that as well. So I wondered if you could speak to the process of what the UMP will be doing to get the permission to develop their land next to the airport, and so that we will have direction on what we need to do with ours, because we have land in the UMP as well, and it also abuts the airport area there.
Sure, and the way the airport is situated, there are different zones that dictate what you can do in terms of height adjacent to the airport. Embassy Suites had to go through this. That's the tallest building out there. And we anticipate going through that with our multi-sport and aquatic center and not anticipating any issues there. But it is a process through the FAA and the local airport that applicants have to go through to get their approval to sign off on. Separate and apart from our process, but we do try to coordinate with the airport in these zones adjacent to the airport to ensure that applicants know they have to meet the FAA requirements as well as our requirements.
Okay, just as a follow-up, are we doing anything to see about what we need to do on the city side for our land there so that we can make some decisions about it as well?
Yes, we have had meetings with the airport director in addition to some state personnel just about issues in general in this zone. And so we know exactly the process we have to go through. Even the entrance walls into UMP had to go through this process. So it's a process we're familiar with. And it's one we anticipate being able to get through without any issues.
Thank you.
Are there any other questions from council regarding this item?
Councilmember Hall has a question.
Okay.
Actually, that was really part of my question because I wanted to know a little bit more clarification on the additional approval process with that airport overlay district. So did the pediatrics project just to the north, is that also in the airport overlay district, or do we know that? I mean, did they have to go through that process as well?
I believe they would have probably had to get airport approval on that or FAA approval. This part of UNP is not in a runway protection zone, but it is adjacent to a runway protection zone, I believe. And so typically that does have to still go through the process. It's just a bit of an easier process when you're not in the protection zone.
Okay. And then I just want to make sure I understood what you said, Ms. Walker. So no matter what our action is tonight, there's still additional approval processes that have to be, they have to go through additional processes to get the project approved.
Right. Anytime the FAA needs to approve something, that'll happen separate of our process, but it will be required.
And what kind of timeline is that?
I don't know if Terry has more recent experience with that. I'm not really sure. We haven't had to do that in quite a while, so I'm not sure how much time our last application took.
It could take a couple of months to get the application run through the proper channels.
Okay.
Usually they're very quick as far as the response on the initial application, which is done online. But it does need to go through a thorough review by the aeronautics engineers and the airport authority.
Okay, thank you.
Councilmember Bierman has a question.
Yes, I do. Catherine, this one will probably be for you, maybe for Jane, but probably for you. What was the purpose of the original building and landscaping setbacks?
I don't know what the purpose was. I know throughout the whole district, you know, on the east side of 24th, Legacy Trail was to be extended and to create that buffer, but we did end up with some funky lots, and I believe council has once before granted a similar change in setbacks for another project to accommodate the odd shape of the lot that was resulting because of the curve of 24th Avenue.
Okay, because you know, it does concern me a little bit that, you know, this is something that I always have had concerns about. Every action we take will come back and be used for a future action. And so a council action in 2015 is now opening the door to reducing this setback now. And, you know, approving one project or one PUD amendment is not a blanket waiver for any future ones. And so it does, I'm glad to see that the trail / walking path / biking path is still going to be there, but it does really concern me that these setbacks were included for a reason. And now, because of one amendment by a previous council back in 2015, now we're being faced with another, and who knows if we're going to end up with any more. So it would be really nice to have some additional feedback about what those setbacks are, and what they were for. But you know, outside of having some additional information on that, I'm not really sure what we can do except kind of go with our gut on it, because it just doesn't seem to me, when looking at the actual schematic of the plan, that this really impacts much of the development, except for it looks like maybe one corner of that far western building. It looks like a separate little building, and maybe a tiny corner of a parking lot. So, you know, I really would like to ensure that when we make amendments to a PUD like this, that we're doing it for a very substantive and significant reason. And I'm just not sure that this one is it. So that's all I've got on that one for now.
Thank you, Councilmember. Any other questions from council regarding this item? Councilmember Patron.
Just really quickly, is the land that we would be putting the multi-sport aquatic center anywhere near this particular site?
This is north of Rock Creek Road, quite a ways north of the NEDC property, north of the apartments. The site for the multi-sport aquatic center and indoor, multi-sport center and indoor aquatics, is south of Rock Creek, between Embassy Suites and Rock Creek, between Rock Creek and Embassy Suites. So that lot is quite large and would not face the same challenge.
Okay, but I guess I wasn't clear, but we're not gonna have little kids walking around in this area potentially.
I wouldn't think so.
As a
They would
matter
be going this far north.
yeah. Wall and all of that. Okay, thank you.
Any other questions from council?
Councilmember Holman has a question.
Yeah, I forgot to bring up the legacy trail part, so I appreciate that being brought up. It is, I wish it wasn't being done parcel by parcel like this. I wish we would have been able to do the whole trail through there. And the street was built a long time ago, but in 2015, I do remember the discussion about the odd shape of these specific properties on this curve. And really, one of my biggest criticisms of the UMP area is the setbacks. I really have always disliked how far back the buildings are required to be and how big the parking lots are between the street and buildings. And so, I mean, I would be definitely open for a discussion about that area in general and reducing setbacks overall to try to bring the buildings closer to the street and have more of the parking behind. Just as an overall discussion about making that area more walkable potentially. So I do appreciate that being brought up. The one thing I did forget to mention though, that as I was looking at the aerial picture of the property, was the oil well site that was there or is still there, and what is being done about it. If it's being completely removed, and because the service road for it would run right through the middle of this property as well. So if you could just address that.
Yes, sir. This is Terry Haynes again. The oil well site has been removed completely, and all the paperwork has been filed with the Oklahoma Corporation Commission. So it is now closed.
And so all equipment, everything is gone. There's really no trace of it anymore.
That is correct.
Okay, wonderful. Thank you.
Are there any other questions from council?
I don't see any, Mayor.
All right, with no further questions from council, this is an opportunity for members of the public to make comments regarding this item. Are there any public comments?
Yes, we do have a public comment, Mayor. Brandy Studley, Ward 1, says, why are we adding more buildings to the north when several of the buildings to the south of that area by Legacy Park are still vacant? That's our only public comment.
Okay, thank you. If there are no other public comments, are there any final comments from council regarding this item?
I don't see any, Mayor.
I jumped in kind of late. Sorry, Ellen. I tried to hit my button, then raise my hand, then raise my hand again. So I don't know Mr. Haynes very well. I can't see his face, so I don't know if I've ever met him in person. But I am one who continues to hammer home the importance of not continuing to add to our impervious surface area when we don't have a stormwater solution. And so all these other points aside, you're not going to get a yes vote from me tonight, because I just can't continue to add to this problem for office space that we do still have a significant amount of in this community. So I appreciate the feedback about the reason why this needed to be built a certain way, but I just wanted to point out that my reason for not voting for this particular project is because we still have a stormwater issue that we have not solved, and we're continuing to make the problem worse.
Thank you, Councilmember. Any other final comments from council regarding this item? All right.
Councilmember Holman's got a question.
I was just gonna mention that to the comment from the public, south of Rock Creek Road is all commercial retail space, and what is being proposed here is an office building. So there'll be no general retail or restaurants or anything inside of this. So that's just to clarify why this would not be going in on the south side, even though there's empty space down there. Thank you.
Any other final comments from council?
I think that's it.
Thank you. The motion on the floor is to adopt the ordinance on second reading. Madam Clerk, will you please call the roll?
Councilmember Bierman,
No.
Council,
Can't hear a thing.
I'm sorry, Councilmember Perry,
Aye.
Councilmember Patron,
Aye.
Councilmember Hall,
Aye.
Councilmember Wilson,
Yes.
Councilmember Foreman,
Aye.
Councilmember Holman,
Yes.
Councilmember Peacock,
Yes.
Mayor Clark.
Yes.
It's adopted on final second reading unanimously.
Thank you. I will now entertain a motion to adopt or reject the ordinance on final reading.
So moved.
Second.
The motion on the floor is to adopt the ordinance on final reading. Madam Clerk, will you please call the roll?
Councilmember Bierman,
No.
Councilmember Perry,
Aye.
Councilmember Patron,
Aye.
Councilmember Hall,
Aye.
Councilmember Wilson,
Yes.
Councilmember Foreman,
Aye.
Councilmember Holman,
Yes.
Councilmember Peacock,
Yes.
Mayor Clark.
Yes.
The ordinance is adopted unanimously on final reading.
Thank you. We'll now move on to item 17, Resolution 1920-114, amending the Norman 2025 Land Use and Transportation Plan for property located at the southwest corner of Highway 9 and 24th Avenue Southeast from office designation to mixed use designation. I'll entertain a motion to adopt or reject the land use plan amendment.
So
So
moved.
moved. Second.
Thank you. Now, Mr. Rieger, since you did such a good job of paying attention earlier, I do believe it is your time to present.
Okay, very good. Thank you, Mayor. This is the hospital project, correct? We're on that agenda item, so, okay, very good. So thank you very much, Councilmember Sean Rieger, for the applicant in this case. And it is not very often that I get the opportunity to present to you a project that I think is a generational move for the city of Norman. And this is one of those items that we're very proud tonight to present to you because of what it means for the area, particularly of Southeast Norman, but really for the entire community. This is the first step in the Inspire Health project that you've heard a lot about. And so we have a large team with us tonight, Mr. Richie Split, the CEO and president of Norman Regional Health System, Mr. John Manfredo, the CFO of the Norman Regional Health System, Paula Price, and we have a large team and consultants. You just heard from Terry Haynes a short time ago, and we have Todd Butler with TEC, multiple people here tonight to talk you through this item and answer your questions. And so let me start sharing a screen right here. There we go, hold on here. All right, there we go. Okay, very good. So first and foremost, I want to introduce Mr. Richie Split. You of course know Richie and what he's done for our community. I want him to talk first to you about what he envisions here, some history, and sort of how we came about to settle upon this site. So Mr. Split, if you will.
Thank you, Sean. And thank you, Council, Madam Mayor. Thank you for your time tonight. It's really good to be with you all tonight. As indicated last November, we're here tonight seeking the council's approval to rezone a parcel of land located in Southeast Norman. It is a vacant parcel of land that we use to develop the very first project of our Inspire Health plan. And that project is the Freestanding Emergency Department Plus. As many of you know, Norman Regional has invested many, many hours and months of envisioning a plan that extends convenient, high quality care, healthcare to all residents of Norman. Tonight, I want to share with you the unique collection of qualities and characteristics that will provide meaning to this development site. And it starts with a profound military history for Norman, Oklahoma. Once we selected this site, we immediately began contemplating themes for the overall development, themes that would create a sense of meaningful contextual cultural context, a sense of connectedness, a sense of place. And the images you're seeing on the screen right now reflect the theme that we settled upon. It's a naval theme, and it's a theme that honors the history of our great community and the contributions made during World War II and the Korean War. You may recall that in 1942, the United States Navy established 2 Navy bases in the southern prairie town of Norman, Oklahoma. There was a north base and a south base. The previous project was on the what was the north base property, and the property we're discussing tonight is actually near what was the south base. The south base was actually located about 1.5 miles west of the particular site that we're discussing tonight. As you see in the images here, the Navy was on the beach in Norman, Oklahoma from 1942 through 1959. In fact, that red dashed line that you see here in the middle of the slide indicates the exact location of a 400-bed naval hospital built in the early 1940s. On the next slide, you will see images of the actual hospital itself. Sean, if you'll advance that, there we go. In our mind, this theme offers great connection between our community's historic past and the future of our community's health system. With this development in Southeast Norman, it's our goal to protect, or it's our goal to honor the selfless service of the brave men and women who fought to protect the sanctity of liberty and freedom in the United States and beyond. And the development theme of our new freestanding emergency department on this site is our attempt to pay tribute to our historic past while accommodating the health and wellness needs of our growing community. So Norman Regional is eager to present this plan to you tonight and launch the very first project of the bold and transformational plan that we call Inspire Health.
All right, thank you, Richie, very much. And you know, I was sitting here thinking nobody on the team could have foreseen when we started down this path that we would be doing this by Zoom tonight because of a health crisis. And so it, I think, is a little bit symbolic almost that we're here on this item tonight through Zoom because we're in the middle of a pandemic. And I would just simply applaud the Norman Regional Health System for carrying us through this issue at this time. And this will help us tremendously in then attacking the next phase of it. So let's take you through the item so we can go through it and explain everything to you that will be in front of you tonight. This is the site that Richie talked about, the site right here at the corner of Highway 9. You see across the screen, across the top, and 24th Avenue Southeast. Just to give you some context here, it is a field at this time. Hitachi is across the street. Hitachi does own all of this land across the street, so that is all owned by Hitachi. To the west of us is the Perfect Swing, old Perfect Swing development. You see Classen Boulevard right over here. You see Cedar Lane down here, and then Highway 9 again over here with the Postal Training Center and the Saxon area right over here. Pebblebrook neighborhood here and St. James neighborhood here. On this slide, I just simply want to make sure you notice that St. James neighborhood does not connect to the south, and that has been a discussion point in this project as to issues concerning access into this neighborhood. It is a section line artery and a section line area, but Walmart is to the south here and Cedar Lane across the bottom. There is no connecting point here. So that became a point of discussion as to traffic up in this area, and we'll talk a little bit more about that as we go. Why Southeast Norman? I thought this might help everybody to kind of see what is happening in Southeast Norman. And I know the council members and staff know this, but maybe just a little bit more perspective about it. What you're seeing on the screen is 2025 map, but what you're seeing is items of developments that have been approved in this area. And these are just developments, frankly, out of our office. There may be other developments that we're not aware of, but you see some significant large developments. Now, these are not numbers of dwellings on the ground, but these are potential as approved through already approved items of zoning in this area. And if you add up all these neighborhoods, Summit Valley right here, Bellatona right here, Cedar Lane down here, and Destin Landing here, once these all get going, and 3 of them are already going, The total potential in this area is approaching 13,000 new people at census rates of 2.39 per dwelling. And so we have a really significant influx of population in this area. And so you see right in the middle of the screen, right there is this proposed site, right in the middle of all of the significant population growth in this area of Norman. We're going to zoom in a little closer now. You see the site again, Highway 9 right here, the Classen interchange over here, Pebblebrook right here, Norman Business Park, Postal Training, Hitachi, and St. James down to the south. And just one more zoom in, we see it now. Now we see Ann Brandon coming across the center here. That is an existing road. And actually what we discovered in this project is that that existing road was never platted, actually. So we are maintaining it as it was. It's been cared for as a public street all this time. And so the continuation of that street as it exists is what's proposed here tonight. We'll talk a little bit more about traffic in just a moment, but I would just say that one of the discussion points on this project has been that the neighbors wanted a connection point elsewhere on Highway 9 besides right here at 24th. That's been discussed quite a lot with a lot of folks, including ODOT, and I would just tell you, we were told categorically that will not happen. That was the answer from ODOT. If anybody has a different sway from ODOT, we'd love to hear it, but we had no doubt from ODOT that they would not approve a different connection point. So Highway 9 and 24th, this is the access area right up here. Existing Crosspoint Church right here. Again, perfect swing area right here. This property is being sold. The seller is a church, Trinity Baptist, I believe is the name of the church. And that's important because I'm going to show you in just a moment some deed restrictions that they have put upon us that will carry forward in perpetuity. So the zoning and the 2025 designation that we talk about so often through these meetings, the existing zoning right now is all office, O1 institutional. O1 institutional basically allows for any kind of office, medical, professional, virtually any kind of office. It does allow a special use for a hospital as well through a special use mechanism if you were to move for that. What we're proposing tonight is a plan unit development, which we do so often to try to give a little bit more controls over specifics of many facets of the project. And so the proposal is a plan unit development. I would note that to the west of this site is commercial. That's the perfect swing development right there. 2025, which is the adopted community master plan, shows this project as the site as office. We're asking that to change to mixed use. Part of it would go down to residential, part of it would go to commercial, and part of it would be medical, which is really kind of a blend of the three different intensities. I would notice though, to the west, currently 2025 does show a plan for this to be all entirely commercial right up to the neighborhood behind it. So 2025 anticipates this area being a fairly intense area of development going forward. So let's look at the site plan. This is the proposed site plan, and I'm going to show you in just a moment, there are some changes to this site plan from Planning Commission that is in response to points of discussion that we've heard about. But this is the proposed site plan in the PUD, and I would note again that in PUD, site plans control. Site plans become an integrated part of the PUD. That's another control you have in PUDs, that the site plan can't be substantially changed without a site plan amendment that goes all the way back through the process. So this is the proposed site plan. The most important element, of course, is the freestanding emergency department plus, we call it, because it really is much more than just a freestanding emergency department. And we'll show you that in just a moment. But that is the main feature. The main feature is right there, the Norman Regional Hospital freestanding emergency department facility, parking around it. The main access would come off of Highway 9 onto Ann Brandon, ambulances up in this area as far away from the neighborhood as we can bring them. That's very intentional to make sure they're right up off the north side of this building, parking around it. And then behind the freestanding emergency department, you see some detention areas here and here. You see two out parcels that are planned as commercial. And then you see really what is basically a reflective and sort of a passive amenity area of open space and trails and green space, some plaza space, a number of areas there that people can come and enjoy some time, perhaps while their relatives are inside the freestanding emergency department, perhaps having tests, having some imagery done, whatever it may be, but they can come out and enjoy maybe some other services in these other nodes, and then enjoy it in a plaza area down here. So we're very proud of that plan and how it's come together. So the freestanding emergency department here, we show a new road right here, which would be a continuation of Overbrook. So Overbrook comes through the site, and that becomes really sort of the separation zone between the freestanding emergency department and then the additional uses around it. Again, out parcels of commercial. And then on the side over here, you see two gray buildings. Those are anticipated to be perhaps commercial, but I'm going to show you in just a moment that those could be medical as well. So those are our buildings here with, again, parking lots shown with them. The site plan is developed very much to scale of the parking lots relative to the size of the buildings. So if this was to change significantly, it would have to go back through council for a significant site plan adjustment. This is a residential facility shown on the lower right to be basically the buffer between the R1 residential and the residential that would buffer between the commercial and the freestanding over to the neighborhood here. Behind is a service drive, and I'm going to show you in just a minute some changes that have occurred with that so that we can protect neighbors behind it from this becoming a speedway or anything of that nature. Right here is the border. And let me go ahead and cut to the chase to some changes that have occurred since we were at Planning Commission. Planning Commission passed this unanimously, 9-0. We'll talk about that vote in just a moment. But at 9-0, the Planning Commission passed it with this configuration that you see on the left. Since then, we've made a number of changes, and the changes you see on the right. Probably most significantly is we took out a large area of plaza space. This was originally planned as a large impervious plaza space. We heard a number of folks talking about, let's make that a little more of a green space and a passive space. The designers went to work and they came back with this, which was really, you can see a significant change of open space and green space and in the area of the neighborhood to the south. So we hope that that helps significantly. It obviously helps with stormwater as well, and that we have much less impervious area here. This area down here, I should say, drains into detention areas at the bottom that then become a notable buffer across the bottom of the site. And in fact, this buffer is about 50 feet wide at the narrowest end down here and significantly wider down here. And I know you're used to me talking about buffers and edges. It is rare for me to show you one that is 50 feet wide at the narrowest point here. And then I'm going to show you a little more distance in just a moment. Some other changes that occurred was that wall right there. And so we talked to some council members and we heard from the neighbors. The request was a masonry wall. Previously at Planning Commission, that was proposed as a fence and a fence with a berm behind it. There was concerns that that just wasn't permanent enough, that people could just simply walk right over the berm and the fence wasn't permanent enough. So in response, to put a clear sound barrier and a permanent wall, this is now going to be a 6-foot precast masonry wall, much like we talked about on the Noun Hotel, all across that south border. And this will be built with phase 1 right out of the chute. So regardless of what happens when in these areas, when the freestanding emergency center gets built, that wall gets built with it so that we have a sound barrier and an impenetrable barrier at that location. So significant reduction in the impervious area, the wall, and then we had traffic calming. I'm going to show you more detail about that now or shortly, but traffic calming devices here and up here, and very intentional to make sure this does not become a speedway behind the development. And finally, additional walking trails. You see all of these walking trails around the site. These are very much intentional to give us some walking paths for employees or visitors so they can enjoy the site and enjoy the experience as they're there. So what's the anticipated timeline? We've had questions about this. What is the anticipated timeline of this development? If it's approved this evening, this will be the first project to be constructed as part of the Inspire Health Vision. And that's really incredible. It would be exciting to get this project going, and this would be the first one. And so the anticipated preliminary timeline of this is City Council approval tonight with your goodwill, hopefully tonight. And then the anticipated unveiling groundbreaking would be the third quarter of 2021. Of course, it takes some time to do these drawings and get them produced and completed. And so that would be third quarter of 2021. The anticipated grand opening, which we will all look forward to, is the fourth quarter of 2022. So just a little bit over a couple of years away. once we get this going, if we have approval tonight, then that would go as fast as possible forward. It's important to note for us tonight, and that we understand that Inspire Health is a large project. It is a multifaceted project. It involves basically 3 different sites: Northwest Norman, Porter, and this campus down here. This campus, this FSED, is a prerequisite for the transformation of the Porter Health Village. We need this site going and blowing before we can really transform the Porter site. So it's important that we get this approved and move forward so that then we can continue on the next parts of Inspire Health. Talking about the phasing, a little more detail on that. The phase 1 is that right there, the FSED right in the middle of the site. That is right out of the chute. And phase 1 is that wall, the precast wall across the bottom of the site. So this is planned to be the first project of Inspire Health Plan right out of the chute. And then the remainder of the project, phase 2, which is the out parcels and these uses down here, would come as the market absorbs those going forward. And we would anticipate that it's probably likely or possible that once a hospital of this type gets built, we would hope certainly that there's some appeal and perhaps for medical or more uses. And most certainly the hospital wants them to be collaborative and companion to the hospital as much as possible. I want to show you a little more detail about this buffer. And it's always reflective, I think, to look at us and see what we could do right now, because I always want to make sure we understand the context. A lot of times we look at fields like this and we think, well, we're comparing to a field. We're not. We're comparing to the current zoning. The current zoning is office institutional. Right now, this site, would allow for a 27-foot tall building 20 feet away from the property line. So you could have that large of a building only about 60 feet away from the nearest houses. What is planned as part of the site plan that goes forward with this PUD is, again, a 6-foot precast masonry wall. And right now the site plan is showing 157 feet from the wall to the nearest structure. Again, a 50-foot setback up here, then the service drive, and then more space before you get to any vertical buildings. Really significant. This is the traffic calming solutions we see. I'm sorry this plan is not colored, but you kind of see it in the same context. We have the residential facility down here, the commercial facilities across here, and the service drive across the back is that element right there. Where you see the red dots, that will be speed tables per the City of Norman standards. So right at the entry down here and right at the entry up here, we would have speed tables to slow any traffic. We all know how we don't like to drive over speed tables and speed bumps. Hopefully this certainly will deter people from making this a thoroughfare as they cross it. It will have to also have signage, speed humps, private drives, service vehicles only. This will have all of those controls put across those 2 areas of the site to make sure we control it as much as possible. Todd Butler, I should say, traffic engineer, is on the call with us tonight and has done a pretty extensive analysis of this project and is available to answer our questions as well. So it's a mixed use development. And when you talk about mixed use development, we oftentimes think about mixed use development in terms of vertical construction. If you look at 2025 actually talks about mixed use development also being a horizontal development. And that's what this one is. This is a mixed use development in the horizontal sense, as that it mixes use across a site, a 30-acre site, and has multiple aspects to it. Of course, the most important node is that freestanding emergency department plus, as we call it. And it's really a plus because this is not just an emergency room. This is a significant medical facility for Southeast Norman and really beyond Southeast Norman. I think most certainly this is anticipated to draw from Noble and rural areas of Cleveland County that will all come to this facility as it's located in Southeast Norman. But this will also include services well beyond the FECD. It will be outpatient imaging, MRIs, CTs, ultrasound, bone density, mammograms. It will be an outpatient lab, blood work, and again, perhaps most relevant to our situation tonight, COVID-19 and similar testing like that. This will be family medicine and special care medicine. This will be outpatient rehabilitation services. This will be pediatric speech pathology and conference room space, opportunity for additional medical uses and professional offices around it. I can tell you, ladies and gentlemen, as a Normanite, and I grew up here, I don't think Southeast Norman has ever had anything like this proposed for this area of Norman. It is a remarkable development and a generational development for Southeast Norman. The commercial uses. So the commercial uses would be in this area and 2 out parcels. Of course, these commercial uses also would have some medical uses within them. And we'll talk about that tonight as a friendly amendment that I think will be coming. But the commercial uses, it's important to note that these come with significant deed restrictions that will forever go forward in perpetuity on the deed that we would have no ability to change. The deed has significant restrictions. This is being sold by a church in all candor, and the church was very clear to us that it was going to be deed restriction for all of these uses, including bars, liquor stores, breweries, a number of things that are noxious uses that most people would find that way. This will be deed restricted along all of those lines. The residential facility, it was important to put a buffer between this facility and the neighborhood, and in zoning and land use, oftentimes that becomes residential multifamily. It becomes an important element to become a good buffer between these types of uses in the neighborhood. That's what this one is intended to be. It is intended to be a compatible residential component. There is no desire, plans, inkling to make this any form of student housing project, and we're have talked about how to limit that. But also I would note that it cannot exceed the intensity as shown on the site plan. Again, this is site plan specific. So if this was to change in any significant way, including parking areas, and there is no structured parking shown on this site, then that would change the site plan and that would take an amendment. So let's talk about just the proposed wellness, a couple more slides. Just wellness again, we talked about significant trails throughout this area and significant open space has been left. As we know, we want the visitors to the hospital to have an area outside to reflect and enjoy the passive nature of what can be around it. We have reflection ponds, the naval theme anchor right here, reflection ponds up here, so we have a really enjoyable space with water. And then we have, again, the open space and the peaceful areas and sitting areas all around this area. So with that, let me just close by saying this was unanimous approval at the City of Norman Planning Commission. And we really were impressed with Commissioner Knott's statement that I think caught us all with our attention to it. He said, "I lived on Highway 9 and I was a first responder to several near fatal accidents at 72nd and Highway 9. The idea of being able to bring this health facility closer to those in that eastern area, to me, is an overriding factor. I understand some of the other comments, but the greater good, I think, is to approve this project." And with that statement, the unanimous approval of the Planning Commission came, and even with the prior plan, not with this significantly improved plan. And so FSAD Plus will be the first project of Inspire Health in response to City Council requests to provide convenient, high-quality healthcare to Southeast Norman and East Norman first. They will be the first ones to get the benefits of Inspire Health. We need it approved tonight to get going down that path, but with it approved, this will be the first one out of the ground, the first one planned, the first one opened. The project will serve as a catalyst for Inspire Health and will allow the transformation of the Porter Health Village to commence next. With that, Madam Mayor, I'm happy to answer any questions. We have the full team with us tonight, and we're happy to answer any questions that you have. Thank you very much.
All right, thank you for that presentation, Mr. Rieger. Are there any questions from council regarding this item? And Ms. Esri, I'm going to let you just call away. I think you are muted.
Councilmember Bierman is first. Did they get that? Okay.
Thank you for the presentation. Thank you for chatting with me several times over the last week or so, and particularly kind of all of the follow-ups today. Excuse me. As you heard me talk about in the last item, stormwater, massive concern for me. And I have heard you've done some pretty excellent things in terms of the stormwater plan for this particular site. So if you could talk about those a little bit, because as you mentioned, public health and safety trumps everything, including the lack of a stormwater utility fee. So really interested to hear what you have in terms of stormwater here, because from what I recall, it's pretty substantial.
Okay, thank you so much. And I do not want to steal any thunder or credit from Terry Haynes, who you just heard from a moment ago. Now you see him on the screen. I'm glad to see Terry up there. Terry is the civil engineer with SMC Engineers. He has designed the stormwater system, and I would ask him to answer that question. Terry, I can share the screen if that would help you. Let me know.
If you would, please, show the graphic, the overall graphic, please.
Okay, let
Well,
me
it's
go.
a pleasure to get the technology fixed on my end and be able to join you. Let's go up to the very top, the overall.
Okay, yes. Let me get us there. Right there?
That'll work. That'll be just fine. There are, as part of the initial phase 1 freestanding emergency department area, we have 2 primary above ground stormwater detention ponds, which are being highlighted now by Sean, one there and one to the west there. Those will be sized to maintain stormwater detention from the runoff from the phase 1 area, as well as that out parcel located at the intersection of Highway 9 and 24th Avenue Southeast. The stormwater, I should explain that this property naturally slopes from the northeast corner back towards the west southwest and onto the Perfect Swing property. It's all currently overland flow. As we all are aware, we have a high clay content, and so once the soils are saturated, the water is just runs across the surface and then eventually catches up to some stormwater drainage channels that are located behind the apartments to the west that are off of Classen Boulevard. As the development occurs, the 2 detention areas that are highlighted will then convey through the area where the anchor is shown, this common area right in here. And we have a series of above ground detention as well as underground detention planned for this area. Underground detention would be a series of pipes, perforated pipes, which allow for the water to collect, percolate into those same soils we talked about, and then discharge on further to the south to the last detention area, which is located just north of there it is, thank you, Sean, and then discharge back to its natural drainage onto the property to the west, and then further to the drainage system by the apartments to the west. And so we're capturing the developed runoff in these detention ponds, both dry as well as underground detention, and conveying them basically through their natural drainage patterns and then across. There was some question about whether or not any of this drainage would enter onto the residential properties, and as it is designed today with the residential properties, with the natural slope of the land, everything basically surface drains back to the west. None of this water that is coming from this development will be allowed to go over to the residential property, and one of the primary reasons why the last detention pond was designed on the south end.
I really appreciate that. Thank you. And so, I never know exactly how council wants to do these things, but this is just the first of several items that we have on this. And so I do have some questions about the PUD itself, but I think I'm going to save those for agenda item 18 when we actually discuss the PUD. I know sometimes these things kind of all get wrapped up together, but I think I'm going to save the rest of my questions for then. Thank you. Appreciate it.
Thank you.
Councilmember Wilson.
Thank you, Ellen. Sean, on the south where the masonry wall will be, will that be built at the time of phase 1, or will you wait till phase 2 to build that? And the same question for your phase 2 drive that is on the south edge, that pass-through drive, will that be built with phase 1 or as part of phase 2?
Yes, thank you, Councilmember. So phase 1, this wall, the border wall, which is the 6-foot precast masonry wall, that will be built with phase 1. So when this freestanding emergency center gets built as phase 1, that wall gets built with it. The service drive, no, would come with phase 2. When these buildings are built, the service drive would come with that.
Okay, so I have a follow-up question. That middle drive that it gets you to the, I guess, yeah, that.
Yeah.
Will that also have traffic calming? I guess that's a traffic circle in the middle. Is that what that is?
It's just kind of a paved area. It's not really a traffic circle. It would go through it. Sort of like downtown or Lindsay Street has pavers or decorative elements within
I
the
gotcha.
drive area.
But is there traffic calming in that as well?
No, there's not in that.
Can we, I mean, why not?
The concerns we heard all along were really back here. We heard neighbors that basically didn't want this to be a raceway and a thoroughfare. This is up within the development itself and really wouldn't necessitate the need for traffic calming. That would be my first answer. Todd Butler, the traffic engineer, is on the call with us tonight. So I always hesitate to talk in front of engineers who know this area, particularly mine. Todd, do you want to address that point as well?
I can do that. My name's Todd Butler. I'm with Traffic Engineering Consultants in Oklahoma City. We did not feel that any traffic calming devices were necessary on that Overbrook Drive extension, primarily due to the amount of traffic and amount of driveways that would be located on that. Typically, I think everyone would be driving fairly slow through the curves. There's more curves through that street connection. And we don't feel that those particular devices would be necessary. The service drive, on the other hand, it's got straighter segments. It had less traffic on it other than service vehicles. And so we thought it would be more necessary there than on that Overbrook Drive extension.
Okay, thank you. That makes sense. Looks like there's probably like 1, 2, 3 driveways. And okay, there's probably some natural calming there. Okay, that's all I had, I guess.
Thank you, Councilmember.
Councilmember Holman.
Thank you. I do have some questions about the PUD itself that I'll save for the next item, but on this one with the land use and transportation plan, so in regard to Councilmember Wilson's question about Overbrook and that little plaza intersection with the pavers, did you say that was going to be like a brick paver type situation?
I say that just as the decorative element you see on the screen, Councilmember. We are not to that level of design detail, though. I want to caution that. So
okay. Well, I would maybe encourage that little red piece or the colored concrete piece that's stamped or whatever might be done in a similar fashion to what's on Jenkins by the football stadium as a traffic calming. I agree. You don't want to too much encourage traffic down that other road, but right there where we think a lot of people are probably going to cross the street and go into the anchor, walking area, it might be nice to have just the brick paver that will slow people down without there being a physical speed bump or, something like that. So that would be my recommendation on that part. And then on the private drive, you have 2 speed tables, one at kind of both entrances there. I was wondering about the consideration for a third one, kind of in between there.
Okay, we have these 2, and Todd, do you want to talk about the necessary need of anything else besides?
Yeah, we felt that the service vehicles would be slowed down significantly with the use of those 2 speed humps, the trucks or service vehicles entering the 2 drives near the residential and that commercial would more than likely come down 24th and turn in. And then the others would be expected to more than likely use Ann Brandon to turn in. So all the vehicles would be slowed within that area, and then the curve helps as well. So we just didn't feel that those would be necessary in that area.
So my concern, I guess, would be between the 2 speed tables.
Mm-hmm.
I get that it's a curve and that would naturally slow most people down, but I guess my concern maybe would be that, you know, depending on what happens in the future with Ann Brandon Boulevard and 24th and Overbrook, and if there's a lot of traffic, if it's hard to get through, I could definitely envision people that live in the neighborhoods down there trying to use this private drive. I could envision teenagers that just got their license maybe, and they want to, you know, between those two speed tables, they might see how fast they can go around that curve. I mean, stuff like that is stuff I could definitely imagine happening. I could have imagined myself doing it when I was 16. So that's why I just kind of thought if there was a 3rd table in between, that might prevent that long stretch. But I don't know if maybe you address that.
Go ahead.
Well, go ahead, Sean.
Well, I was just going to say, I think you might get into more of that, Councilmember Holman, when we do get into the phase 2 and we actually see what's built there, and maybe they determine at that point whether they need that or not. I think maybe that's a use issue when they get into those matters, and also, you know, this is envisioned to be possible dock areas up here. You see it with this use, but I don't know. I think that's maybe a more of use. We certainly will take it into consideration as we go forward and consider it at that time.
And then, if this would be the right time to talk about the Ann Brandon Boulevard and 24th Avenue, that intersection.
Sure. Let's talk about. Go ahead and ask your question if you will. I know we talked about it earlier today, but
yeah, I've just mentioned really ever since the very beginning of this whole project being mentioned, being built on this corner, I've had a concern about this particular intersection, this existing intersection, and how close it is to the Highway 9 and 24th intersection, and trying to avoid a similar situation to what we see at Crossroads Boulevard and Robinson on the west side of town. The ingress, egress, or the driveway, the mouth of Ann Brandon Boulevard onto 24th is what I would consider like abnormally wide. And as you mentioned in your presentation, that Ann Brandon Boulevard was never platted. So that's very interesting to me, because I've always wondered how that was allowed to be aligned like this. And I know it lines up with the driveway into the church across the street, so that makes sense, but it is so close to the highway intersection. And so I just have been very concerned about increased traffic using it to get to 24th Avenue, increased traffic from Highway 9 using it to get to the emergency center, and then even more so the increased traffic on Ann Brandon that could occur should and when the Perfect Swing property eventually does redevelop someday. So that intersection has just been kind of a real sticker for me, as we've talked about.
okay, thank you, Councilman. And obviously I'll have Todd answer this question. I do want to say, yes, this has been an interesting discussion point as to how this never got platted. I don't know the answer to that, but it was pretty shocking to us when we got into this project and realized that that was actually technically a private street, although really never treated as one. It's been treated as a public street all along. But Todd Butler, do you want to talk through all of those issues that Councilmember mentioned, please?
Sure. Well, first of all, it's difficult to do a comparison with Robinson and 24th. This is going to be a lot less traffic than you're referring to on Robinson, but the closeness of this was reviewed. and specifically the distribution of traffic was reviewed. And based on the layout specifically for the phase 2 part of the project, most of that traffic will be using that Overbrook Drive for access to and from those particular facilities. Some of it will use Anne Brandon, but for the most part, from an ease of access, we felt that most of that traffic would use Overbrook Drive intersection to access that phase 2 development. We did review the traffic under very future conditions, 2030 traffic conditions. In addition to the average annual growth to Highway 9, we worked with the city to look at projects that are approved but currently undeveloped, and we distributed the traffic expected to be generated by those undeveloped parts of those projects throughout this area, and added that to the traffic along Highway 9 and 24th as well. And under those conditions, that particular intersection at Anne Brandon is still expected to operate very well at a level of service A overall. And we think the critical movement would be a very high level of service of level of service C. What we're not seeing here is ODOT has some changes proposed along Classen at Anne Brandon to induce some restrictions of movements of traffic at that particular intersection. And along with that, they're doing some revising some a signal modification at the intersection directly north at the ramp intersection to provide full access there. So part of Anne Brandon will not have full access at Classen as well. So there's somewhat restricted amount of traffic to Anne Brandon based on what ODOT is planning to do at that location. So overall, we feel that the Anne Brandon intersection is expected to function as it currently exists, the traffic control that currently exists at that location.
So, because what I'm afraid of happening is that we end up, there's already a signal at Highway 9 and 24th, of course, but that we end up with another signal at Overbrook. We end up with a signal at Anne Brandon, and then we end up with another signal at Overbrook and Anne Brandon. So we end up with 4 traffic signals within a very small area. And this is looking years into the future, of course, but that's what I really would like to avoid happening at, if at all possible, is more traffic lights in this area. And I know the changes to Classen really are eliminating cross traffic from going across it, but traffic on Highway 77 will still be able to turn left and go into there. It'll be a protected median from the last drawings I saw. And so that traffic and then the new developments we've seen along Classen, the potential for the Perfect Swing to develop into something potentially pretty intensive commercially, like a big box store type situation, just does give me a lot of concern about Anne Brandon not being signalized, but I don't really want it to ever be signalized. I would prefer some sort of controlled turn or a roundabout, even anything to prevent another traffic light. And that area of Highway 9 too, especially since the widening, when traffic is coming from the north across Highway 9 to the south on 24th, it's kind of up on a hill, and they come over the hill and go downwards on 24th as they're coming towards this. And so there's been many times where I've tried to pull off of Anne Brandon Boulevard onto 24th and, thought I had enough time, but cars are coming off Highway 9 at a high speed sometimes. And so that's just been some of my experience over there and what has kind of led to some of the concerns that I've presented. So I do appreciate your explanation. I don't know if our own traffic, or if our own staff was on and might have some comments to add as well.
Thank you, Councilmember. I will weigh in. This is Sean O'Leary. Mr. Butler did a good job, I think, of explaining the background. Would just elaborate a bit and say that this development was required by staff for them to submit a full traffic impact analysis that was submitted back in April. Our staff of traffic engineers has spent a lot of time with Mr. Butler and his team reviewing that information. You raised all the right questions. Those are the same questions we were asking and that were answered with the traffic impact analysis. But also mention that when they do that sort of thing, when Todd and his team do that, they project other traffic generators from undeveloped properties like the Perfect Swing. So we're looking at the whole future complement of traffic, and we're looking for exactly what you said, what's going to happen at the key intersections and Brandon 24th, Overbrook and so on. We would not, as a staff, want to or ever allow multiple signals at those locations. So we were looking to make sure that wasn't going to be the case. As Todd indicated, that is not projected to generate the kind of traffic that would warrant that sort of thing. And if there ever were some change, unforeseen change that did generate more traffic than we're projecting, we would do exactly what you're talking about, and that is to do more of a restricted access, controlled median, the sort of thing that ODOT is preparing to do there at Ann Brandon and Classen. So we're really very satisfied with the projections that they've made. In fact, in this case, the roadway system is really well equipped to accommodate this development without the developer having to do very much at all. So fortunate for them. I would mention one thing that was identified in that the intersection of 24th and Highway 9, the southbound approach, as you indicated, it was identified that we need to make some changes there as a result of these traffic projections. So the existing left turn lane, through lane, and shared through right turn lane will be restriped as part of this project to be one exclusive left turn lane, one through lane, and one exclusive right turn lane before the first phase of this project is constructed. We think that will ease traffic there for that southbound movement at 24th.
Okay, I appreciate the explanation from both of you. Really, that helps a lot. I hope that helps neighbors in the area understand the situation better as well. So definitely something I hope we keep a real close eye on should this project get approved. So I think this is the only questions I have right now on this item. I do have some about item number 18 should we get there. Thank you.
Thank you, Councilmember.
Councilmember Patron.
Hi, thank you for the presentation. I've been eager to see how this would shake out. So I'm excited for the area to get some medical help for sure. So I guess my first question would be, what exactly have they purchased? As far as your zoom in photo here, is it the whole magnified area such that the property line is actually to the left of, I can't see what that is, but.
There we go.
Okay. Yeah. So is it pretty much the whole thing is accounted for on the others for the plat here?
Yeah, I want to make sure you finish your question. Yes, so the property is, you see right there, 29.6 acres. It is one tract of land. What we have site planned, excuse me, what we have site planned is the entire parcel. And so it has not been purchased yet. It is under contract with contingent upon this zoning to purchase. There are some very tight time windows I should make you aware of that we need this basically tonight, or that contract is probably in jeopardy. But this is the contract parcel right there, one parcel of land, 29.6 acres, contingent upon this zoning.
Okay, and if you wouldn't mind swapping back over to the other.
Sure.
Okay, so yeah, I see the shape now. What is the mud hole to the next?
It is an existing pond. I don't have any information other than just say it's an existing location, and actually you can see it before we have the plans on here. You can see it right there. So it's an existing pond offsite, not on our property or proposed to be on this property. I don't know that it has any function. Terry Haynes on the call. I think we've talked about it before. We don't know that that has any functions or relevance to this project.
Okay, so it's not it's not serving a stormwater purpose for the
Not that we're aware of. Terry, do you want to expand on that? I know you've looked a little deeper into it than me.
We did. I never really came up with a plausible reason for the pond out there. It is not a part of this development, and we're going around the pond as far as the offsite conveyance of the stormwater runoff from the development if it in our plans. But the pond is part of the it's on the Perfect Swing property.
Okay. On the commercial out parcels, it looks like we might, for the one up on the corner of 24, what is that? I mean, it looks like it has some sort of plan.
Yeah, whenever we do these plans at zoning level, we're simply looking at conceptual plans to give you some idea of what the parking area and the building relationship would be, but these are not set in terms of an end user yet. We don't have end users yet for these parcels, so there's no, I think that particular one, maybe they showed a bank floor plan or something, I'm not sure what it was, but again, we just try to do it in terms of spatial relationships to make sure that we have a building that is of similar size to what we believe will happen there, and parking of similar size as well. Because again, we're setting a site plan through the PUD. So that's the analysis that you go through. Terry may want to elaborate on that a little further when he draws these up, and we have the architects as well. But those are just shown for purposes of making sure we've planned the PUD accordingly, but there is no end user yet identified for this.
Okay, so can we expect that the setback of what whatever it eventually would end up being is consistent with what the drawing is here as far as from Highway 9, and you know that it's closer to Ann Brandon than it is to Highway 9. I see that you have a green space for the rest of that parcel around Ann Brandon. I'm just wondering if that's what we can anticipate for setback for a project there.
Yeah.
So this is Terry, Sean. To answer that question, yes, this is about as much as a development we could fit on that corner. What's not shown in the graphic is there's a right of way, and we also have a line of sight that's running along Highway 9 at that intersection of 24th Ave. So yes, that would basically be about the maximum size of a site of this nature.
This is a random question, but it's just from the history behind my question is actually from Legacy Park. Can you tell me how deep the water features are for the anchor and the 6 reflection pond? Is that meant to be like 3 inches of water, or is it an actual pond on those water features?
Terry, do you have that information, or would that be Jack?
I think Jack, I know you're on. Could you address that question, please?
And Jack Joyner is the architect that's been the main planner of this site. Go ahead, Jack.
Sure, thanks, Sean. This is Jack Joyner with JHBR Architecture in Oklahoma City. Those will be shallow, more reflection ponds. We don't want it to be a deep pond that would be, a safety hazard or anything like that. But as far as now, we're just looking at a couple feet.
Okay, so just to bear in mind, and I mean, somebody that has more experience with than I do on writing PUD language or whatever, but Legacy Park, we had some animals drowned in those, and so we ended up putting in stairs to keep, dogs that have gotten in the neighborhood or in the area that had gotten out couldn't get out. So I just would want to make sure that you all are keeping that in mind for those. I think they're beautiful. I think they'll add a lot to the area. Just speaking from experience of things that have happened in the city.
Thank you, Councilman.
Okay, the service drive. Why does it arc more towards the houses in the 50 foot narrowest area rather than hug closer to the residential to give these lots back here more of the buffer space like their neighbors have where the pond is.
Jack or Terry, one of you two want to discuss the design methodology of how you approach that?
I'll jump in. This is Terry. Part of it is well, again, that's quite a large space in between. So we have about 52 feet from the back of the curb of the, let me see if I can get my pointer out here. Here we go. So there is about 52 feet from the property line or the south, the common line between the residential properties and that driveway. So that is 50 foot of green space buffer in here. We also have to look at the access as far as servicing, and that does include trash trucks to be able to get in, to get out, to be able to service the backside of the drive, and then leave just enough room for the other service trucks that would be, in this case, against this housing. Same thing along the backside of this building. There's also providing green space between the buildings and the proposed trash enclosure areas, which also would be screened with gates and fences. That's a city requirement, but it gives us more opportunity to provide the green space on both sides of the service drive. I'm not sure if I quite answered your question, but you have.
Sort of. So I guess what I'm saying is if you look at the width behind the commercial out the strip mall area, I know it's probably not what it's supposed to look like, but the part that is off Ann Brandon, so the service drive from the back of the building is a rather narrow area to where, you know, I'm sure that they're large enough for the service vehicles. So I'm wondering on this other end, why you wouldn't hug the sides of those a little closer too, in order to keep this neighborhood down here, the lots down here, consistent on the amount of space that they have and a noise barrier. Does that make sense? Like why you have a large entrance. I wish you could see what, I don't have a pointer for your thing, but for this residential, newly developed residential thing, there's a big, I guess, assume that's a parking lot, and then some sort of, I have looking at this other map too, gate. So I was just wondering why it didn't on both of them, why it didn't hug closer to your buildings rather than hugging closer to, like it does on that side over there, why rather than hugging closer to the houses down here. And then my second part, and this is just, I'm not trying to change your project. I'm just wondering why, if you all would entertain considering, if this is about the service vehicles, why, and the neighbors are concerned about the traffic that's going to be humming through there, why wouldn't it just be dead end from both sides? In other words, around your anchor here, there wouldn't be a road. You would just have this beautiful open space. And if it's a service vehicle, it's needing to service the residential side of the project, that it's going to dead end right past that commercial entrance. Same on the other side, if it's coming in off Ann Brandon, have it dead end after the commercial entrance to those buildings as well. That way it's not a thoroughfare.
Yeah, let me ask Todd Butler or Terry, the one first impression I would have, I would say, Councilman, is whenever you dead end, you're another host of issues you get into what we call bulk cul-de-sacs, which are large, much more impervious concrete goes into those situations because we have to get large semi trucks around those over 100 feet typically of a bulb intersection. And then also you have difficulties of the continuation between these properties. But Todd, do you want to talk a little more about that as well?
This is Todd Butler again. I agree with Sean. There's a connectivity issue that you've got to be concerned about. But you'd also have to allow for a vehicle to get in there, large vehicles, to be able to turn around. And we feel that this is just the better option for service vehicles to provide service to all of those particular lots within that phase 2.
And if I could jump in, this is Terry Haynes again. It's also for safety vehicles, for emergency vehicles, for the fire truck access, and we have to be able to create that same turnaround for a large fire truck that may need to enter into the backside of the structures. If one end is blocked off, there is another opportunity to come in from the other, as is shown today. If it was just had one way in, one way out, it could be blocked off. Emergency vehicles could not get into that area.
Okay. Okay, let me see if there's, I have several notes here, and some of it might not be all appropriate for this particular question, but on the next one. But you spoke to on the phase one that we're definitely going to see the freestanding emergency center before we would see breaking ground on any of these other commercial out parcels, correct?
That's correct, Councilmember. The plan is that the FACD goes right out of the chute as number one.
So it will open before we see breaking ground of the other projects.
I don't know about that because the opening is 2022, I believe we had. I don't know if I had that, forget the slide I had that on. So I don't know if this would be open with a zero turn of shovel on the rest. I think that's unknown at this time, but the first project out of the chute would be the emergency room.
Okay, so yeah, I just want to kind of give the public what they can anticipate on, even though these are coming in two phases, they could be happening, the construction on them in tandem as far as how the public would perceive it, because it's not necessarily that phase one would be complete and operational. But it is the one that is the central focus and why they're doing this, obviously. So that's why they want to start it first and get the medical going.
That's correct. That's why we're here tonight, is to have this first project underway for Inspire Health, get it going. Then we start looking at Porter, Northwest Campus, all kinds of things. But this is the one that we need to get going, and so it goes right out of the chute with an anticipated time frame that it's opening in fourth quarter of 2022.
I think for my purposes, that's really all I have for the moment. I may have a question on the follow-ups.
Thank you, Councilmember.
Thank you for the great production.
Thank you.
Councilmember Hall.
Good evening, everybody. I wanted to thank Mr. Haynes and Mr. Butler for clarifying a lot of the details about the traffic plan, the stormwater plan. Your expertise on how you've developed this has been particularly helpful. So thank you for being with us tonight. First thing I want to do, totally low tech, but in reference to Mr. Splitt's explanation of how they came up with the theme for the freestanding emergency department and the whole development area. Let's see. Okay, so that's a picture of the South Base Hospital. That's my dad, who was an ensign in the Navy and was stationed at that South Base Hospital. So when Mr. Splitt first revealed how they chose to honor the history of the surrounding area, it really did bring a smile to my face. So that's just on a personal note. My other low-tech graphic, if you could go back to this, I don't know if it's the site plan slide or the maybe the slide, Mr. Rieger, that shows the surrounding area a little bit more.
This one?
Yeah, that one. Okay, so this is, we've made a lot of references to the neighborhood so far, and so because we have the protest map in our documents that we received about this project, it did cause me to make sure I understand this surrounding area around St. James Park, because you've identified the commercial use where the old Perfect Swing is located. But on this protest map that's produced from our planning department, this is all surrounding St. James Park is all R1. Do we know if that's correct?
Let me look here, Councilmember. So this is the current zoning map as I'm familiar with it. And
Yeah.
so that yellow right there is R1.
Okay. Okay. I just want to make sure that I had that straight because, you know, part of the consideration as we go through the discussion of the more of the details in the PUD is the protest map. And I think it's important for anyone who's listening in tonight to understand sort of the context of a protest map because although it's a 15.9% protest, the notification area is a 350-foot area surrounding the project. And so you can see that most of the land there is not a neighborhood. So St. James Park is on that south border. And so there was a pretty significant number of residents in that area that have written letters of protest and letters of concern that are within that radius area. And then the little pink dashed lines also show lots of residents in the area that have been involved along the way with questions. So when we're referring to the neighbors, I think this gives everybody an idea of the concentration of a neighborhood that's just to the south of the project. So that becomes relevant when we're, that's why I want to make sure that this is indeed R1, because I think the future development involves expanding the development of the St. James Park. And so the reason I'm bringing that up right now is we haven't really talked about the west boundary. And so in the slide that you have, you can see the blue line where you are committed to a precast concrete wall or similar material, correct?
Correct.
Yeah, okay, so so that covers that complete south border, but as this all develops out, it looks like we're gonna have more residential neighborhood that wraps around to the lower west boundary of the project. So I'm wondering how you're treating that west boundary right now. I see trees, it looks like, or shrubbery of some sort, but you can see that there's, let's see, 1, 2, 3, 4, at least 6 houses that are, you know, behind the project, not precisely your property line. I understand that, but I'm just wondering how you are intending to treat that western boundary right now.
Okay, so this would be the large detention area here, natural detention area, landscaping around it. I think we are envisioning this as the end of the property. We are not anticipating a wall at that point. I do want to clarify one point. I want to make sure there's no confusion here. This is R1 right here, but St. James, to my knowledge, stops right there. It does not go up north of that line. I want to make sure we're not confused about that point.
Does it extend to the west?
Yes, to the west, but it doesn't extend north. There's an area right there.
Yeah.
That is zoned R1. That is not to be St. James, though. I want to make sure we're not confused about that.
Okay, do we know what that's going to be? Or who?
You don't, it's part of the perfect swing property, and you see 2025 has it designated as all commercial. So this presumably could be anything commercial, C2, C1, C3, straight west. So the bordering point right there borders basically full on commercial in 2025, R1 in zoning. I'm not sure why there's a difference there because that's all part of the perfect swing property. And you can see that right there. This is all part of the perfect swing property. So 2025 would have all of this as commercial.
But what you're saying right now is that entire parcel is owned by one property owner and it's zoned in two different ways?
That's my understanding, Councilmember, yes.
Okay, okay, that's good to know. Well, still interested in how you're treating that whole western boundary for the time being.
Yeah, for the time being, since it is open range land over here and 2025 planned commercial, we don't intend a border other than what we would have to do would be the landscaping of the tree row you see right there. And of course, this is a large detention area. This is a large distance right here. Terry, I don't know if you know the dimensional distance right there, but that's a pretty big distance that we're talking about at that area right down by the detention pond.
Okay. And so on the service road, it also appears just from site plan that are those intended to be trees, I'm assuming, on both sides of that service road?
Correct on the outside. I don't know that if it's planned, you see it in this conceptual plan shown on the inside. I don't remember if Jack Joyner intended that as part of it or not. Certainly on the exterior of any paving parking lots, we have to do a tree row. And at the extension along this southern boundary, we have to do a tree row as well.
Okay, well, you anticipated my next question because you have touched on the barrier wall, and then there will be another barrier, so to speak, because you will be planting trees there as well.
That's correct, Councilmember.
Okay, thank you.
Councilmember Hall, just real quick, this is Gunnar Joyce of Rieger Law Group. Just to confirm really quickly, that is all one lot owned by the same owner. It goes all the way to the Perfect Swing site and all the way back.
Okay.
Sean, if you want to stop sharing real quick, I've got the county assessor site up if you want to see the
Sure.
visual.
Yeah, let's see it.
Perfect. There you go. So that is all one site, same owner.
Okay, and is it zoned in two different ways?
Apparently, yeah, based on the city's website.
And how does that work? Do you know?
I don't know that yet.
right.
We found something.
Thank you for clarifying.
You're welcome.
Thank you, Gunnar. How that works is a good question. We run across that every now and then. I've seen it 2 or 3 times in my career. There's smaller sites usually. You don't see one that big usually that has different zonings. I see it quite a bit in smaller sites that one lot got zoned something, or oftentimes where we see a council member is when a parcel got divided without going through the city process of subdivision. And so sometimes that happens many years ago and the zoning gets changed at that time. That's usually how I've seen it happen, is decades old issues where it got subdivided and then zoned without going through city process.
Okay, well, that really explains why I picked up on that conflict and couldn't resolve that myself. So thank you for the clarification. And I think most of the rest of my questions are directed towards the PUD. So,
okay.
I see no more comments from council.
Thank you. Since there are no more comments from council, this is an opportunity for members of the public to make comments regarding this item, which again, to clarify, is amending the Norman 2025 land use and transportation plan for the property of the location of this project. Are there any public comments?
Yes, Mayor, we do have some public comments. Laura Hogart, Ward 5, adjacent neighbor. Please consider how NHRS has lied to neighbors about site plan, uses, height, and detention plan. The service road on South needs to be removed. This project will create more vacant offices and retail space, as well as a vacant Porter campus. Apartments are not appropriate for this area. Brandy Studley, Ward 1. East Norman has always been cast aside. We have needed this for a long time. It takes me 20 to 25 minutes to drive to the hospital off Tecumseh. This is great. Kim White, Ward 4. He mentioned that massage parlors are deed restricted. Does that include therapeutic massages and acupuncture wellness centers? That's all.
Thank you.
I have one comment from the public. Angela Wacker, Ward 5. She said, is this going to be an ER? Will there be a helipad for critical transportation? If so, where would it be? And if not, why not?
All right. Mr. Martin, be sure to unmute yourself.
Thank you, Mayor and Council. I've been fortunate enough to be a 16-year resident of the St. James Park Addition. My wife and I built a home there when we were married and have loved living there for 16 years. As Councilmember Hall pointed out, I'm one of those who is outside of the notification area, but travel past this particular development site essentially every day for the last 16 years. We've brought our 4 kids home past this site from the hospital. We've lived our lives and have enjoyed very much living in this area. When we built in St. James Park Addition, both lots on either side of our home were empty. We knew that there were going to be homes there eventually, much like the development to the south of us. We knew that there'd be future development that would occur. And every day as I pass this site, whether it be in my car to go to work, or I often go out and jog on 24th and Braden Boulevard, I recognize the fact that at some point in time, this particular corner would be developed. It's too much an attractive site for nothing or for it to remain vacant forever. I was always curious about what that might be, knowing that the church had ownership of it. Many thought that ultimately there could be a church building there. Over time, there's been rumors that a big box retailer might land there. And of course, once Perfect Swing was closed down, most of us in the neighborhood have always been interested in what might be coming for that site. Since Inspire Health was initiated and developed, this has been of great interest to me, and I'm excited about what will be if you approve this item and the ones after this. I had the good fortune a number of years ago of working for the city, and like Commissioner Knotts, one of my very first activities, having worked for the city manager, was to attend a very large town hall meeting at Cross Point Church. It was to address the many traffic fatalities that were occurring on Highway 9. And sadly, those occurred. Lots of things have happened in the following years to help rectify that. But I can only imagine the lives that could have been saved had this facility been there 20 years ago. And so I'm thrilled that the hospital has contemplated making the investment in Southeast Norman. I'm really excited that this is the first of the entire Inspire Health project. I sat through the earlier meetings months ago, and many of you asked questions about when and if this was really going to occur, thinking that maybe all the attention was going to be on the healthplex. Rather, as we said here tonight, this will be the first project that breaks ground, likely the first project where the ribbon's cutted, and the first project that will make a lasting impact on our entire community. And I'm also excited about the development that can occur around it. There's a lot of opportunity there for different things to occur. Clearly, there's restrictions, deed restrictions with the church. Those are responsible. And I would hope it would remain at that and give the hospital the opportunity to develop this to the best of their ability. And lastly, I just want to say thank you to the hospital for taking into consideration the concerns, needs, and wants of my neighborhood. There are neighbors to the south of this development, and I think they've gone to great lengths with the wall that they've agreed to put in place, and also with the open space that's there to provide an amenity and a buffering between the development and the neighbors. So I hope that you adopt this item and also the subsequent items that will come after this. Thank you.
Thank you. Are there any other public comments regarding this item? Seeing none, are there any final comments from council regarding this item?
Councilmember Wilson.
Thank you. So having lived on Highway 9 for 5 years, in my 5 years on Highway 9, I experienced, I think, 3 fatalities in front of my house. One I know would have probably been best suited to go to a nearby hospital. The other 2 were unfortunately just dead on arrival. But this is and the number one thing I've heard since I've been a Ward 5 council member is the lack of emergency medical help in our area. And I think this is a really big step towards that. I understand that the heartburn of the neighbors in that direct vicinity, but I feel like Norman Regional has done a really good job of trying to address those concerns. I keep one concern, which is the traffic, and I think Stephen Tyler Holman actually addressed some of that or talked about that in his comments earlier. I'm willing to take the chance that this is going to emerge as a beautiful project because I really think it's essential for Ward 5 and for Noble even and further south. And as we see some of these Destin's Landing, which is not my favorite development, but it's there, it's coming online, and there's going to be a significant amount of people in this area. I also agree with commercial development along Classen somewhat. And this to me is just a natural kind of offshoot from that. It keeps that, inevitable sprawl in one area. So for those reasons, and the number one being a hospital in a very needed area, I support this project.
Thank you, Councilmember.
Councilmember Holman.
Thank you. Well, one is the question from the public about the helipad. I really hadn't even thought of that, but I think it is a really good question. I can't recall any complaints I've ever heard from neighbors around the Porter campus about the helipad there or at the Healthplex, but I think that is something that definitely we could address. Is this facility going to have a helipad? And if so, or if not, why not? I think that was a good question as well. So maybe if somebody wanted to, Richie or somebody might answer that one.
Okay, so Richie or John may be best suited to answer that question.
Can you hear me now?
Yes.
Okay. Thank you for that question. And yes, the freestanding emergency department, as we mentioned, is positioned for growth and the growing demands and needs of that very fast growing part of our community. So we could add that helipad in the future. Remember that facility, or having a helipad there, would be to transfer to another location. We operate MSTAT, and so if somebody's being MSTATed from a scene, say the accidents that Councilmember Wilson mentioned, we would not be stopping necessarily at that location. We could, but rather we would likely be getting those patients to a facility where surgeries might be involved to care for the patient. So a helipad could come as the facility grows, as the demand expands for that part of our community.
I appreciate that answer, Richie. My other question, just one thing I forgot to talk about with Sean O'Leary or traffic folks is the current condition of Anne Brandon Boulevard and the current condition of 24th Avenue, south of Overbrook specifically, is a wide street, but it's not striped, and the surface of the street is not in particularly great shape unless it's been repaved in the last few months or so, and I'm just not aware. But I know Anne Brandon is not in the best shape either. So I couldn't tell from the concept pictures if these two streets are going to be improved as far as resurfacing or anything like that.
Councilmember Holman, if I can get back to you tomorrow, I'll get you some more specific information about our plans for street maintenance. We're not recommending that of the developer at this time. The streets are in good condition and the appropriate width and so on for this particular development. But I do recall that both of those streets, Anne Brandon and 24th Avenue Southeast, are in our current queue for basic surface maintenance in the next, I'm going to say 2 years, but I'll get that to you and the rest of council in the morning with a more specific target based upon our current program.
Okay, and I just mentioned too that neither of them are striped. 24th has a median, all the way down to Overbrook, but past that it doesn't have striping, and Ann Brandon doesn't either. So, but yeah, I look forward to that. I appreciate that response, Sean. That's all I have on this item. Thank you.
Councilmember Bierman.
So I really appreciate Sean and Richie being here to answer questions, and I really do appreciate all the work that you have done with council members and with the neighbors to try and address at least some of, if not all of these concerns. I do have more questions that I assume you will have answers for when we talk about the PUD. But I am going to be supporting this project because it is a public health and safety issue also for Ward 1. There are a number of places in Ward 1 where someone has to walk more than a mile to get to a bus stop. And with all of the significant medical services located north enough or northwest enough in town, it makes it very difficult for many of the residents of Ward 1 to access needed medical services, particularly those of our public trust health system. And so I am really looking forward to having this project here. What I am going to be coming back to you all in trade for is additional green space at the reimagined Porter campus. Because this is going to be significantly contributing to impervious surface area in this city, which does give me a lot of heartburn. However, I am going to make a promise to myself and to the residents of this city to continue working with Norman Regional to ensure that I at least get some green space in trade up at the Porter campus to offset some of this impervious surface area, which I also don't believe Sean Rieger, I don't believe it was mentioned that the stormwater solution for this particular project has been engineered up to 95% impervious surface when it will not have quite that much. So it is intended to be a long-term solution that traps more stormwater than this project is even likely to produce. So I support all of that. I'm really looking forward to having some much needed health services in an accessible spot for Ward 1 residents. And but I will have some questions in the next item when it comes to the PUD details.
That's all I've got on council.
Thank you. The motion on the floor is to adopt the land use plan amendment. Madam Clerk, will you please call the roll?
Councilmember Bierman.
Aye.
Councilmember Perry.
Aye.
Councilmember Patron.
Aye.
Councilmember Hall.
Aye.
Councilmember Wilson.
Yes.
Councilmember Foreman.
Aye.
Councilmember Holman.
Yes.
Councilmember Peacock.
Yes.
Mayor Clark.
Yes.
The land use plan amendment is adopted unanimously. And to make a correction on the last item, I apologize. Kate Bierman was a no vote. It was not a unanimous vote. It was 8-1 and voting against Kate Bierman. Apologize.
Thanks, Ellen. I knew what you meant.
Thank you for that clarification. On to item 18, ordinance 1920-57, a rezoning request from O1 Office Institutional District to PUD, Plan Unit Development for property located at the southwest corner of Highway 9 and 24th Avenue Southeast. I'll entertain a motion to adopt or reject the ordinance on second reading, section by section.
So moved.
Second.
This is a companion item to the previous item. Are there any further questions from council regarding this item?
Councilmember Holman.
Okay. Sean Rieger, Mr. Rieger, if you would talk maybe briefly about the expansion possibilities of the medical facility based on this layout, and Gunnar and I had a conversation about it earlier, but if you would kind of go over, so we had talked about how, even in this presentation, that the population growth in this area could be significant over the next few decades. It's already seen a lot of growth, and it's definitely, we've talked about the changing face of healthcare, and Richie's talked a lot about that, how we're outpatient and not just trying to have a bunch of beds and everything. But, with just the population growth that we're talking about here, we could imagine the demand on this facility, especially the large rural area that it will be serving, could merit that it, be expanded in the future into more medical services, like more like a full service hospital even. So if you would maybe talk about the expansion opportunities that exist there.
Certainly, and actually, I'm going to bring in Jack Joyner, who is the design architect, Terry Haynes as well, because a lot of times when you plan a building like this, you're sort of pre-planning the site and the building for what you anticipate the expansion possibilities will be. So Jack, if you would probably be the best to answer that question, or Terry.
Sure. Thanks, Sean. This is Jack Joyner again. You can see to the east of the freestanding emergency department plus, we have the detention area, but between the detention area and the freestanding emergency department, we've got a parking area. If we were going to expand that facility, and Richie or John, maybe better to describe what that expansion would be, that would be the potential area we would have to expand, and then obviously have modifications to the parking area.
Okay. And they had mentioned that I think Gunnar or Richie had mentioned something about 25,000 square feet of additional space could be anticipated, perhaps. Was that correct?
Jack, go ahead and address what you think you anticipate the size of addition could be over here.
Yeah, obviously that's a discussion for future need, what the size that will be, but we definitely have the area to make that happen.
Okay.
You kind of see, Councilor, if you see that building is anticipated at 48,000 square feet, additional 50% of that would probably fit, as half of that building might fit right over in that area.
Okay. And we talked about the residential component, that the intent is for more geared towards senior independent living, not assisted living, not that type of situation. But we also talked about that if that was not possible, it could be any general type of multifamily. So we had talked about some of the concerns of the neighbors about student housing complexes. I don't particularly think this would be an attractive location for a student housing complex, as it's not near the campus really. So, but to kind of address some of those concerns about what type of complex could be there, I think we had talked about maybe agreeing to a limit on 3 bedrooms per unit, which would prevent that, rent by that 4-bedroom, rent by the room, share a living space model that we see in so many student apartment complexes. So maybe if you might mention that a little bit.
Yeah, thank you, Councilmember. I appreciate that. We did have those discussions today, you and I, and we ran it by the team. I think it's a great idea. We appreciate that idea. We were thinking amongst the team, how many apartment complexes have 4 bedrooms and up, and I think the only one I could think of was the Edge complex, which is student housing largely. You get some of the other ones we've zoned over the years, Callaway House, the View, some of those get into that concept, and those are definitely student housing. It is not our intention, desire, want, anything about it to make that a student housing project. So we are welcome and receptive to that friendly amendment to make sure that we put in here that that we can have no more than 3 bedrooms without permission of council. And that's been an effective tool I know that the council has used up in the center city and areas around the north end of campus. So we are happy to apply that standard to this housing. It is not our intent to desire to have any student housing. But we do think it's important to keep the flexibility of what type of housing it could be otherwise.
Okay, I appreciate that, and I would, I don't have it written up here, so Catherine might help me out. But I would propose an amendment to include that language in the PUD, if possible.
And we would be agreeable and receptive to that amendment, council member. Thank you very much.
Thank you.
If it needs a second, I will second it.
Thank you.
Okay, let's recap the language. It sounds like we now have a motion on the floor. Would you, Councilmember Holman, please repeat that for the record?
It would be a motion to, for the residential component, that it would basically allow no more than 3 bedrooms per unit, without coming back to city council for further approval if more bedrooms were added. Something along those lines.
Madam Clerk, were you able to get that down?
You're muted, Ellen.
The amendment to the PUD, the residential component have no more than 3 bedrooms per unit. To come back to city council if they want to make a change.
Correct.
And Catherine, yeah, and Catherine might want to clean it up for me.
Sure. I think it would probably be best just to add it to the definition of residential within the PUD. So after it says residential shall allow for senior living facilities, including but not limited to senior independent living, assisted living, and memory care facilities, as well as other uses allowable as a matter of right in RM6, provided any residential unit constructed does not exceed 3 bedrooms.
Yes.
Does that work for you, Sean?
Yes, we can agree to that.
Okay.
All right, and that was seconded by Councilmember Bierman. Are there any questions from council regarding this amendment? Raise your hand. Nope. All right, seeing none, this is an opportunity for members of the public to make comment about this amendment. Are there any public comments?
I don't have any.
Seeing none, this is an opportunity for council to make final comments regarding this amendment. Are there any final comments? All right, seeing none, council members, or excuse me, Madam Clerk, will you please? Council, wait, Councilmember Holman.
I can't tell if you were talking about this or something. It's Stephen wants to talk amendment. I assume Kate does not.
Yeah, I just wanted to clarify too that this amendment does not prevent students at the university or anywhere else from living in an apartment complex or any residential. Students can live anywhere they would like to live. It just means that this will not be constructed as a student-oriented apartment type complex, which we have seen many of. So I just want to make that clear. We're not preventing students from living anywhere, but we're trying to prevent a student complex from being built here. So thank you.
Thank you, Councilmember. Any other final comments from council regarding this amendment? All right, seeing none. Madam Clerk, will you please call the roll?
Councilmember Bierman.
Aye.
Councilmember Perry.
Aye.
Councilmember Petrone.
Aye.
Councilmember Hall.
Aye.
Councilmember Wilson.
Yes.
Councilmember Foreman.
Aye.
Councilmember Holman.
Yes.
Councilmember Peacock.
Yes.
Mayor Clark.
Yes.
The amendment passes unanimously.
All right, so now we are back to item 18, the PUD request as amended I believe we were taking questions from council regarding this item. Any other questions from council? Oh, Councilmember Bierman.
So my first question, so I live exactly 0.2 miles from fire station number 9. And the reason why I plotted that out is because it is not that much further, if at all, from the new freestanding emergency department if it passes, and the backs of some of the homes that are very close to there in St. James Place. So can someone talk to me about what, if any, requirements or regulations there are going to be to limit the amount of ambulance noise once the ambulances either turn onto 24th or cross Highway 9 onto 24th? Because I can hear every ambulance or every fire truck that leaves fire station number 9. And, it's not all that frequent, but they're not going to the fire station with their sirens on, they're leaving. So I didn't know if anyone had any feedback on that.
Yeah, thank you, Councilmember. This is Sean, and I'm going to ask Richie or John Manfredo to come into this discussion. But first, I just want to again reorient you to make sure that you're aware the ambulance traffic would be at the far northern end of the site, just off this corner, as far away from the neighborhood as we can get them. But so from a planning standpoint, locationally, that's what we're talking about. Richie or John, you might want to add to that as far as operationally goes.
Sure, this is Richie, and to Sean's point, we intentionally placed that facility in the location to help with the noise and with the lighting and everything else, but we control those lights. So our MSTAT crew will be very conscientious about the neighborhood around. They can hit the switch and as they enter onto 24th Street into the facility, that will be very similar to what they're experiencing today. If there's an MSTAT vehicle going along Highway 9, you could hear it as they are responding to an emergency, but as they come into the facility, into that development, those sirens go down and we control that every step of the way.
Great, that's what I like to hear. I certainly would love to see kind of an internal policy that once you kind of cross that threshold of Highway 9 onto 24th, if at all possible, the sirens go off, just because, we all know how weirdly sound travels in this city. So I just would really love to see that and be really cognizant of the neighbors. And so Councilmember Holman addressed the same question about residential living. But one of the things that Mr. Rieger and I have been working on today was related to my concern with the percentage of unrestricted commercial in those kind of out parcels. The way the PUD is written right now, the freestanding emergency department is included in the percent, or could be included in the percentage of allowed medical versus allowed commercial. And so after some fairly significant discussion with Mr. Rieger and getting some guidance from Ms. Walker about what the language would look like, I would like to offer an amendment to increase the minimum percentage of required medical and decrease the amount of allowed commercial. And this is it because the Porter campus is a medical campus. We have Doctors Park. We have a lot of medical offices that have located around that area. And, this is a property that is going to be developed in part, if not in large part, with tax exempt revenue bonds. And so I think maintaining the integrity of the medical campus is really important. And I'm very, very thankful that Mr. Rieger and Mr. Split were willing to agree to amendment language like this in a way that was very productive, not confrontational, and certainly recognized the importance of ensuring the integrity of a medical campus so that we don't end up with primarily commercial development around this freestanding emergency department. So I will make a motion to amend section 3, subsection A, permitted uses, and now my phone's turning on me. So all lots within the property, excluding the freestanding emergency department site, shall be referred to as the remaining property. Medical, a minimum of, why does my phone keep turning on me? A minimum of 30% of the remaining property. Commercial up to 40% of the remaining property. Residential up to 30% of the remaining property.
Thank you, Councilmember. If I could react, and I do appreciate your comments of working back and forth. It is always a great pleasure of ours to be able to work through issues like this with you, with any council members and come to a resolution. But the credit goes to Richie Split, John Manfredo, and the Norman Regional Health Team that they looked at this closely today and decided that it was a workable solution that they could accommodate. And I would just reiterate that they do intend very much to want to make sure that this facility overall is a beacon of medical and health for this area. We just simply have some unknowns that will carry forward with us after the phase one, and we have to be able to accommodate and be flexible for. But we were happy to do this amendment with you today. We appreciate the suggestion, and it was a concern we had heard quite a bit. And so hopefully this puts that to bed, so to speak. So thank you very much for that.
Second.
All right, we have a motion. Madam Clerk, do you want to read that back?
I do think Ms. Walker has the language.
Okay.
As well.
Okay, so this would be an amendment to section 3A of the PUD. So it would say uses permitted. The freestanding emergency department is planned for Block 1, Lot 1. The remaining property shall contain the following allowable uses: medical, non-FSED, a minimum of 30% of the remaining property, commercial up to 40% of the remaining property, and residential up to 30% of the remaining property.
Okay, and we had a second from Councilmember Wilson. Does council have any questions regarding this amendment?
My dog is, sorry. My dog is
Hearing nothing but the dog. So hearing nothing but the dog. Are there any comments from the public regarding this proposed amendment?
Not that I have.
Seeing none, are there any final comments from council regarding this proposed amendment?
I'll just make one final comment and reiterate once more how appreciative I am that both Mr. Rieger and Mr. Split were very accommodating and understanding of this request. I can't say that, you know, I always go into these types of discussions with a whole lot of optimism, but I was definitely proven wrong today, and I really appreciate that, because I do think that this will be helpful in making sure that the Southern campus includes as much medical as possible. So, and that future councils now have the guiding wisdom that this council laid out for them in the PUD. So I'm very appreciative of you both and the entire team for working with me on this, including Ms. Walker for getting the language ready so quickly with my scribbles and a text message to get this off to her. So thank you all.
Well, on behalf of the Norman Regional Health Team, thank you as well for working with us. This is how it should work. So I appreciate your optimism. Let's keep that up. I appreciate it.
I share that sentiment as well. With that, Madam Clerk, will you please call the roll?
Councilmember Bierman,
Enthusiastic aye.
Councilmember Perry,
Aye.
Councilmember Patron,
Aye.
Councilmember Hall,
Aye.
Councilmember Wilson,
Yes.
Councilmember Foreman,
Aye.
Councilmember Holman,
Yes.
Councilmember Peacock,
Yes.
Mayor Clark.
Yes.
The amendment was passed unanimously.
All
Second.
right. We are back to item 18, ordinance 1920-57, the PUD. We've had 2 amendments so far. Are there any other comments from council regarding this item? Okay, before we dive into public comment, we have had a request for a break. So let's take 5, it's 5 minutes. It is 9:32. I will see you all at 9:37. Please turn off your cameras and be sure to mute your audio.
Way, yep. Oh, well, he's probably gotta go to bed too.
All right. We have Councilmember Hall, and then we will get started. Yep, she was just waiting for me, weren't you, Councilmember Hall? Okay. All right, to remind everyone where we were at, we are on item 18, ordinance 1920-57 with 2 amendments, and we are now on public comment on the amendment or on the PUD as a whole as amended.
I see nobody.
Okay, no public comment. So are there any final comments from council regarding this item?
Don't see any.
Okay, so the motion on the floor is to adopt the ordinance as amended on second reading. Madam Clerk, will you please call the roll?
Councilmember Bierman,
Aye.
Councilmember Perry,
Aye.
Councilmember Patron,
Aye.
Councilmember Hall,
Aye.
Councilmember Wilson,
Yes.
Councilmember Foreman,
Aye.
Councilmember Holman,
Yes.
Councilmember Peacock,
Yes.
Mayor Clark.
Yes.
The ordinance was adopted on second reading as amended unanimously.
Thank you. I will now entertain a motion to adopt or reject the ordinance as amended on final reading.
So moved.
So moved.
Second.
The motion on the floor is to adopt the ordinance as amended on final reading. Madam Clerk, will you please call the roll?
Councilmember Bierman,
Aye.
Councilmember Perry,
Aye.
Councilmember Patron,
Aye.
Councilmember Hall,
Aye.
Councilmember Wilson,
Yes.
Councilmember Foreman,
Aye.
Councilmember Holman,
Yes.
Councilmember Peacock,
Yes.
Mayor Clark.
Yes.
The ordinance was adopted on final reading as amended unanimously.
Thank you. Item 19, preliminary plat for the Norman Regional Health System East Campus Edition located at the southwest corner of Highway 9 and 24th Avenue Southeast. I'll entertain a motion to adopt or reject the preliminary plat.
So moved.
Motion.
Second.
Second.
This is a companion item to the previous 2 items. Are there any further questions from council regarding this item?
I see none.
Seeing none, this is an opportunity for members of the public to make comments on this item. Are there any public comments?
I have none.
All right. Are there any final comments from council regarding this item?
Seeing none.
All right, I think I'll make a quick comment about the whole Inspire Health program. I think this is one of those projects that we're all gonna, as we've touched on, we've had an opportunity to do a few of these lately. When it's done, we're gonna be able to point to it and say, I helped do that. And this is game changing, I think, for South Norman, Southeast Norman, East Norman, as we continue to grow. And we continue to provide outstanding healthcare for our residents and surrounding communities. And I think Mr. Rieger said it quite well. When we first had the Inspire Health conversation, I don't think any of us foresaw what was coming. And it has been an honor and very helpful to have Norman Regional Health System throughout the whole COVID-19 pandemic. And I really appreciate our partnership. And I'm looking forward to seeing this grow and what we can do for our residents. So with that, Madam Clerk, will you please call the roll?
Apparently we have a public comment. Just a second. Nathan Anderson, Ward 6. I'm concerned that any future expansion of this NRHS facility might require removing a significant part of both its southwest detention and parking. This fits with WRT, the future of our Porter campus? Question mark. Too sure. That's all.
Okay, thank you. Madam Clerk, will you please call the roll?
Councilmember Bierman,
Aye.
Councilmember Perry,
Aye.
Councilmember Patron,
Aye.
Councilmember Hall,
Aye.
Councilmember Wilson,
Yes.
Councilmember Foreman,
Aye.
Councilmember Holman,
Yes.
Councilmember Peacock,
Yes.
Mayor Clark.
Yes.
The preliminary plat was approved unanimously.
Thank you. Item 20, ordinance 1920-61, special use for one and only one of the specific uses permitted in the M1 restricted industrial district, specifically G, medical marijuana processor, any tier except that tier 1 and tier 2 will not be allowed to have on-site sales, as allowed by state law, in the A2 rural agricultural district for property located at 4520 East Franklin Road. I'll entertain a motion to adopt or reject the ordinance on second reading, section by section.
So moved.
Is there a second? Is there a representative of the applicant to make a presentation?
Yes, Mayor Clark, Gunnar Joyce with Rieger Law Group. The applicant, Jordan and Michael Fyack, are also on the call, and there is another attorney, Justin Williams, who specializes in the medical marijuana industry that is here to also assist. But I'll quickly present a short PowerPoint here to explain this special use request. This is the location map. Just like you said, we're right off of Franklin Road and 48th Avenue Northeast. This is the existing aerial of the site. There's one house on it currently. It's about a 9-acre tract, currently zoned A2. Here is the site plan. The current allowance under the A2 zoning category allows for medical marijuana commercial growing, and that will occur on this site. That is not part of the special use request tonight. Additionally, as you can see here, there's a new warehouse shown. This is an accessory building that is also allowed as a matter of right under the current A2 zoning category. So the medical marijuana growing and the medical marijuana warehouse both are approved, and construction of that warehouse is currently underway. City of Norman has issued a building permit for that warehouse. And so, excuse me, to briefly talk about the site and what's underway right now, under the current A2 zoning category, accessory building warehouse is already allowed and underway, and medical marijuana commercial growing allowable across the whole site and will be underway once the warehouse is completed. So why are we here tonight? It's solely for processing. And the applicants here are proposing to process in a portion of this warehouse that's being constructed. It will not be within the entire warehouse and will not occur anywhere outdoor on the property. So solely an indoor processing request. So just to talk a little bit about why processing is something that we have to ask for. The processing license under the state and the city's ordinances is required for any alteration of the cannabis flower. And so the applicant can grow the cannabis flower, can grow medical marijuana, but any processing, any alteration, including even breaking flowers into smaller pieces, requires a processing license. And so that's why they're here today, to request the ability to do this inside the warehouse. The processing is going to be entirely indoors, entirely inside that warehouse. This is not any kind of commercial storefront. This is not a dispensary. There is no ability for the processors or the commercial growers to sell directly to a customer. Everything is wholesaled, and so there is no parking and transaction for consumers here on site. Just want to make that clear, that there is no commercial aspect. And then again, this is not a change in the underlying zoning. It is going to remain A2. It's solely a special use request, and special use is specific to the property owner. It's also only lasts while the owner owns the property, and it has to be active for a period of 2 years. If they stop using this for a period of 2 years, the special use goes away. So that's kind of the general request. I would also like to point out that we've heard comments from neighbors. We obviously want to be very considerate here. And so as part of a special use request, you can place special conditions on yourself. So the applicant has done that here. They have proposed 6 special conditions for this special use. Again, a lot of these are going to apply to the entire site. And if this is not approved, medical marijuana growing in that warehouse will be done on the site. The warehouse is being built right now, and none of these 6 things are required under the current zoning, under the current plan. And so we are requesting here to bring in a very small, minor change to the existing zoning to allow processing inside the warehouse, and in exchange, we're self-imposing these 6 conditions. So I'll walk through them real quick. The first is hours of operation. That's something that would not be applied to the commercial growing activities under the current A2 zoning. The applicant is willing to self-impose that at 8 a.m. to 8 p.m. for processing activities. That's to limit any impact that there could be noise or light associated with the building late at night or early in the morning. Additionally, the applicant is proposing fencing and landscape buffers, pretty substantial buffers on the property that, again, would not be required if they just move forward under their current zoning. The first being a 4-foot buffer, and I'll bounce here real quick, to separate these existing driveways. This property to the west and the subject property have 2 driveways that are very close to each other. There's been concerns by this property owner that people coming to the site might not turn down the correct driveway. And so part of these conditions are, first off, to buffer that driveway with landscaping or a fence. It's preferred by the applicant that they do a green landscape buffer, either hedges or trees. But we have written in the special conditions that that buffer has to be installed and maintained. And so if in the event landscape just doesn't function there, they're committed to putting in a fence. And then there's additional buffering going around the warehouse. This is to kind of prohibit the visual impact of the warehouse on any surrounding neighbors. So again, they at least 6 feet in height, landscape buffering. Again, the intent and the desire here is a 6-foot landscape buffer around the warehouse, potentially evergreen trees or the holly trees that'll form kind of a natural landscape wall. But again, in the special conditions, it's a requirement that that buffer has to be maintained. And so if in the future, landscape is just not working there, they're committed to a fence to, again, ease that visual impact that the neighbors might have. And then full cutoff outdoor lighting fixtures will be installed on the warehouse. They're going to comply with the commercial outdoor lighting code. That again is something that wouldn't be required on them. I do not believe that that one might be required on some of the commercial growing lights, but this again goes to the whole property. The enhanced property identification measures is a specific comment that we heard from that same neighbor to the west. And we are committed to putting in either enhanced numbers, property address numbers, or a large mailbox to identify clearly which driveway is associated with this property. Again, I think it's important to note that this is not a request and is not even the intent of the applicant for commercial signage that fronting Franklin. This is solely just improved identification off of Franklin for the site. Finally, the concerns that we've heard about marijuana smell are addressed with the carbon filtration system in the warehouse. This is another important fact, that carbon filtration is something the applicant is committing to here, but again, is not required if this just goes forward as commercial growing. And so this is another consideration, that in exchange for the processing that'll solely occur in a portion of that warehouse, they're committing to carbon filtration throughout the entire warehouse to ease the smell that is going to exist regardless of the outcome of this application. And then finally, enhanced security measures. They're committing to the following: a central alarm system, self-locking and self-closing doors in the warehouse. So that way a door cannot be accidentally left open or left ajar. They shut automatically, they lock themselves. Full video surveillance on the property, and employee-only access to the warehouse. So again, we feel this is a very substantial conditions that the applicant has placed on themselves. I've put the picture up here. I believe you have this in your packet, but this is not just things we're committing to in the slides of presentation. You have the full condition of approval document that'll move forward through the life of this special use. So that is, in summary, the application, and we're happy to answer any questions you may have. Thank you.
Thank you for that. Okay, I saw Councilmember Wilson.
Yeah, I have several questions. Sorry, I'm gonna get my writing place. Okay, so currently an agricultural zoned property could grow marijuana outside the whole acreage. Am I correct in that?
That's my understanding. I don't believe there's a limitation on the density or a portion of the site.
Okay, and tell me again how big that building's going to be?
Yeah, it's just under 11,000 square feet. I think it's 10,900. A portion of that, not the entire building, is going to be the processing.
And tell me what type of processing they're going to be doing.
Yeah, that as part of this request, they've requested Norman breaks processing up into 3 tiers. All 3 are requested here, although this is a new business, and so the current initial plan is solventless processing. And I apologize, I'm a little naive in this process, so I'm going to ask Justin Williams, the other attorney helping out the applicant on this, to address that further.
Good evening, council members and Madam Mayor. Thank you for having us this late in the evening. I do want to.
It's early.
Right.
Come on.
Yeah, he's not familiar with these. I apologize.
I believe there are 3 separate tiers of processing under Norman's codes. The first one concerns the manufacture of edibles. So that would be gummies or baking cannabis into some edible product. The second tier would be solventless extraction, of which there are 2 that are contemplated for use by the applicants here. The first would be pressing, which concerns the application of heat and pressure, whether that's just physical pressure or hydraulic pressure, to press the oil and rosin out of the medical cannabis to create wax or shatter that is then able to be made into some other sellable product to dispensaries. And also ice and water extraction, which would utilize the altering temperatures to also pull out the oils from the medical flower to sell to dispensaries for consumer use.
And also, Councilmember Wilson, I'm going to share the screen real quick here as I brushed over this. But the warehouse has been issued a building permit right now. And again, like Justin said, there isn't a plan for any kind of chemical extraction or combustible. I think, Justin, correct me if I'm wrong there, but combustible solvent processing. But in the event that does occur, the applicant has to go through the full city process again for an additional alteration permit. And so at that point, they submit the equipment they're proposing to use inside of the warehouse to city staff. City staff will review the equipment and then any changes that have to happen to the warehouse, such as fire suppression or any additional electrical additions or alterations to the building prior to another permit being issued for those additional uses. That all has to occur before they can kind of enhance basically the types of extraction that are going to occur in that warehouse. So right now, out of the ground, solventless processing, ice and water, pressure and heat, no combustible chemicals.
So let me talk
if they wanna
about
do that,
pressure
they
and
gotta go
heat
back.
real quick. I'm sorry. Pressure and heat, what are we looking at fire wise? And before you answer it, I'm gonna go ahead and push this out to maybe Sean O'Leary or Ken Kaminsky. What's our fire suppression situation out there? And Gunner, or Mr. Joyce, I'm sorry.
Either one works for me, you're fine.
I'm
yeah.
sorry. Would there be a significant heat situation? When you say heat, I don't know what that means. There's just like a
No, great question.
household heat or
I asked that same question. I'm glad you brought that up. I was told it's essentially like a large hair straightener, and it's about 200 degrees. So
okay.
It's not a yeah. I was thinking a lot higher, a lot harder, higher
Okay.
temperature than that.
Well, just for curiosity's sake, somebody on city staff can answer what the fire suppression, it gets weird out there. We're putting in a lot of new water wells, so some areas out there have fire hydrants and some don't. So is there anybody on here that knows?
Councilor, this is Sean O'Leary. I don't see Ken on the line here, but I may be missing him. I don't believe we have public water systems in this area of Norman, so there would be no fire hydrants or systems for the fire trucks to access immediately adjacent to the parcel. They would probably have to go back at least a mile to get to the public water system. So it would be whatever the trucks can carry to the site, just as they would for any other property in this part of Norman.
Well, Sean, do I understand correctly? I know when I tried to get a dog boarding facility out where there was no fire suppression, that we had to do a storage tank on site. Would that maybe be the case here?
I'm going to have to kick it over to Jane Hudson or that group that issued the building permit. I know the building permit has been issued, so fire suppression would have been addressed as part of the building code review, and Jane can probably speak to that.
Good evening. So the building permit that was issued for the grow facility. And at that time, I guess that there weren't any concerns with fire suppression or anything like that. There weren't any additional requirements to my knowledge. But if they come back with any of the chemical processing, I mean, it very well could be that they would need to have some sort of fire protection out there. And that would be through the fire review.
Okay. So that's already established. There's already processes in place to address that. We don't have to address that tonight. Okay. One more question, Jane, this may be it for you. Remind all of us, and I think I know the answer, but special use in agriculturally A1 or A2 zoned property, what items, what kinds of businesses can be allowed there?
Within the A2 district, I mean, there's a large list. We've got skeet, trap shooting, riding academies, home-oriented fish, bait establishment, rodeos, slaughterhouse, bed and breakfast. Then there's the item for the one and only one from the M1, which is what these applicants are requesting. Veterinary clinic, a zoological park, a crematorium, municipal uses, wedding venues, and that's in the A2. In A1, there's only the municipal use, tiny houses, and the agri-wedding venue.
Okay, that's all my questions. I did see that Jordan and Mick aren't really showing up on my screen, but maybe they had some answers to some part of my question.
I was going to say the city did install a new water well system right next door on the Argos property.
Okay. All right. Well, that's a good answer. All right. That's all I had. I'll leave it to somebody else now.
Councilmember Hall. Okay.
I think my question is for Miss Muckala. Is she still with us?
Yes.
Okay. Hello. Good evening. How are you?
Good.
I wanted you to clarify comments that you made at the Planning Commission meeting. You had pointed out to the planning commissioners, I think what we were just getting into with the processing, the tier 1, the tier 2, and tier 3, and that under our city ordinance that if we pass this special use, it would apply to all 3 tiers. Is that correct?
As written, they are asking for all 3 of the tiers. And at Planning Commission, I was concerned there was some confusion as to whether or not they would need to come back to do a tier 3 use, which they would not. But what was said here tonight, I think related to building permits that would issue and review and inspection of their fire suppression for equipment. And that's absolutely true. They'll have to go through proper processes for that. But as requested, they would not need to seek additional approvals to use our tier 3.
So at present, what's being proposed is the tier 2 level?
I wouldn't say that. Actually, and I might clarify that, our tiers are a bit different. Tier 1 was the pre-rolling. And tier 2 was the addition of an already extracted substance that was extracted off-site to make a derivative product. That was our tier 2. And then tier 3 actually encompassed all of our extraction. We didn't separate chemical versus non-chemical extraction or anything like that. We didn't delve into that. We left all extraction in tier 3. So if there's any extraction, it would be in our tier 3.
So the extraction that they're coming forward with tonight would be included in our tier 3 then, not tier 2. Is that right?
Yes, that's where it would fit categorically. However, the special use they're requesting would allow them to do all of it. In fact, well, tier 3, I should say this, the way that we, I think it was during a meeting that we changed it, but we made our tiers cumulative. So tier 3 is going to include 2 and 1. But yes, we are in, when we're doing any type of extraction, we're in tier 3.
Okay, but if you could clarify what we were just talking about with the press or the ice and water extraction, which is a non-chemical extraction, which I think is what they're talking about for now.
Yes.
But if they would come back, they wouldn't need to come back to council for any kind of additional special use. It would all be involved with working it out with permitting with the city. Do I have that right?
Yes, that is my understanding.
Okay. Okay. I think that's it for now. Thank you.
Any other questions from council? Councilmember Patron.
Just because I'm kind of unfamiliar with this business, can you tell me what can the neighbors expect as far as traffic coming in to cart away the product?
Yeah, Councilmember Patron, Gunnar Joyce again. That was one of the intents of our hours of operation. Special condition that we placed on ourselves is we had heard concerns at pre-development and planning commission. We tried to address the planning commission. That's when we presented these conditions, but they were concerned early morning and late night deliveries would be something that happened on the site. And in order to address that, we've limited the hours of operation to 8 a.m. to 8 p.m. so that there would be no deliveries before 8 a.m. in the morning or after 8 p.m. at night. As far as frequency or intensity of those deliveries, I don't think we know that yet. I don't think the plan, and Jordan and Michael, you follow up here, I don't think the plan is multiple a day by any means. I think it would be various times throughout a week.
If I may add on to Gunnar's comment, this is Justin Williams, additional counsel for the applicant. We're growing a plant here that takes several months to mature. And so I think that deliveries of the product, especially initially, would be a one-time ordeal. There would be a need to purchase seeds or very small plants. And then thereafter, it would be several months before there would be any product ever leaving the facility unless they were to expand within that one building. Once the operation is fully functional, the idea behind most operations at all, I can't speak for the applicant fully because it hasn't begun any operations yet, but the idea would be to try to tier or stagger production such that you are bringing in a harvest every matter of weeks. So as it concerns transportation of actual product, you're looking at movement every week or two and under a best case scenario. And there's a possibility where you only see a movement of product every couple months. The traffic concerns of the neighbors, I think, are going to be most felt by actual employees who come to the site. But that is something that, again, is already going to be present under the grow or for purposes of operating the grow facility, regardless of the council's actions tonight.
And just that's a great point. I'll follow up one more time. We really believe that the delivery intensity and frequency is not going to be impacted by this actual special use request. The deliveries and the pickups will occur on the site if it's commercial grow or if it's got the small subpart of processing as well. And if anything, the commercial hours of operation condition that we're placing on the applicant would not apply if this special use is not approved. And so we think that our condition improves deliveries on the site, knowing that commercial growing is going to occur regardless.
I could add some little additional clarification as well, just for the council's benefit, and I will not try to dive into this too deeply, but the applicable regulations of the Oklahoma Department of Health require any company that is transporting medical marijuana to also have GPS utilized on those vehicles to keep the medical marijuana in a locked box or structure within the vehicle, to have the person who's transporting it be actually licensed with the State Department of Health. And you also have to have a transport manifest that identifies not only the origination of the product, but its destination. And obviously, Gunner's presence here and my involvement in this company is intended to ensure that all those processes are followed.
Just as a follow-up, looking at the subject track map, is it just using Franklin Road, or I guess my question is, are there any private roads that are involved here that are shared with the neighbors such that a road maintenance agreement would need to come into play?
No, it solely fronts Franklin, so it's the driveway to the property.
Great, thank you.
Thank you.
Any other questions from council? Okay, seeing none, this is an opportunity for members of the public to
I have
make
a
comments
question
regarding
real
this
quick.
item.
Pardon me.
Councilman Perry.
What's to keep you all from bringing product from other places in to be processed in this location?
Well, if I may answer that, Councilmember Perry, nothing under the law would prevent the applicant from processing medical marijuana purchased from any other commercial grower or from any other commercial processor. That is correct.
So this could be like the old cotton gin where everybody brought their product to you and had it processed.
That is correct. That is permissible.
Okay, that's the only question I have. Thank you.
I can just.
Go ahead.
I mean, our plan from the beginning, when we're first starting out, is to be self-produced. So we would only be processing our products that we grew ourselves at the start, for sure.
Also, just we'll add on to that and say that, again, the commercial growing is going to occur on site regardless. And so the easiest and least expensive way for processing to occur is for them to use their own product that's already in the warehouse. And it's not going to be a major processing site. It's solely one room inside of that under 11,000 square foot warehouse. So it will not, as proposed, turn into a massive processing warehouse or site for additional medical marijuana, throughout Norman.
Thank you. Are there any other questions from council regarding this item? Okay, now seeing none. Are there any comments from the public regarding this item?
Don't see anything.
Thank you. Are there any final comments from council regarding this item? Councilmember Wilson.
Yeah, I have, regarding marijuana and agriculture, I feel like we should allow, especially in agriculturally zoned areas, what you would do for tomatoes to happen out there for marijuana. I know it's controversial, but I feel like this applicant has gone above and beyond what we have asked them to do as a city. And so I ask that you all support this. I intend on supporting it. I feel like it's a valid industry in our state. And it mostly protects and maintains the green space out there. It's by right, you could have that same size horse barn. You could do a lot of things, including, and I always think this is comical, and I use this as you can have a crematorium, you know, so I think that this is not beyond the scope of what the rural Norman can, you know, maintain and desires. So I intend on supporting it. Thank you.
Thank you. Any other comments from council? Councilor Holman, your hand went up. We'll be like in class where if you move, I'm going to call on you. So, okay.
I had an issue.
Sorry, it's getting late. Any other comments from council regarding this item? All right, seeing none. The motion on the floor is to adopt the ordinance on second reading. Madam Clerk, will you please call the roll?
Councilmember Bierman,
Aye.
Councilmember Perry,
Nay.
Councilmember Petrone,
Aye.
Councilmember Hall,
No.
Councilmember Wilson,
Yes.
Councilmember Foreman,
Aye.
Councilmember Holman,
Yes.
Councilmember Peacock,
Yes.
Mayor Clark.
Yes.
The ordinance is adopted on second reading by a vote of 7-2, voting against Councilmember Perry and Councilmember Hall.
Thank you. I'll now entertain a motion to adopt or reject the ordinance on final reading.
Motion.
Second.
Is there, the motion on the floor is to adopt the ordinance on final reading. Madam Clerk, will you please call the roll?
Councilmember Bierman,
Aye.
Councilmember Perry,
Nay.
Councilmember Petrone,
Aye.
Councilmember Hall,
No.
Councilmember Wilson,
Yes.
Councilmember Foreman,
Yes.
Councilmember Holman,
Yes.
Councilmember Peacock,
Yes.
Mayor Clark.
Yes.
The ordinance is adopted on final reading by a vote of 7-2, voting against Councilmember Perry and Councilmember Hall.
Thank you. And now we're on to item 21, ordinance 1920-56, adding section to the city code for short-term rentals, providing fees and guidelines. I'll entertain a motion to adopt or reject the ordinance on second reading, section by section.
So moved. Second. Whatever.
I'd like to recognize Ms. Jeannie Snyder, Assistant City Attorney, to make a presentation.
Okay, let's see if I can share the screen. No. Uh-oh.
There it is.
All right, but now I'm gone. Okay, there we go. Is the screen up? I mean, can you all see the PowerPoint? Okay. My first time to
Zoom. We see the Zoom
Yeah,
screen.
you seen
open
the
up the
okay.
PowerPoint.
Bryce. I'm telling you, I hadn't done this. I was like, ah, crud. You see it now?
Yeah, but it needs to be bigger.
Okay,
Make
it
it
needs
full
to be
screen.
bigger.
Do the little slideshow button on the bottom.
Here, Catherine's coming to my rescue. Where's that?
I think
She's a pro.
Yeah.
They're all in here now, three of them.
I think you're good.
Is that good?
There we go.
Okay. And now if I can just get up to the first one. Okay. Yeah, I had 3 people come to my rescue, so that's awesome. Okay. We have been talking about short-term rentals since February of 2018. And by my count, I think this may be the 14th meeting on this. We've had a lot of discussion and and a lot of input at the meetings. And I'm glad that we're here tonight on this. Just a quick overview before I go through the ordinance, not change, the actual new ordinance is currently they're not permitted in our zoning ordinance. If right now it would be in a residential area, it would be like a hotel would be if you rented for less than 30 days in a hotels and are not allowed in residential areas. We're going to add it to a new section in the licensing agreement. That is how we settled on it after all the discussions. They're going to be, and I'll go through the zoning districts in a moment, there's going to be added to almost every zoning district except rural commercial, light industrial, heavy industrial, and restricted industrial. We'll go over the PUD and SPUD requirements and some special use. Jane Hudson is on and she'll help me get through that. If there's any questions about the effect on the CCFBC, the form-based code, it is permitted as overnight lodging, and I'll get into that just a little bit more, and Jane can answer any of the more detailed questions about that. And then one thing I'm really, really happy about, and I'm really pleased, it's really going to work out, and I'm having fun learning how to work the software program with host compliance, our monitoring service for this. And they have been excellent. I'm not the most tech savvy person out there. They answer every email. They're been very anxious to do any kind of 15-30 minute conversation with me online. They've just been great. And so I think we've really found a great partner to help the citizens be comfortable with us knowing that we know where all these short-term rentals are located in Norman. This is just the full list of will they be permitted, and as I said, they'll be in an allowed use in about every zoning district. Short-term rentals in PUDs and SPUD zoning districts cannot be allowed without first receiving approval for a zoning amendment from City Council. So you would still hear those. If a short-term rental wanted to go in one of those areas, that would still come before City Council. There's also office institutional districts with special use for mixed building. Another requirement we've built in is if an applicant wants to have operate more than four short-term rentals, they would need to come before City Council as a special use to see if City Council wanted to approve that special use. And also, if an applicant's license is denied, suspended, or revoked, at one point and then at another time wants to come back and submit a new applicant, that applicant would have to comply with the special use and come before council before that could be approved. And I already mentioned these. This is where they will not be allowed: the rural commercial district, light industrial, heavy industrial, and restricted industrial. Now this is just, I'll go over the ordinance, the licensing ordinance. You've got to have a license and you've got to pay the fee. I just mentioned you can't have more than four unless you get a special use. Only one party a guest. You can't have a number of different, it has to be one guest that's hosting, that is renting the short-term rental, and no one under 18. Now, short-term rental hosts can have their own requirements if they want somebody to be 21 or 25, and then the tenant or guest would have to comply with that. We know commercial or social events, and although that is not defined, that social events would be like bachelorette parties, weddings in the backyard, those types of activities. It shall outwardly appear as a residential dwelling. If it's in a residential neighborhood, we don't want it to look any different than the rest of the neighborhood. We don't want it to adversely affect the character of the neighborhood. And that was talked about from the very beginning. And as I've started looking about short-term rentals across the country and talked with other cities and host compliance, who talks to cities all day long about it, that is a high concern, and we do not want to affect the residential character. No sound equipment, amplified music, or musical instruments would be allowed. So there's no band in the backyard. They would also have to comply with any of our noise ordinance or disturbing the peace ordinances that are already in place also. And parking ordinances. Any vehicle there cannot violate any current Norman parking ordinances. I have come to find out that this next one, I believe, is probably one of our most important, is must have a local contact. That's somebody that can come in a short time, I think we say within an hour or something, and be a contact for the neighbors or for the tenant that, or the guest that is renting. And we're going to have requirements in there that has to be posted in the short-term rental. But I think that is probably going to be one of our most important aspects of this, is that each short-term rental host have a local contact that can respond pretty quickly. It's also going to be real important in our monitoring service, because we've got a 24-hour hotline that'll be involved, and they'll have that local contacts number where that can be contacted. And then they've got to keep updating the information. Licensing requirements on the application, which I'm really excited to say is all mobile. You can do it from your phone or any other mobile device. When I get into just a moment talking about the monitoring service, that's going to be kind of cool that you can, people who own these can do it online. They can pay their fee online. They can pay their taxes on the tax collection online. I think that's going to be really cool. So again, this is just information on the licensing. You've got to know who owns it, mailing address, and it's got to be the owner of the property. It can't be a tenant who wants to like sublease it out. It's got to be the owner of the property, and we know who the owner of the property is through our contacts with host compliance. We will look for if they have any city code or state violations. They're going to have to upload, and you'll do it from this mobile registration, some insurance information. Once we get started, and they should have already been paying occupancy taxes, we'll know that, and we'll want them to do that. They're going to have to, in their application, how many bedrooms, what is their occupancy in there. We're going to ask for a layout of the property with an on-site parking plan, just so we'll know. They've got to have, fire escapes and escape routes noted in there. Egress for windows in the bedroom must be operational. Obviously, we want them to have smoke detectors, carbon monoxide, and fire extinguishers, that the property is in compliance with anything we have within the city, maintenance, building, electrical. And this last one, and then annual inspection. And if anybody has questions, we can talk to Jane a little bit more about that, but that will work like our annual inspections already we do on hotel, motel. With my contact, my representative from host compliance, and I've talked to Tulsa. Tulsa had already passed their ordinance and then got online with host compliance, and they've been on with them since January. Just in the month of July. So it wasn't like, and they have 650 or 700 in Tulsa, something like that. It wasn't like there was a huge rush and all of a sudden they had 500 people applying, So it's come in, and I think we'll be able to manage that. And then I think that's how we'll be with our inspections. But that is going to be, we may find some kinks that we need to work out, but from talking to Tulsa, I feel like the pace of it's going to be very manageable. And then it was important, and in most every discussion we had about notification of neighbors. If it does turn into one that they have to do a special use, they'll have to follow the special use process or procedures already lined out to get a special use, and there would be a notification of property within 300 or 350 feet. The notice here is not like that. It's very similar to the historic district notification, that they will notify, I'm reading from the ordinance, immediately adjacent to or directly across from the street or alley or any direction from the subject property that there's going to be a short-term rental there, and that they also in that notice there'll be the name and address of the property owner and the required contact and any other city office phone numbers that need to be included. And that's something we will get supply to them, and so they will be able to get it out to those folks. There won't be that many. I know that I've had conversations with a few neighbors that have said, well, but that's really just a notification. There's not really a protest for them. It's not that type of a notification, but it will let the neighbors know it's there, who's running it, and who they can call. And I think that'll be very useful. The issuance of the license requirements, same information. We've got to know the address and the holder and bedroom information, and that it has that the structure has a valid occupancy, that it's something that city has said can be occupied and still can't have any violations. I believe Councilmember Patron had brought this up a number of meetings ago. Stillwater, I kind of took it out of Stillwater's ordinance, that if you've got a homeowners there, this can't be in any conflict with any restrictive covenants or deed restrictions or lease agreement that may affect that property. We want information to be posted inside the property so guests will know. So it's just another level of information that, yes, this is a licensed facility or a short-term rental, who the operator, or if they have a property manager, who is that local contact, what are the occupancy limits, if there's any noise restriction, if there's a burn ban going on, if there's water restrictions going on. We want all that posted. We wanted to post about the trash and recycling dates, and I have a feeling that most of the short-term rental hosts do this type of, they have this type of information provided to their guests. I have seen other short-term rentals outside of Oklahoma, and usually there's a packet in the facility in the home that gives you all this information, and that, again, they're going to say it prohibits these social events and commercial events. To renew, you've got to have a renewal fee. We will know if you've paid your hotel motel taxes. That's going to come in monthly. They're going to be able to do that online. Mindy Ains in finance, well, she's the one who gets those types of records anyway. She's pretty familiar with the host compliance. It's going to still be a learning process for both Mindy and I, because I guess by default, I'm the point person, and I will be the one reviewing the licenses and the complaints that come in, and we'll be working with Mindy about the tax collections. I'm excited to do it and a little nervous about it all at the same time. And that we can deny that if all this information is not provided. And the final one is the license denial, suspension, or revocation. If they fail to comply with any of our conditions, we'll deny it. If they don't upload a copy of their insurance, or if they don't upload a copy of their parking, if they're missing any part of the application, it can be denied. And if the property has violations of the city or state code within 24 months, so that's 2 years prior to submitting the applications, the city may deny, suspend, or revoke. And that's on their frequency of the repeated violations, whether a violation was committed intentionally or knowingly, and then finally, or if there's any other information that demonstrates the degree to which the owner occupant has endangered the public health, safety, or welfare. It doesn't say convictions in court. It says information. So if there's information about a property and they apply, they can be denied. And again, though, if they're denied or suspended and they want to, regroup and reopen or restart, participating in the short-term rental market to get a license, they'll have to come back through the special use process. We worked on this a long time, and just kind of borrowed from a number of different cities throughout the country, and that's how we boiled it down to this. I can't say exactly where we got them all from, because I think I started with looking at New Orleans and have traveled around the country on Google looking at everybody else's short-term rentals. Okay, the host compliance monitoring service, I am really I'm really pleased about this. Again, they've just been, they don't call themselves customer service representatives, they call themselves customer success representatives. And when I was home during the COVID, during that about 5 weeks, I started putting this together and worked with one salesperson, and she got me to the people who were building the software, and then I've got our personal representative. So I just wanted to show this one page. When I open up when I get on, on the web page and sign in, it's web-based. The first page, I didn't reproduce it here. There's a background of all the different social platforms that host compliance uses. Airbnb is like saying Kleenex or Clorox. I mean, everybody calls it that, but that's just one. Those are just those guys in 2008 who started it in their apartment in San Francisco and put out an air mattress, basically. And $30 billion, industry later is what they developed. But there's 30 to 50, they tell me, of these social platforms. Some are beach vacations, so obviously nobody would advertise on that, but there's lots of it. And host compliance, somehow, again, I'm not the tech whiz here, they sweep those platforms all the time. So if there's a new host advertisement comes on, they're going to know it. And then they would send out a letter and tell everybody about the process. But this is the first thing that comes up. I did this last week, and when I looked at it today, it was 186. So if you look over here, that's little, I know, that's Norman, and all of those little green dots are short-term rentals that are advertised on one of those. I can't really make it bigger, but when I'm looking at it in live time, I can get down and see the street almost, and then I can click on the little green dot, and it tells me the address, and then I get quite a bit of information. And so this is a week or so ago, and that kind of tells you there was about 190 today that said 186. That's awful teeny tiny. I know you can't see it, but back a week or so ago when I was typing this up, I think around 79% or so are single family homes that the whole house is rented. Most of them have 3 bedrooms. A few have 4 bedrooms, but the majority are about 3 bedrooms. There's a drop down that when I start to look, I can get the listings of every single short-term rental listed in Norman. I get a wealth of information, and the data is unbelievable. And I'm going to just really work on trying to figure out how to use that data to our advantage. But I see the owner, I can tell every social platform that they're on. Once everybody's licensed, it'll tell me if they're licensed. If there's a complaint, I can go to the complaint. If there's a place for comments, that if Mindy puts a comment or I put a comment on it. So there's a lot of interaction with that. When I've been spending more time over the last week or so getting ready for tonight. And there are some that come up not yet identified, and I asked what that meant. Well, they are very careful when you look on an address, how they determine that they've got that address, because they use information from the county assessors, and they really look at the outside of the house. They sometimes look at just 2 different pictures. They might look at the VRBO one and the Airbnb one. I mean, it's amazing the information that is available out there. But so they're very careful about how they make sure that they believe that that's the one. I can look at how many possible nights are rent or it's used. A lot of it is sometimes an estimate because they go by minimum nights. If the property says how many nights you have to do it, it's 3 nights or 2 nights. They just are able to really look at the data, and I'm working on it. I'm gonna get better on it, but there's a lot of information out there, and so I just think for the money, it's not much. And I'll just go over it real quick and then give you guys a chance to ask me some questions, because I've had some emails. I've received about 15 or so myself. I've had some phone calls with folks, and so I kind of know some questions that going on out there, and I have some answers. But the address identification is what I've just saying, that we've identified pretty darn close every short-term rental already in Norman. The compliance monitoring, it's so when they start to be licensed, I'll be able to monitor that, who's licensing, who's not, and letters will go out that are produced by host compliance on City of Norman letterhead type stuff. The 24-hour hotline, I'm real excited to see how that works too. They staff it, so we are going to get on our new front page of our city's website a link somehow. Deidre and our staff is working on that with IT, and there'll be a link directly to the short-term rental page where they'll be able to then click onto the registration, which will start taking them through the registration so they can get registered. Or if they want to read the ordinance, it's going to be right at their fingertips. And then I'm working on some questions and FAQs for the page. So when people go to that the short-term rental website, they'll be able to understand what's going on. One really kind of cool thing about so they get a call on the hotline. I get here the next day. I'll look at the complaints. I can actually listen to the recording of the call that came in from whatever neighbor, and then we'll help direct to take care of some of the problems. They also will call the non-emergency number of the police department from their 24 hours. So I think that's going to really help. They'll have the local contact person. So there'll be somebody, I believe, that when the neighbors have problems or concerns, somebody's going to be there. I'm not saying it's going to work perfect the first week, but I'm real excited about that. The rental activity monitoring, tax support, they're able to tell pretty close to how many nights and at what rate they believe that short-term rental was rented per month. So when the tax form comes in with their money, and it'll all be paid online through a web-based place called Stripe, and Mindy and Finance has set all that up. And so they'll be able to pay that, but we'll be able to say, whoa, you only said you had 2 nights rented. I know we can go back and go, look, we've got an estimate that you rented at least 23 nights. So then there's an audit process we can go through, host compliance, that they will help us figure out and get documents from the host of the STR. So I think we're going to be able to, know that we're getting not 100% exactly, but pretty darn close on the amount of taxes that they owe. And then these two mobile and able, that they'll be able to do their tax collection. We'll be able to do the tax collection, and they can sign up online. I mean, that's saving a staff person. They could still come in. We could walk it through if they want to do it in person, but I mean, people who are advertising short-term rentals online are going to be pretty savvy about it. They're going to want to go to the website. Boom, boom, they're going to be registered. If it passes tonight, I will in contact with them, make sure I like what the letter says. A launch letter will go out because this will take 30 days to come into effect. I wanted to get started, so a launch letter go out in the next week or so saying, where's my example, saying something like, you've been identified, you have a short-term rental as found on one of more of the websites. We adopted the City of Norman has adopted this licensing. We can put whatever we want in there. And here you need to go to this website, get registered. And if you have any questions, and then it'll be signed by me. I'll look every day to see who's come in and see if they need to be approved or not. They'll send like another letter after that. It'll, the first letter usually doesn't get everybody. And then they'll do a follow-up letter. And then as new people come on, they know, and the letters will go out. So our staff, me and Mindy and Jane's staff and code, it really won't take staff time. It's going to take a little more of my time, which I'm kind of a fun, different thing for me to be doing, is learning this software program, and that they really built for us. But I did it. I've done some practice, and believe me, you all know I couldn't even get the little share thing up. I was able to get through it. So I think I believe will be what makes our citizens feel comfortable, and won't be as taxing on staff. So that's all I have. If I do have some questions, I didn't know if you wanted to just ask me some, because I have a feeling there's some that I have some answers to. So.
All right. I'm sure
How do
we
I get
have,
this stop share? Okay.
that actually helps so I can see more people.
Yeah.
Council members, who wants to start with questions? Councilor Patron and Peacock, I see you next.
Okay, so on the local contact, I think that is a really important feature of this. What happens if, say, the next door neighbor is trying to, we've given them the notice of who to contact if there's a problem. And so they call the contact, they get no answer. Is there a mechanism for us here at the city? What's the punishment for that if the local contact is not contactable?
Well, if they're not complying with everything in the application, which is having a local contact that's ready to respond, I think I'd probably make a phone call the next day and say what's going on, but it could be a reason for a revocation of the license. That is, I think, one of the most important aspects. Is I've been spending some time with it lately, that the local contact is going to be a very important point person. And if they're not available, they could be in violation of their licensing. Brenda's not here. Alan may be able to help answer. It's a licensing. We could also call a license review board on them, bring them in here and say what's going on.
Okay.
So, I mean, suspicion of their license could be the punitive action.
Okay. And then I wanted to just go ahead and have you say, because we didn't mention HOAs, but if there is when you were talking about deed restrictions, HOAs have given up some of their property rights to be in compliance with certain rules that they've agreed to within their own neighborhood. And if they want to decide amongst themselves that they're not going to allow short-term rentals, they have the ability to prevent short-term rentals within that HOA governed neighborhood, correct?
Yes, because I know of some HOAs in Norman currently that they prohibit long-term rentals. They don't allow repeat rentals at all in some. So they could do that if they have an active HOA.
Right. And then can you just say there was 4, you're allowed 4 under this initial program. And then on your 5th, you would need to come for a special use. And how would that look? It would just be someone coming forward and saying, I have this other house that I'd really like to put on the short-term rental market. So will you give me a special use? And at that point, council's going to have to cross that bridge when we get there.
They would, and Jane may want to, or Beth, either one could, I'm not that familiar. I mean, there's the zoning ordinance has provisions if you want to do a special use, and I believe it's pre-development, planning commission, and ultimately city council, just like you would any other special use. I will say I went through the list today of the ones that we believe that host compliance has an address identification. I found 2 owners that had 2 and 1 owner that had 3, and that was it. So I'm not seeing a lot of multiple owners right now. We don't have any. The one person had 3. I didn't look deep enough into it to see if they were all 3 that active either.
All right. Thank you. That's all I have for right now.
Councilor Peacock.
Yeah, thank you. Has there been any discussion on the total number of short-term rentals citywide in relation to a cap or anything like that?
I think Councilmember Peacock, we did discuss that sort of, but never to put a cap on it. We've hovered around 200. When I'm counting, and that's including some that are not identified addresses, I really don't anticipate 150. And as I was looking at some of it today, I think it'll be less than that for the entire city. So we touched on a cap, but how would you do that?
Yeah, I understand it's hard to draw the line somewhere. Thank you.
Okay, Councilmember Hall.
So, Ms. Snyder, we've been having this running conversation for about 2.5 years now. I have followed this closely. pretty sure I might get a perfect attendance pin for attending all the meetings as a neighborhood advocate, except for when I was out of town and sitting in crazy locations, contacting Councilmember Clark and contacting Councilmember Bierman. So we've been in this conversation for a long time, and so it has taken it's evolved. As you pointed out, we've had lots and lots of meetings about this, and tried to find that balance between outright prohibition versus complete absence of regulation. So would you characterize what we have right now as a complete absence of regulation on short-term rentals?
I don't think we've got I think we don't have an absence of regulation, because I think we do have some conditions. We have a number of conditions on them. I think where we landed was in licensing in pretty darn near every zoning district. So I think that there was lots of discussion about that. And Councilmember Hall, you're right. I think you, except me and you and I, maybe Councilmember Bierman, I think maybe she didn't miss very many. That has been a discussion from the beginning, but where we landed was licensing in all zoning districts except those 4, and then a few little extra conditions on the PUDs, SPUDs, and if you want more than 4.
And could you just give a rough guesstimate of how many ordinances you actually reviewed and brought forth to all of the different council sessions for review by the council? You have any idea?
How many different cities?
Yeah.
I've read a lot. I didn't know if I read them, but at one time, I'm looking behind me because I have like 5 big binders. I probably have reviewed 15 cities or 20, because even with Susan Connors, our prior planning director, was here, she was also doing a number of reviews. I always kind of start with like the big 12 schools. I don't know if there are benchmark cities, but that's kind of where I started. I did review New Orleans quite a bit, Austin, Palm Springs, I believe, is going to a ban. But I will say, from coast to coast, the concerns of short-term rentals is the same with citizens. They are, and they're very legitimate concerns. And from New York City to Norman, Oklahoma, they all have the same concerns: is safety in their neighborhoods, the transient nature of short-term rentals, parking, and controlling loud parties, and that kind of thing. That is universal across the country. But I have read quite a few, and Stillwater has passed one, and Tulsa has passed one. Oklahoma City grandfathered in everybody up to a certain date, and then they have to do special use. But everybody, if you already had one by a certain date in Oklahoma City, you just got to keep running it. So I haven't looked to see if Enid or Broken Arrow or anybody like that has passed an ordinance lately.
When did we first have the capability of monitoring how many short-term rentals were operating in Norman?
March of 19.
Okay, so over a year, well over a year, you have been able to monitor, probably with this monitoring service, we've been able to capture where most short-term rentals are operating, right?
Right.
And to me, it seemed like that number has stayed pretty stable. Do you think that
stayed right around 200? It started dipping. Now it was down to 186, and I really think some of those are still not identified. Some folks, when I look at them, some rent for like $25. A few just are some rooms. I saw a really nice house today, and it rented for $75 for the whole house. I was like, some of those there's pretty good deals, and I think we'll see some folks drop out. They won't want to, just won't be worth their time or the money to go through the process. So I think we're going to lose a few. So I'm curious. I'm very curious about that.
Yeah. So over that year and a half, and even during the last few months during a pandemic, that number has stayed relatively stable, right?
From what I've looked at now, I did not look at all of them to see if they were renting.
Yeah.
If they've stayed busy in February, March, April, May.
Yeah. I think one of the things that I think you probably, I think this may have been in the staff report. We can tell where these short-term rentals are. We also can characterize what types of units they are, I guess I'd say. So I think in the staff report, it said that 77% of the current short-term rentals that are operating right now in Norman are in single family homes.
Right. So it's never hit 80% that the times I've thought about noticing that number, but it's hovered around 78 to 79% are single family. The whole house is rented, owner not there.
Yeah, do we have, so that 77%, would you say that it's a freestanding home and the owner is not on the property?
That was what I would believe, because they characterize them as single family.
Okay. Okay. So over that last year and a half or so, I know that you've also monitored with our police dispatch folks the kinds of complaints that come in that would be related to a short-term rental.
Well, right. I did that this week. I talked to records, and I just had him do a query with the words Airbnb, short-term rentals, a couple of things like that. So I could have missed a few. There really haven't been that many. There's been a number. One, I feel like calling the owner. They apparently have a problem with their alarm, because there's probably been at one place 4 or 5 times that the alarm was set off. We did recently in July have a house that was called for a disturbing the peace, and that tenant has been cited with disturbing the peace in municipal court. We had one that was a loud party, and the police responded. I'm not sure, I just am reading call notes, so I don't know how they got a hold of the owner, but the owner showed up and kicked the people out of the house on the spot. There was another one that police were called because the tenant had felt like somebody was stalking them, and they came for them. One poor tenant, I think it was at an apartment area. The management company thought they had checked out, and so when they came back, they had just thrown away all their stuff. So that I thought that was a little sad for the tenants. And then there's been one property recently that we have had quite a few calls on. But really, when I looked over it, from January 2019 through this week, there just haven't been a lot of calls. And I could have missed some by the query I had them run. I mean, I could have missed some here or there. I know I spoke with our code enforcement. We've had two properties that have really caused some issues. But other than that, I have not personally received any of the complaints on any, except for 2 particular properties.
So how do residents get remedy right now?
Just like you would if it's your neighbor where you live right now. If there's parking, a couple of those were to somebody had parked on a sidewalk, and they were called for parking issues. I mean, if you got parking issues, you've got to call the Norman Police Department. During the day, the parking service officers can come out. If it's a loud party, if it was in my neighborhood or anybody's neighborhood, they would respond accordingly. If the tenants are, and they can still be called. If it's disturbing the peace, loud parties. Now, I know that's frustrating to neighbors, and I know those, if there are any of those watching tonight, they're thinking that just is hard and it doesn't work. Well, it is not easy. That's the truth. I mean, the police get out there and what's going on, and that's why I've come to believe this local contact is so important, that they can be called to be over there. I did speak to Captain Barber today and ask him if it was possible to, as these locations get licensed, that I have a contact with the police department, and that address, that information can be put. New World is our computer program that keeps all the dispatch information. And so I could say it's at 123 West Main, and then when a police officer or fire department or whatever goes to respond to that home, it's going to have a note that this is a short-term rental. So the officers will know when they go up, they get there, that they're not dealing with a homeowner. And so I'm hopeful that I can get that worked out. So it'll be a notification in our police computer system that they'll know when they show up out there.
Well, I know as I was tracking this as someone in the, as a neighborhood advocate, I guess I would say, there were several other people that attended all of these meetings pretty regularly that were, I believe there was a residence that had lots of issues in Ward 8. And I think that's probably one that you're referring to. And that's been some time ago. And I think we've gotten
Well,
solution
we
there.
actually filed an injunction against that property, and they were not allowed to operate. And then we really started. I kept telling their attorneys, "Yeah, we're working on it." Since that time, I think they've been renting it as a long-term rental. I did not see it in the list. The neighbors have called me, and I spoke to them anytime they had a question. But at this point, I don't believe it's operating as a short-term rental.
Mhm. And then, of course, I think we're all aware of, we have another one right now that's really been causing problems for their neighborhood. And, but other than that, can you think of any other, other than just parking complaints or?
Not that I personally
Okay.
know of. That's why I contacted Code today, because they would get that, and they got it on this last property that we're having trouble with, and a letter went out to them. I mean, that Code doesn't have to call over to legal and say, hey, we're going to send this letter. They act on how they do. And that owner has been notified. I personally spoke to the owner myself also.
Okay. And I'm asking all those things mostly because we've had a lot of engagement on this issue in just the last few days. And I really appreciate residents that are engaged and want to understand how all our city processes work. And I welcome them to the table to have all these discussions. And so I think in a nutshell, what the primary issue is with most of the emails that we have all gotten or phone calls has been this whole notion of operating an Airbnb or a short-term rental in an R1 residential district. And I think it's important to just give a quick summary of how we have tried to deal with that issue and how I've tried to deal with that issue myself over the last 2 years. And, what we're talking about tonight is what compromise looks like, and trying to find that balance of addressing and regulating what is already happening, and trying to understand the sharing economy and how we deal with that with city ordinances. And so I think, we've done the best we can to get to this point. I think I'm going to stop right there. I'm going to have some other comments later because I see some other council members that want to have questions, but thank you. And thank you for all the work that you've invested in this. Appreciate it.
Thank you. Councilmember Foreman.
I just have 2 questions. So if we know that someone is doing the short-term rental and they fail to comply and register and do all that, or we've revoked their license, but they still do it, what do we do to enforce to shut that down?
Well, there's a penalty section in Chapter 13 under licensing that they can be cited, and the fine is $50 to up to $750 and or 60 days in jail. So they would have criminal charges filed against them. I mean, I'm hopeful that we don't have, I mean, I'm being naive, I know, but I'm hopeful that we don't run into that. But if we do, we do have a process for that.
Okay, and then the second question is, say we have the worst case scenario, a house on campus corner, parties, loud, all that stuff. When there's a fine assessed, is it to the renter or the rentee?
Well, it depends. If they're not I'm sorry, I spoke right over you, Councilmember Foreman.
No, you're fine. You're fine.
It's you light up in little lime green when you start talking. I should be careful. Just like a tenant was issued a disturbing the peace. The actual person who rented that property, they were the ones causing the loud noise. So she actually got cited. She's from Lawton. But if they're operating illegally, it'll be the property owner.
Okay. All right, that's all. Thank you.
All right. Any other questions from council? Councilman Bierman.
Hey, Jeannie. I feel like we have all aged a decade since we started working on this. A dozen meetings, 3 committee chairs later, here we are.
That's true. I know I made a little timeline today. It was quite a lot.
Yeah. So my first question, and I can't believe that this is something that in the dozen meetings we've had on this, I can't believe I never caught on to this exact possible issue. So when we talk about a license being revoked, we talk about it being revoked from the property. But what if an owner has more than one license? How are we handling that? Because my sense, and maybe I'm completely off base here, but my sense is that if we're having persistent problems with a property, obviously we're cycling through the people who are actually renting the short-term rental. The one common denominator there is the owner, who maybe isn't providing enough information, isn't monitoring their own listings carefully enough. So do we feel that it is penalizing enough to simply revoke the license from that one property? Or should it be the owner that is subject to license revocation, which would mean if you have multiple properties and one of them is a serious problem, best get on that, because otherwise you might not be able to operate short-term rentals in this city.
Right.
It's at that one property.
I had never thought of that, but
Me either.
But I believe under that section about the license denial, when it says, or any other information that demonstrates the degree to which the owner has endangered public health, safety, or welfare, I think we could have a strong argument that it's not attached just to that one location.
Okay, so the ordinance provides enough flexibility.
I
in that
believe
regard
so. I
to-
had never honestly thought of that circumstance, but.
Well, clearly we don't have all that many people operating more than one short-term rental in this city. So, I mean, I don't think that it's going to be a huge problem, but I just wanted to ask that question. My second question actually comes from one of the many emails I received on this over the last few days, and I've responded to every single one, and with the exception of 2, they all have been much more understanding after being given some additional information and backstory about what we're actually doing here. And one of those people actually responded back to me because he is the chairman of the county equalization board. And he wanted to know if the city would be willing to share information, so like the public information about the licenses, let's say, with the county assessor's office, because they approve the homestead exemptions. And so if a home is being used as a short-term rental while they also claim their homestead exemption, they're no longer eligible for that tax exemption, and those taxes should be collected to the benefit of the citizens of the county. So can we work with the county and connect with the assessor's office and figure out a mechanism by which we can share at least enough identifying information so that they can address the homestead exemptions?
I did just talk to Brenda earlier in the week about providing the names from the information I have from host compliance. If they're licensed, I believe we can provide an address. We can release an address. But you're just coming up with all kinds of new ideas tonight. I hadn't thought that, but I certainly will. We will get together with them and figure this out.
I really appreciate that, and I think that the county assessor's office would appreciate that too, because it's apparently something that they've been trying to figure out how to get more information on. I should probably also shoot them back an email and let them know about this monitoring service that they may want to pick up for county-wide, because that would help them too.
Right, and we use their information. I don't know how they did it, but we gave something and they gave it to us, and we hooked them up, and because we get parcel numbers and everything.
Okay,
so
well, that sounds great.
Add that to my list.
And then one last point, I just think it's important for the residents who might be watching this, that someone who is renting a home cannot apply for a short-term rental license, that it has to be the owner of the property. So if you have a long-term lease for a particular property, whether it's 1 year or multiple years, you may not go and acquire a short-term rental license, that only the owner of the property can make that decision, which I think is also important for people to recognize. So
I really appreciate all your work on this, Jeannie. I think it's long past time we established licensing and some regulations for something that has existed in Norman for over a decade. And if we do nothing, short-term rentals aren't really going to be going anywhere. So we might as well make them safer and collect the hotel motel tax and provide neighbors with some additional recourse and opportunities to address nuisances at the residents next door. So I really appreciate this, Jeannie. Hopefully we'll be moving forward on this tonight.
Send me your contact information of who you just talked to.
Yes, I will. I'll forward it to you.
Any other questions from council regarding this item?
I don't see any.
All right. This is an opportunity for members of the public to make comments regarding this item. Are there any public comments?
There are 3, I think, and they're getting lined up. Elise has some comments, and I have some too, so I don't know how you all want to do this.
Yes, I'll read my public comments, Mayor, from social media. Robert Campbell, Ward 6. So with this online tool, the city of Norman will be able to calculate the number of days that Normanites will be displaced annually from housing stock. Congratulations. Also from Robert Campbell, Ward 6. Pimps aren't going to complain. Johns aren't going to complain. Sex workers aren't going to complain. Victims will be afraid to complain. Patrick Schrank, Ward 6. What criteria is used to grant a special use? Quality of other STRs, ratings from guests, whether the certain neighbor next to the 5th rental doesn't want it next to them. That's all my public comments, Mayor.
Thank you.
I'd rather let the people go first and then I'll read my comments.
I don't see public.
Yeah, me neither.
Turned itself off. I have to.
The laptop turned off because nobody was in there, so they got to turn it back on. I'm going to read one of these while we're waiting. This is from Lindsay Gibson. She's from Ward 2, and she's thanking Council Member, Planning Commission, and staff for working to devise a fair and mutually beneficial ordinance for the short-term rental industry. As a 4-year industry veteran with over 220 reviews between my 2 Airbnb listings, Ward 2 and 7, in Norman, this is a step I've looked forward to since the topic was first raised. As an Airbnb host, I've been awarded the distinction of Superhost for the past 13 consecutive quarters. My overall host rating is 4.94 out of 5 stars. My properties are clean and healthy, and I maintain good relationships with my neighbors. I believe that a rising tide floats all boats, and that by regulating the short-term rental market in Norman, the overall quality of Norman's listings will improve while benefiting the city with a currently untapped source of tax income. I believe that our Norman neighbors who have had negative experience with short-term rentals in their areas have valid concerns. However, I strongly feel that regulating the industry will ameliorate these issues. I encourage you, council members, to move forward with this ordinance.
All right.
Am I on or?
Yes, you are. Go ahead, sir.
My name is Art Shipple. I'm Ward 1 with Kate Bierman, whose question actually called up one of the points that I didn't hear addressed in this at all. She was talking about the multiple property licenses, but in the city of Nashville, in Tennessee, they've had a problem with a lot of people buying up multiple properties, leasing them out on short-term rentals. I can't talk with this thing. Sorry, I have breathing problems, so wearing face diapers hard. They have people buying multiple properties, renting them out because short-term rentals, they make more money than they would on a long-term rental. So when they're doing that, they've actually driven up the price of real estate in Nashville to the point where low-income people can't afford housing anymore. In particular, they're seeing a lot of historically Black neighborhoods are being cleared out entirely because, people who don't even live in Tennessee are buying properties in Nashville, Tennessee, because of the proximity to the commercial and tourist attractions. They're renting them out on the short-term rental basis. And they're pricing all the working class people entirely out of the neighborhoods. And by the same token, they've also had a problem with people out of town. It's happening in Nashville, it's happening in other places where people are doing title theft to make it look online as though they own a property. And then they do a bait and switch routine. I think it was Vice did a in-depth coverage on this, where they had people were being offered a really beautiful property at a really reasonable price. When she said that $75 for the nice house, it reminded me of exactly what I saw on that one, because they were talking about they would offer a great price for a nice mansion. And then when you got there, when you got in town, there was an email saying, "Oh, sorry, we had a plumbing problem. We're actually gonna have to put you in this other house that I own." And so they would rent the same property 3-4 times in a weekend to different people, none of whom actually got to go to that property. They all went to hovels and basement apartments. And because Airbnb actually has a system where they rely on the renter's feedback to rate the rentees, or the person renting the property out rates the people who come and stay at their place. So they have a feedback rate. So if you go someplace and they say you were a bad tenant, then it's going to be hard for you to get in at, you get a bad tenant rating in Nashville. It's going to be hard for you to get a place in Albuquerque because Airbnb is going to store that thing. So most people save their really, really big complaints, and they just suck it up and go, "Oh, okay, well, they screwed me over, but that's how it goes," because they don't want to get that bad mark on their part. So I was wondering if this monitoring service, does it have some independent method of validating whether these people are legit and whether they legitimately own the properties they're renting out, how many of these properties, and are they actually providing the service to, because we're worried about what the people coming in are going to do to the neighborhood, but what we're not worrying about is that somebody is using this as a cash mill and scamming multiple people who just say, "Well, I got scammed in Norman, but hopefully it won't happen when I go to New Orleans." And so does this have some type of monitoring service coming back? And one thing in particular, I noticed earlier, she said, well, she said the license, well, it'd probably go for all of them. But if they're separate license applications for separate units, I think a good lawyer is going to say, well, that you revoked that license, but you didn't revoke this license, and you'd have to fight about it in court. So, and I didn't see any of those points actually being addressed in anything that we said tonight. But in particular, like in Murfreesboro, Tennessee, on the other side of Nashville, home title theft has become such a thing that people are actually so cocky about it. They're advertising properties on Zillow, for sale and stuff, and people are handing over money orders and things, because once they got started going, "Oh, I pretend I own this property to a short-term rental." Hey, well, not only can I rent it out short-term, I could sell the property and I still don't own it either. And so that, we need some kind of way for this authentication service to give feedback to go to Airbnb and I don't know what all the other names are, but to, you know, tell them, hey, look, don't list that property because it's a scam. Because right now Airbnb is kind of, it's a he said, she said thing with, you know, the person who stayed there versus the person who claims they own it. And a lot of times that's a front company, it's a shell. And there's a guy in San Francisco who's being pursued by the feds right now because he had shell companies, and each of them really owned one or two properties. But when you trace each of those companies back, they were owned by a larger shell that owned 10 or 12 in like Chicago and New Orleans and Nashville and in Austin, and San Francisco was a really big one. And you know, there's people who are 15 and 20 deep to rent the same apartment in San Francisco, and none of them are getting it because the guy who's offering it doesn't own it, and they don't even know it's the same person because, you know, it's as Charlie is offering the apartment, you know, at 123 Main Street, and Bobby's offering the apartment at 123 Main Street on a different, you know, different site, and Gary on this one and that, and so does this monitoring service have some way of getting back and letting the clients know, hey, that's overbooked because there's multiple people claiming to own it and none of them really do. You know, otherwise I foresee people, investors coming in and buying up property, particularly with if we ever get over this nonsense about the COVID shit, people will do it for, like, we got people renting space, people paying $20 to park in a lawn to go to an OU football game. What are they going to do if they get the chance to, you know, say, oh, well, you know, I can rent a nice Airbnb at this house, you know, on Elm or College, and be right there by the game and walk to it. And it's sold, you know, it's rented out on 6 and 8 and 10 platforms, you know. Right now, I don't see any way that we're going to prevent that. And so maybe the scam hasn't come here yet, but it's going to, you know, and Nashville has got so bad that, you know, people are literally going in with what they think are titles and finding out, oh, that's not really the title. Somebody downloaded a copy of it and made their own notary and watermark on it. And you know, I just, it seems like we're coming in with a license that would have been great in 2008 or maybe even 2010, but there's a lot of scams involved in this industry that are not being addressed here.
Thank you.
Anyway, those were my points.
Probably was. Hello, everybody. My name is Ryan Hauser. I admire your endurance. I'll try to keep my comments brief because I know you've been here a long time, as have I. I do run an Airbnb here in Norman. I live on the property and I have a small outbuilding. And I had some specific questions about the implementation of this law. I do support it. I think, you know, some regulation is certainly warranted, and I appreciate all your work on it. But I did have a question about the inspectors. How many of them are there? And if there's going to be 30 days to get in compliance, I don't want to be out of compliance, certainly, and I have guests booked up to 3 months. And so I don't know how many inspectors you have to inspect these 150 or so or more places. So that was a question I had. I also had questions about, you know, once they inspect it, if there is something they feel is out of compliance or that you need to correct, how long it will take to get them back, because every day one's out of compliance is revenue lost. And So I was very concerned about that because 30 days is not very long to inspect all those properties. So in addition to that, I had a specific question. In the staff notes, I noted that on page 2, and I don't know what kind of force or effect for definitions these might have because I don't see this language in the ordinance itself. But under the general conditions, it says STRs are not permitted outdoors. Well, I guess you can't pitch a tent. In an accessory structure, shed, garage, or in a recreational vehicle. I guess my question goes to the garage. I mean, there are many garage apartments either over the garage or attached to the garage in some way. And I didn't know if the council had considered that or if those type of apartments would not be in compliance. I sort of read it that you couldn't just put somebody in the garage. But if I'm incorrect about that, and I didn't see it in the ordinance, as I said, but since it is the staff report, I didn't know if it had any kind of force or effect in regard to the understanding of the ordinance. So I guess those are my questions. I don't know if anyone has any comment on them. I'm trying to keep this short.
I have no comment. I'm looking at you, Jeannie.
Okay, I was looking at you, Mayor. I didn't know if I needed to comment. Right, that one about the garages and accessory structure, that is in the final draft. That's been removed. So that's no longer in there. The inspections, and Jane, are you still on? Yeah, the inspections will go through our code enforcement. We recognize that we're not going to get to everybody in the first 30 days. So, because we talked about a number of different ways how to do inspections, and for now we have fallen that at least we want this first year to be inspections. So that will be something that we will coordinate as they come in with code. And I'm going to let Jane, who supervises code enforcement.
So we have one inspector right now that does the hotel motel inspections, and those are on an annual basis, obviously, and she does those with the fire department. So those are typically done, I think, in May or so, but you know, we have 5 inspectors. We have 5 code officers. So we do have different code officers that we could schedule to get out for these inspections. I need to visit with them and see, you know, what their schedules are and everything. But I mean, we'll do our best to get you a quick turnaround. We'll have to get the inspections and get them out there and let them take a look at what you've got on site. And then they'll let you know what you need to bring up to code.
And Mr. Hauser, I don't anticipate, you're sitting here thinking, well, when do I get to start renting? I don't, that may be like, it wouldn't be that inspections are pending or something, because that's going to be on our end. And we're not going to make it be 4 months later and you'd be wanting to know, well, I've gone, when are you going to let me operate? So we had discussed that, and it could be just in the note, because I'm going to personally oversee every application that comes through in licensing. So we'll keep them scheduled, and it may just be inspection pending, something like that.
Okay. And finally, my last question had to do with tax collection. I know that some jurisdictions, or at least I've heard tell in some jurisdictions, they actually work directly with Airbnb or HomeAway or whatever the platform is, and they take the money out themselves and pay it to the municipality. Has that been looked into, or is that even possible?
So we've looked into it, and we're not going to do it that way. Airbnb has no audit provision. I mean, we have no idea who's paying what when Airbnb just cuts a municipality a check. So you'll do a hotel motel monthly tax report online, and you can pay it online every month. And then we have a way that, I mean, we'll be able to look and see if we think somebody's too high or too low. And again, I want to say to everybody, I mean, we're going to run into some, you know, some tweaks that we're going to have to do along with this monitoring company, but it's going to make it really easy. I think as a host, you're going to be really satisfied with the ease of it all, because you'll just set up an account through Stripe, I guess, and we'll get it paid online. I think you'll be real pleased with it.
and this is super specific, and I'm sorry, but is there a specific day of the month, end of the month, everyone's due on the same day? Or
Oh, I did not ask that question of finance, and Mindy's not here today. Ryan, if you want to call me tomorrow, I will get you that date. I guess I didn't have anybody from, she's not here. So,
okay.
but I think it's the end of the month. I believe she's told me it's the end of the month. Oh, there's Anthony. I'm so sorry.
Yeah, the current hotel motel taxes are due at the end of the month, yes.
Okay, thank you. I think that's all I have.
Okay, I'm sorry, Anthony, I didn't see you over there.
Everybody go to sleep. It's late.
Thank you.
Thank you. I think he left his glasses. Good evening. My name's Rick Trepanier. I live in the Brookhaven neighborhood. As Jeannie knows, I've bothered her a few times the past several days. Basically, what I wanted to express, as I have in an email to the council members, is that living in a house directly across the street from this particular establishment, since it's only been in operation for maybe 7 or 8 months. Over the past couple of 2 or 3 months, the situations with the people coming in is getting more disturbing. For instance, the neighbor to the north had an incident back in June, excuse me, where 2 intoxicated people showed up on his front porch at 2 a.m. in the morning, tried to gain access or into his home. He's got 2 young children there. He confronted these people. Obviously, they were drunk, did not know where they were at. He let them know. Later that night, there was more excitement outside, more noise. So that was one event. Another, this would have been on 4th of July. We had 11 cars that showed up. Most of them were from Texas. I noticed at least 2 people per car. This particular establishment advertises 16 plus people for that home. There must have been at least 25, maybe 30 people. That weekend got a little bit crazy. One of the occupants actually confronted one of my other neighbors, who asked them to just respect their privacy, and he wanted to fight them. So we're having those issues. I've had to clean up beer bottles, trash, and I'm across the street. So we're all affected by this, and it's really quite a serious situation. From what I understand, I filed a complaint with the zoning department. And I understand, in talking with Jeannie, talking with the zoning department, that obviously you're not receiving a lot of complaints over or out of many of the other establishments. My concern especially is that the allowance of these type of establishments in a R1 zone neighborhood is, I think, is just too much. We don't have the citizens in that neighborhood don't have the option under this current ordinance draft to even express any objection to somebody coming in. All we're going to get under this current draft is we're going to get a notice from whoever the establishment owner is, telling us that, or for somebody that would come in, that there's going to be one set up next door to you. And at which point you don't have any choice except to take it. My concern, once again, with this ordinance is essentially we're getting this crammed down our throats. And in R1, these are areas that just should not be subjected to this type of an establishment. Zoned R1, as I'm sure all of you know, are pretty much a gold standard for neighborhood living. these people, my neighbors, everybody's trying to raise families. They got young kids. And the last thing that anybody wants to do is go home at the end of a hard work week and have to put up with this kind of nonsense, because you cannot relax. You cannot get any rest because you don't know what's going to happen next. And I'll admit that it's not like that every weekend. For example, last weekend, there was 6 cars that showed up. Seemed to be an older group, relatively calm, no problem. That's not the norm. What we were experiencing is what I explained to you earlier, just a lot of rowdiness, excessive noise. So essentially, we don't get to enjoy the peace and quiet that we should be able to enjoy for living in the neighborhoods that we live in. I can tell you my property taxes are quite high, and I certainly didn't expect that I'd have to live across the street from such an establishment. I've been in that neighborhood since 2001. So this is really a shock to me that this was even going on. I've seen the activity over there get worse. Didn't realize it was an Airbnb until one of the neighbors had approached me and asked me if I knew it. And then obviously it all came together. So ever since I found out, I've been trying to dive in, come up to speed, try to understand the ordinance, and just trying to figure out what's going on here. I'm just surprised that our local government doesn't seem to think that having these kind of establishments move in next door to families is a problem. And we're looking for our quality of life. I can tell you, having experienced this, there is no quality of life that occurs starting on Friday evening when they start coming in. And it stays like that till Sunday morning when they move out. So I'd hope you all would take this into consideration. My request is to possibly just eliminate these from an R1, just not allow Airbnb in R1 zone neighborhoods. And if that seems to be too excessive for you, then at least table the vote for passing this tonight. And I'd like to have a discussion, possibly bringing in the possibility of having the neighbors make the decision as whether or not we want this coming in next door to us and into our neighborhoods. I can tell you, since I got involved in this, we've been trying to notify as many people as we can. We put out about 1,800 flyers or notices over the weekend. And as I walked my neighborhood, I delivered about 800 of them and had an opportunity to talk to some of my neighbors that were outside at the time. Every one of them absolutely did not want this or does not want this in their neighborhood, in our neighborhood. For that matter, in any of our neighborhoods that are especially R1, where these are single family residents. The whole purpose of a zoned R1 is so that, once again, we don't have to put up with this kind of nonsense. So once again, I'd like for the council members to reconsider passing this tonight. I would be more than happy to sit down with anybody to discuss this, see if we can't find some other alternatives before this is engraved in stone, because obviously once you pass this, our rights are pretty much gone and we're not going to be able to do anything. Now, listening to Jenny, and she's explained it to me, you've done an excellent job in putting the ordinance together for most places. I just don't believe that an R1 neighborhood is the appropriate place to have these establishments just automatically set up. The entire city looks like you've canvassed this to ensure that the short-term rentals can be put in pretty much anywhere. There are definitely places that are more appropriate for short-term rentals. I just don't believe that in our R1 and even R2, that's the appropriate place for these establishments to be set up, at least not without, at a minimum, of the approval of the residents, especially those that are going to have to live next door to these type of establishments. Because Because once again, my experience has been very negative, and I'm very concerned what's going to take place as we move on down the road, especially if they do start having football games again. It's going to get crazy. We saw 11 cars for the 4th of July. I can imagine seeing twice that many. I can see, just seeing big parties at this house because it's a nice house. It provides a lot of amenities, and the people that are interested pretty much, I think their idea is they paid their money, so they're coming in to have a good time and to hell with everybody else. So, because we just, you have provided some means for complaints and so forth. The problem is, once these things start getting out of control, it's too late. It's already happened. The problems have already occurred. Yes, we can call the police. They can show up. You can find them. You can do whatever you need to on an administrative level. But the problem we had, like on the 4th of July, these incidents pop up, and unfortunately, we can't have a policeman sitting out there the whole time. So next thing we know, are we getting in a fight with these people because we've asked them just to keep it down? So that's a real issue that I think you all need to have a little bit more consideration for. Because I'm assuming that none of you have had to live next door to one of these establishments yet. I certainly didn't think I was, but sure enough, we are. So once again, I'd ask that you table the vote for tonight so that we can have an opportunity to discuss maybe some alternatives to especially the R1s.
Thank you.
I'd be glad to answer any questions if anybody had them.
I actually do have one. So this house is in my ward, and I was wondering if Jeannie, if there's clearly there's a bunch of complaints about this particular Airbnb or whatever, whoever's carrying it. Is there the ability to not approve a license based on what we're hearing now? So if enough of his neighbors can come forward and say this license should not be granted on this particular home because they're clearly not complying with complaints from the past, why would we issue them a license going forward?
Well, and Councilmember Patron, I fall back to that section on the license denial, suspension, or revocation, that part C about any other information that demonstrates the degree to which the owner or occupant has endangered the public health, safety, or welfare. I'd have to, unless a license comes through, I wouldn't be able to say one or the other, but that would certainly, I think, be a way to give a way to deny that. I do note, I have been doing a little looking while we're sitting here talking. It appears that property is now up for a long-term rent. It's advertises for long-term rental right now. So there may be some movement in that.
They've sounds to me like they burned their bridge to be able to have an Airbnb, and
but it does look like maybe they're trying to rent it long-term instead of short-term rentals.
Okay, I'm happy to talk to you about this at another time, and I appreciate you coming down to talk about it. And we have been getting your emails, and I appreciate those too. So hopefully we'll get this particular issue remedied for you.
I do appreciate, I'm sorry, go ahead.
I was just going to say thank you.
You're welcome. And I just, even though this is my problem, because of where I live, I'd also like you to give great consideration to the other citizens in this city that could possibly be having to deal with the same situations. I don't have any other information from other areas or other establishments. I only had one, it's a third party comment that the gentleman in our neighborhood knows of some people that live, this would be east of 36, directly east of Brookhaven, which there's also an Airbnb. It's been there, I think, for the past year. Their problems and their complaints were during the OU football games. And obviously, everybody knows it's, I mean, everybody wants to have a good time. I'm all for having a good time, but their traffic concerns were pretty significant from what I understand. So it's just not my house. I mean, obviously, I'm very concerned about our neighborhood, my neighbors, but I'm also concerned about our citizens that could very well be subjected to the same kind of problems that we're having too. And once again, I think one of the better alternatives here is to allow for the citizens of those neighborhoods to possibly have their own decision making on this. Because once again, the R1 is just something that our neighborhoods, this ordinance starts to pierce that veil of what an R1 is. And once that happens, what's next to happen in an R1? Like I said, R1s are the gold standard. It's almost like sacred ground for people wanting to basically trying to, obtain the American dream, buy your house, bring your family in and have a happy life. I can just see that these type of establishments within these zoned areas is not a good way of doing that, because that quality of life that I know the mission statement of the council members is going to get violated real quick for people that have to live with these. Because once again, this is not just about me; it's about all the citizens in this community. Like I said, I have no problem with short-term rentals in the appropriate places. All for the business. But we definitely, I think this is a much more serious consideration. I'm not sure in the 2 years or 14 meetings whether or not these particular quality of life issues were ever considered. And of course, the other issue that I've got a concern with is the property value. I can tell you, in just talking with some realtor friends, that this would be a real negative if you're trying to sell your house next to an Airbnb or a short-term rental. And a prospective buyer finds out, there's a good chance you may not be able to sell that house, or you'll lose that deal, or your property value is going to go down. The only value that's going to go up is going to be the short-term rental house. They're cash cows. I get that. I understand. I have no problem with making money. We all want to make money, but it can't be at the expense of the neighbors surrounding these. And this is
Thank you, sir. I appreciate that.
Okay. Well, thank you all.
Are there any other public comments?
I have several emails. Would you like me to start?
Yes, please.
Pamela Joy Jolly Stewart, Ward 4. She's been a short-term rental co-host since 2017, September. When we considered purchasing a guest house for my husband's large family, we knew on a teacher's salary, this dream was unattainable without a revenue stream. Fortunately, it was suggested we offer the modest house as a short-term rental to fund our dream. This morning, my sister-in-law's family of 5 flew home after a week-long visit for their parents' 50th anniversary. It was incredibly rewarding to block out our calendar and allow them to stay free of charge. It wouldn't have been feasible without our short-term rental income. We have also hosted friends and family of neighbors and are honored they refer guests to us. Hosting has been a tremendous benefit to my family. I'm excited to see that council's finally voting on a short-term rental ordinance. After following this topic very closely for almost 3 years, I want to publicly thank council members and city staff for the great progress that has been made, but several parts of this ordinance need clarification. The intent of the following items isn't clear to me, and I would appreciate clarification for the record. Section 3501, she's got several questions. Item 3 limits the number of parties per short-term rental. Outside of a pandemic, what's the purpose of this condition? Item 4 prohibits any commercial or social events. How will this be defined or enforced? This language seems wide open to interpretation. Item 6, residential character, 7 musical instruments, and 10 local contact in Norman must be available to respond within 1 hour. Applicable to other lodging options, it seems essential that the standards be consistent. License application requirements. If the city council were to require hosting platforms to enforce the license application requirements, such as item 5, collecting and submitted taxes on behalf of their hosts, the challenge of monitoring compliance would be drastically reduced. There are significant differences between the various hosting platforms, and just as other businesses are held to specific parameters, e-scooters, the same should be done in relation to short-term rental platforms in order to reduce the oversight required and necessary monitoring. I have a family member who is a tax accountant, and she shared with me how a client listing a property on multiple platforms ended up owing thousands of dollars in taxes because one of the platforms her client used did not collect all the required taxes. By placing the onus on hosting platforms, it wouldn't be necessary to pay a third party for compliance monitoring, which would result in significant savings. Thank you for your time and consideration. We are eager to submit our application and contribute to the city's budget as a legally operating tax-paying short-term rental. Paul Foster, he is Ward 3, and his wife and he are 20-year property owning residents of Norman opposed to this ordinance and urge our Ward 3 representative vote against it. If the momentum against the council is there to pass this anyway, I would suggest there is a much more fair approach available for the property owning citizens of Norman, which this council can easily adopt. This approach would be to table or strike the ordinance for tonight, or alternately simply make this ordinance not effective until January 1st, 2021. For the reasons and purpose described below, I even offer some simple amended language to accomplish it. Section 133504 of your proposed ordinance provides that the ordinance is not in derogation of or in conflict with any restrictive covenant, deed, restriction, or lease agreement that may be applicable. The purpose of the delay is to give the property owners and neighborhoods through the various HOAs the opportunity to adopt restrictive covenants that they may desire for their particular neighborhoods. There's no reason to impose a one-size-fits-all solution on every neighborhood when different neighborhoods have different needs, different preferences, and different aspirations for their property. For example, persons owning property in the area around or near the university may very much be in favor of being able to themselves or their neighbors engage in short-term rentals of their homes and properties, and they should be able to. Persons owning property in some of the other areas of town may be very much opposed to this sort of activity occurring at all in their neighborhood due to its changing the nature of the neighborhood from a quiet, secluded, peaceful neighborhood with like-minded neighbors respecting each other's property to something entirely different, which isn't that hard to imagine, which they should not have imposed upon them. The property of the city should, when possible, always be put to the highest and best use as decided by the locals. This is part of the idea of zoning. And just as we in this city don't always like having solutions from the state and federal level imposed on us, when we might have better solutions that are a better fit for us locally, in the same way, a one-size-fits-all approach from our city government imposed into each and every neighborhood, regardless of the makeup and particular unique aspects of these neighborhoods, is not necessary. Each neighborhood should be able to decide whether property rentals of a short-term nature are the highest and best use for their neighborhood, and the restricted covenants of a homeowners association can certainly help with this. This very short delay of the effective date of this ordinance shall allow those neighborhoods to take the appropriate action they desire. It is the fairest, most equitable approach to allow property owners to determine at the level of their own neighborhood what their property values and futures will be. Also legally, it may be that a minor amendment to section 133504 is necessary to ensure that what I propose is truly effective. And I request that such amendments be adopted, such as, for example, the underlying language which followed could be added to ensure this protection. This section or any the underlying language is he adds to the section, including but not limited to any restrictive covenant adopted by a homeowners association or otherwise and duly recorded prior to January 1st, 2021, which specifically prohibits or limits short-term rentals of property subject to such restrictive covenant. If you intend not to go with this suggestion, I respectfully request to hear the explanation from Ward 3 and the mayor and anyone else who would offer theirs.
Catherine? Is she still here with us?
I just heard a door. I'm not sure. She had a medical appointment in the morning at 6 or 6:30.
Okay,
I'm here. I don't need sleep.
Oh, there she is. Okay. I thought I heard the door. Was that Beth?
I'm here.
I couldn't see who walked out.
okay.
There's an alarm going off.
He never leaves.
So I'm not sure why my resident chose that particular date, January 21. I'm not sure what that was about, but or why that, if that was an arbitrary date or if that was something to do with his own HOA. But can you go ahead and explain, like, if we adopt this today, residents who have HOAs or who are putting together HOAs, they can pass this at any point. Isn't that correct? It's not like it has to have already been passed within the HOA prior to us passing it. They can adopt it after it's passed and it has the same effect, correct?
Correct.
Okay, so I hope that my resident who sent that email understands and heard from City Legal, it's not a matter of you have to get this done by a certain day. It's a matter of the city's going to pass this. It doesn't go into effect for 30 days, but you, at your next HOA meeting, if you don't want short-term rentals, you should put that as an agenda item on your HOA meeting, should this pass tonight.
And this ordinance won't go into effect for 30 days,
right?
As most ordinances, so there's some time built in with that as well.
Thank you.
This is a short one. It's from Kim White, Ward 4. I agree with the fees for license and for inspection of the STR. I would like the council to entertain the idea of some sort of cap on the number of licenses or of the number of renewals each year in order to ensure there is available housing for those who would like to purchase a home. The unintended consequence of short-term rentals is that the inventory of homes available is decreased for those who want to be full-time residents due to the number of homes being turned into STRs. Please think about this and put some kind of security into the STR wording to keep housing available to those in need. John Feltner, and he, I don't know what ward he's in, but he strongly opposes the ordinance as written, specifically in that it modifies city zoning code to permit short-term rentals within R1 single-family dwelling districts. The city's own planning assumptions predict up to 200 nights rented out annually as short-term rentals within residential neighborhoods. This level of traffic and resultant commercial activity is hardly consistent with the plain English designation single-family dwelling as used in the existing zoning ordinance and would be a great degradation of quality of life both to nearby residents and to residents living along residential neighborhood feeder roads leading to the rented homes. The principle implicit in municipal zoning is property owners consenting to restrictions on their property rights in exchange for limitations upon their neighbors' property rights. Homeowners bought or built-in locations zoned R1, thus sacrificing their own possibilities for monetizing their net properties with the expectation that their neighbors would be held to the same restriction. This proposed municipal sanction for short-term rentals in single-family neighborhoods changes the rules at mid-game as to what R1 zoning means. 200 guests comings and going per year is consistent with neither Norman's present R1 definition nor my environmental expectations as a property owner in Norman R1 neighborhood. Despite good intentions, the proposed ordinance's provisions, which attempt to mitigate effects upon neighbors, don't accomplish anything other than to define that municipal code enforcement will be the venue for disputes arising from neighborhood short-term rentals. The ordinance does not address the real problem: strangers coming and going by the hundreds annually per short-term rental in residential neighborhoods. This is a de facto citywide zoning change, degrading the residential character of most of Norman's residential neighborhoods and devaluing the properties of those who aren't short-term landlords. Simply put, if Norman's homeowners want to live next to a hotel or boarding house, they would have bought or built their homes in areas already having them. This proposal is a radical change in municipal land use regulation, isn't being clearly identified as such, and appears to have progressed well toward adoption without receiving the attention it merits. Those wishing to enter the hospitality business are free to do so, but should do it in places other than neighborhoods zoned R1. Allowing aspiring hoteliers to monetize residential properties, which they acquired in full knowledge of existing R1 zoning, is injurious to the property interests of the rest of the neighborhood's inhabitants. This is a governmental preference pitting aspiring hosts versus neighbors, and is a blatant taking of property rights in the interest of aspiring landlords. One wonders whether internet trendiness plays a role in this proposed ordinance having progressed as far as it has. If the industry in question wasn't somewhat novel and was advertised using old-fashioned signage rather than via online booking services, would a zoning change have been treated so favorably? If a small-scale hotel is acceptable residential use, why not any other service business? There's no thought apparent behind this proposed ordinance. Rather, it appears to be simply a regulatory giveaway of short-term rental owners, as well as another municipal tax. That anyone saw a need to bring forth this zoning change forward suggests that at least some short-term landlords in Norman residential neighborhoods aren't successfully operating under the radar and are looking for municipal regulatory sanction. This tends to confirm anecdotes from other cities having many short-term rentals, that short-term rentals are nuisances in residential neighborhoods. There appears to have been no independent analysis regarding this proposal. The city has not published thoughtful staff work. Both the city staff's and council's analysis posted on the City Council agenda webpage are repetitions of a paid outside consultant's recommendations to making these zoning changes. I note with interest that the paid consultant, who would have nothing to sell if it weren't for a perceived need for municipalities to monitor short-term rentals for compliance with their own regulations, stands to gain an approximate $25,000 annual fee for a minimal automated web monitoring service for the indefinite future. The conflict of interest inherent in this self-serving consultancy arrangement is apparent, but nonetheless, this tainted advice seems to have been accepted without question. Not only is the proposed ordinance change a taking of property rights, it appears to have been considered under circumstances which, under the kindest possible interpretation, favor an incumbent city vendor.
Madam Clerk, we've had a request for all the emails that were read tonight. Could you forward those to council to make sure that we can review them again? Thank you. Are there any other public comments? Was that it?
There's someone,
Okay.
I think.
Are there any other public comments?
What about the YouTube ones?
We already did those.
Okay. All right. Are there any other final comments from council regarding this item?
Well,
Stephen's got a comment.
Councilmember Holman.
Just a couple things, because I have been involved in this issue since it started a couple years ago, and I've been in all those meetings, committee meetings about it, and it's really, I think there's been some misunderstanding about it. We're really trying to regulate something that already exists, as opposed to really allowing it. And we had some very intensive discussions about what is a commercial use in a residential area. Is a rental house a commercial use in itself? Just in general, if you rent a house out, is that a commercial use? How is renting a house out different than a short-term rental? And we came to the conclusion that the only difference legally was 30 days. 30 days is what is the difference between a short-term rental and a long-term lease. It's not a 6-month or a year lease, it's 30 days. So we had a lot of discussion about what is the difference, what does that mean? And we did have a lot of discussion about the one gentleman's point about people outside, investors from out of state coming in and buying homes, buying a whole street of homes and using them for short-term rentals. And that definitely being a major concern of ours would be that low income or affordable housing stock in Norman would get bought up by people that don't live here and turned into short-term rentals. Or in the case of Brookhaven, there being some very nice large houses that may have swimming pools and nice amenities that would be attractive to large groups of people that would want to come and use it to have a party over the weekend. Or multiple houses like that being bought up in areas like that for that. And so we definitely did have a lot of discussion about those very specific issues and how to address them, and trying to look at what other cities are doing. And as was mentioned before, what we discovered is cities all across the country, big cities to smaller cities like Norman, have really struggled to come up with a good way to regulate this. And what I think what this ordinance allows us to do is to better and more efficiently address the problems that we're hearing from neighbors about like some of the ones that have been brought up tonight. And as was mentioned by Councilmember Patron in her question, HOAs that I think and just maybe confirm me if I'm wrong, but yeah, HOAs that currently would prohibit it, that stays in place. What we're doing does not override existing prohibitions or restrictions that are in HOAs. And I don't recall there being a grandfather clause included for these if they're in a neighborhood that at any point decides that that their HOA or whatever decides that they're not going to allow short-term rentals in our neighborhood, they would not be grandfathered in, at least the way I understand it, unless I'm wrong. Maybe Catherine could correct me on that, but that they could change it at any time, that this ordinance does not permanently place short-term rentals in their neighborhood or anybody's neighborhood. And so I did want to just be extra clear about that, that if your neighborhood does not want these, you have the opportunity to change your neighborhood rules and not allow them. But I do think right now, as some people have mentioned, they've been doing this in Norman for 3 years already. They've had a rental like this. And for many of them, there's not been any problem at all. But as we know with many aspects in our society and life, it doesn't take it's not all the good ones that we worry about. It's the 1 or 2 or 3 bad ones that really cause a problem that can ruin it for everyone else, or, you know, get people really upset on the whole idea. So I think this ordinance is very necessary for us to deal with this issue and to better address the problems that have been brought up by the neighbors in these emails and the folks that have spoken to us tonight. So that's not even in, you know, talking about the hotel motel tax portion of it, which, you know, hotels do have to pay. We had a lot of discussion about, well, if this is basically a hotel, again, if it's a hotel, is it commercial? Is it allowed in the residential neighborhood? What is a, you know, all that stuff was stuff we really did debate back and forth quite a bit. So I just want to make sure the public listening is very clear that we did really discuss all these aspects in depth, and we've really tried to address them the best we can. Tried to put in some regulations on how many could be owned by by one individual, by companies. And I know that if you can, you know, hire the best attorney in the world, there can always be some sort of thing you can find in the law, and we're always going to have to be vigilant and look out for that. But I think this postponing or waiting doesn't solve any of the problems that we've heard about. These things will continue to go on without any regulation as it is right now. So that's kind of where I'm standing on it after working on this. But I definitely appreciate the comments and questions we've heard from residents about it and about this whole process, really. I don't think this ordinance is the end of city council, us or the next one, having to talk about and address this. And it's not just Airbnb. We've had to deal with this on scooters and bike share, like several technology issues that have come up. And we know that technology can change very fast, and government public policy doesn't often change very fast. And so it's been difficult. And like I said, for cities big and small all across the country, it's been difficult to address these types of situations, whether it be with scooters, Airbnb, and other things like it. So anyway, that's the comments I have on it. And I'll pass it on to my colleagues. Thanks.
Councilmember Hall.
So as always, Councilmember Holman did an excellent summary. And, you know, I just want to circle around to some of the comments that I made earlier, because I personally feel like I'm in such a unique position on this, because when for the last 30 months, the city staff, the sitting council members, interested residents, residents that were being affected by this on a daily basis, sometimes in a very positive way or a very negative way. I've out of the last 30 months, I've been the resident. So I really am sensitive to all of the people who are commenting tonight and who are coming to this issue without the benefit of having been part of this conversation for all this time. So I'm really sensitive to that. So I've been in those shoes for much more time than I've been a sitting city council member. So I've watched now Mayor Clark, but at the time, Councilmember Clark, Councilmember Holman, Councilmember Bierman, Councilmember Wilson, work through these issues over, you know, I think around 18 different meetings. And of course, these are all public meetings. These are all meetings that we welcome input from the public. You can attend just like I did all that time. And I really appreciate the engagement on this issue over the last several days from a neighborhood who's being affected in a really negative way right now. So I just wanted to add just a little bit to what Councilmember Holman said about the struggle and the different points of view that everybody brought to the table. And as a resident who was watching all this and had an opportunity to comment on and off, but mostly watching the process go forward, we did take a position as a neighborhood. And we did work with other people that I happen to live in Ward 4. I happen to be in Core Norman. These kinds of things affect us in a different way. And so I think it's important to find out, to just say that we don't have the option in Core Norman of having a homeowners association. That's not a legal entity that's available to us because our neighborhoods are so old. And so I'm glad that there are neighborhoods in Norman that have that option, but that's not an option for us, which is one of the reasons that I'm glad that we've gotten to the place that we have, because this is offering a lot of protections that aren't in place currently, and it gives neighbors next door a way to contact, and we do have a licensing fee and so many things that as I was reading back over all my notes for the last couple years, I had kind of forgotten about this, but I actually had positions representing Ward 4, basically a lot of interested people in this topic in Ward 4, and what we were hoping to see the council accomplish. And I think we understood from the very beginning that, as you mentioned, Councilmember Holman, short-term rentals are part of our fabric. I mean, there's no getting around that they're operating, and they've been operating for a long time. And so the challenge was, how do we regulate this? And so as a resident, we were hoping to get licensed to operate short-term rentals. And we were hoping to get specific conditions, such as the number of licenses per applicant. We wanted people to be guaranteed that they had insurance, that we had an inspection option, that we addressed the sound and music issue, that we address parking, which in Core Norman is a daily issue. We really wanted a prompt local contact, and we've accomplished that. We thought it was really important to level the playing field with people who are operating a bed and breakfast, who do pay hotel motel tax and do have to comply with even stricter regulations than we're talking about tonight. So it was important to us to collect hotel motel tax on each short-term rental. We're accomplishing that. It was really important that we provide some support for our city staff, because as I like to say often, it doesn't matter what your job description is on city staff, you're probably overworked and you're probably underpaid. And we don't have the kind of city staffing that we should for a community our size. So it's really important to have this monitoring service to help us be able to do the enforcement piece and to collect the license fees and the hotel motel tax. So we advocated for having an appropriate fee to be able to cover all of that, and we've accomplished that. So as a resident in an R1 neighborhood, I am completely sensitive to all of the arguments that have been presented tonight, and trust me, these have all been hashed out. And my position really hasn't changed much from when I started all this, because I thought it was really important to treat short-term rentals like similar to a type 1 and type 2 bed and breakfast establishments. And I really advocated strongly that we have special use for short-term rentals in R1. There are other things that we advocated strongly for. Well, we hashed that out and consider different points of view. And in the end, we weren't able to convince the majority of council members that that was the way it should go. So I'm saying all that because I think we have had a long conversation. I think we have found consensus. It hasn't been easy. I think we still, amongst my colleagues, have differing points of view about this. But I think what we all agree on is that it's time to implement what we've been developing for over 18 months. And I, for one, I think at our last meeting, publicly stated that this is something that I will be carefully watching, and that I am willing to give it a chance to work. And because we haven't had a lot of complaints all these months, that we're mindful of that, and we're mindful of the egregious bad actors that we're having to deal with in current time. And so I think we're all committed to addressing those things and working out the kinks as we go along. And if other things come up along the way, I will be the first one to bring this all back up and make some amendments and make some changes to make it work. So it's been a long slog, and I really appreciate all of the work that everybody's put in on it. And I am prepared to support this tonight and implement it and move it forward and not forget about it, but see how it's going to work. And I'm very interested in communicating with any of the residents that I've heard from over the last few days, and more than happy to, continue those conversations and see if there's anything that we want to do moving forward once we give this a chance to work.
Councilmember Wilson.
Thank you. Both of the colleagues that spoke before me covered pretty much everything that I agree with. And I love the word slog. It's been a long slog. That's a great word for this. Ever since I've been on council, it's been 3 years. We have talked about this at every retreat and however many meetings. So it's been a long conversation. We have examined, we've turned it over, we've done all the things, we've looked at other cities, we've looked at all different scenarios, we've had consultants, it's a very thoroughly talked about topic. It's not, I feel like the thing for me that it's already happening in the community to the tune of 200 or so properties. So this actually gives us a mechanism to eliminate the problems. And so I actually think this is a win I know it's hard to see it like that, but I think this gives us a way to control the situation, to get to level the playing field for the other businesses that have been playing by the rules, the bed and breakfasts and the hotels, and to get the hotel motel tax. That's a benefit to our whole community and our arts. So I will be supporting this tonight.
Councilmember Foreman.
I was just going to kind of, reiterate what my fellow council members were saying. I think a lot of the concerns I had from people feel like we're introducing this to the city for the first time, and we're not. And I think a lot of people probably have Airbnbs around them and they may not even realize it. And I understand everybody's concerns that they have about who's coming into their neighborhood. But if we don't pass this, we don't have a way of stopping it. So this gives us the tools in place that if someone is, violating all these ordinances that we have, then we can revoke their license and shut it down. But if we don't pass this, then they can continue as long as they want. So I support it, and with Lee, we'll keep an eye on it, and if we have to make amendments or do what we need to, we will. So that's all. Thanks.
That's all I see.
All right. Well, Councilman Patron.
Okay, so a lot of these letters, I've had support and protest on this. And so I think one of the points that Councilmember Foreman just made is the one that I find the most persuasive on this, and that is because there are so many already all over the city, and yes, there are some in my ward as well, without a way to register complaints against the problematic short-term rentals, we have no way as a city to shut that operation or establishment down, because if it's just a sound violation or a parking violation, the citation goes to a tenant. Under this licensure situation, then it goes to the homeowner, and we have a record and can revoke a license. But until you have that structure in place, we're trying to chase down an individual tenant for a $50 parking violation. That's not what really we want to accomplish. We want to accomplish, if you're a serial offender in this and you have 16 different cars, like the gentleman was speaking of, then they have no business. They're not respecting the neighbors. They have no business having a license for an Airbnb in that home. For me, on the designation of an R1, that doesn't, when we've had these long conversations about this, people have property rights as well. So we're balancing, and this is outside the scope of an HOA, and I'll talk about that in a minute. But for a regular R1, well, they can already lease out their home. And then when you get to Councilmember Holman's point, what's the difference in a short-term rental versus a long-term rental? Well, it's a 30 days. So even though most of us look at that as it should be a 6-month or a year lease, that's not what the law looks at it as. It looks at it as 30 days. So I circle back around to, until we get something in place, there's nothing that we can really do to help out the residents that really are at their wits' end with this. And again, I think Councilmember Foreman's correct. There's probably a whole lot of these out there, and you probably have them in your neighborhood and don't even realize it. But it is always those few that spoil it for the whole bunch. So let's be able to get those shut down if they're not operating in a way that is respectful to the neighborhood. And having city legal look at this, 6 ways from Sunday, there's really no other way for us to deal with this except for to pass an ordinance that governs this. I think that, and on that note, I really encourage neighbors to file the formal complaint. Call the local person. If this passes tonight, call the local number on hand. I don't care if it's 2 o'clock in the morning. They have to put their name on that associated with that house. Call. File the complaint with the city, because once the record's there, I think we did a 3 strikes and you're out for that license. So, if it goes to a review at that point. And if they're found this is enough neighbors are coming forward and saying, we've all filed complaints on this property, the city's going to be able to do something about it. HOAs. I have brought this up several times, every meeting that we've had. If you live in an HOA and you do not want short-term rentals, at your next HOA meeting, you would need to pass the rule for your neighborhood to prohibit short-term rentals, just the same as you have them for your long-term rentals if your HOA doesn't allow for those. HOAs are already pare back property rights for an individual home. You all are agreeing to live under more restrictions and more rules than you would have in a neighborhood with no HOA. So if you want to limit the property rights to be able to have your house for rent or have it for a short-term rental, your board can vote for that, or whatever the process is within your individual HOA. But that's, sometimes it's cumbersome to live under an HOA. They can be really annoying, and someone sends you a letter that says you need to bring your trash can back up. You were 30 minutes late. Bring it back up to the beside your house or whatever. But it's times like this when you have the benefit of an HOA, because you have power in numbers and you can limit property rights. So take advantage of those if you want to in this particular instance, or have that fight amongst yourselves in your HOA to decide whether or not you're going to have short-term rentals. We'll pass that buck on to you all to decide. Please keep in touch and file those complaints if you have them. And if there's anything I can do, holler at me. Thanks.
All right, is that it? I think we got everybody. Well said, everyone. We've spent what feels like a lifetime on this issue. The whole time I've been on council, and we've done our research and we've looked at this sideways, upside down, backwards, inside out. And I'm grateful for all of your work, Jeannie, that you've done. I know this has been a project I'm sure you're happy to see move forward so we can, again, be responsive to the Airbnbs that are already in Norman, as well as collect that hotel motel tax that is crucial because people aren't staying in hotel motels like they were, but they are apparently still staying in Airbnbs. So with that, Madam Clerk, will you please call the roll? The motion on the floor is to adopt the ordinance on second reading.
Councilmember Bierman,
Aye.
Councilmember Perry,
Aye.
Councilmember Patron,
Aye.
Councilmember Hall,
Aye.
Councilmember Wilson,
Yep.
Councilmember Foreman,
Aye.
Councilmember Holman,
Yes.
Councilmember Peacock,
Yes.
Mayor Clark.
Yes.
The ordinance is adopted unanimously on second reading.
Thank you. I'll now entertain a motion to adopt or reject the ordinance on final reading.
Second.
The motion on the floor is to adopt the ordinance on final reading. Madam Clerk, will you please call the roll?
Councilmember Bierman,
Aye.
Councilmember Perry,
Aye.
Councilmember Patron,
Aye.
Councilmember Hall,
Aye.
Councilmember Wilson,
Yes.
Councilmember Foreman,
Aye.
Councilmember Holman,
Yes.
Councilmember Peacock,
Yes.
Mayor Clark.
Yes.
The ordinance is adopted on final reading unanimously.
Thank you. Item 22, miscellaneous discussion. This is an opportunity for citizens to address City Council. Remarks should be directed to the council as a whole and limited to 3 minutes or less.
If we don't have any public comments from YouTube right now.
I have one for Mark. I must like him a lot to read this. I'm just saying. Not safe for work. Please watch Human Trafficking. Not safe for work. This award-winning film starring Donald Sutherland and Myra Sorvino lays it out for you. This is a reality in Norman. 5115 is one of the many scenarios of sex trafficking that Norman City Council approved tonight. It occurs in an upscale home in an upscale homeowners association with security involving fraternity-aged guys and underage girls. These scenarios are real. Oprah Winfrey did a special on sex trafficking in the OKC Metro. We live on an international highway near a casino with lots of game days. People pay exorbitant amounts so they can do whatever they want. We already have a short-term rental under investigation by the FBI for sex trafficking, including a baby. These rentals push the poor workers, the disabled and elderly further out into the edge of town and run down properties to be able to rent. The properties will lay fallow for much of the year with Norman citizens could be living there. My degree in counseling, I have had rape crisis training. I have spoken with survivors. I have worked with survivors. I have spoken with abusers. I have worked with abusers. We did not have to go down this road simply for profit. If the police have not been getting complaints about short-term rentals, it could be due to highly organized crime rings. Short-term rentals are approved for every zoning type possible in Norman. Imagine living in an apartment and having the apartment above you rented for short-term rentals and it being a party apartment all night long and into the morning, and you can do nothing about it. Renters have almost zero rights in Oklahoma. They're not a part of a homeowners association. Very disappointed by this ordinance, especially coming from our majority female city council. I apologize for the foreign language description of this video. This is the one link that I could find that had the full movie. This movie is graphic, but it is not pornographic. It was a Lifetime movie and it was award winning. I guess in Norman, it's any vice for a price. The ordinance flies in the face of the party house ordinance, nuisance ordinance. This will be detrimental to our already suffering local hotel motel industry. That's it.
All right.
Ellen, I know we got another email in from Brandy Studley. She wanted to make sure that you read it. You're muted, so I can't hear you.
Sorry, was that miscellaneous? I didn't realize that. I thought it was about the conference.
No, she CC'd me on it. It says miscellaneous comment, Brandy Studley, Ward 1. Oh, she might have sent it only to me. I'll read it in my miscellaneous comment then. Sorry, Ellen.
All right. Any other public comment for miscellaneous discussion? Okay. Then we will move on to council comments. Councilor Bierman.
All right. Well, then I am going to, for everyone who doesn't know, I received a comment for miscellaneous comment from Ward 1 resident Brandy Studley. And she says, first, I want to thank Councilwoman Wilson for her service, beg her not to go, but understand as a woman who puts her family and sanity first, understand why she is leaving. Secondly, I would like to thank all of you for listening to your community and looking at alternatives to help the community. I am disgusted that you are having to deal with the hate and lies against some of you put out by a group that has recently developed in Norman that includes members of the FOP. The fact that they have become so unruly shows a further need of why we need to police the police, take away some of their responsibilities that they are not able to or educated to properly handle. You all are great community leaders, and we appreciate you making the right decisions even when it is difficult to do so. Again, thank you. That was from Brandy Studley, Ward 1. And kind of glad that she sent that to me because I didn't have a whole lot to say in my miscellaneous comments tonight, except that at some point in the next, I guess, 4 weeks, I'll be having a, I suppose, virtual ward meeting, a ward meeting of some kind, whether it's masked up and in person or virtually, to talk about the bond elections coming up next month. And so I will try and at least get that scheduled by the end of the week and try not to have it be too late in August. That way, if I need to have another one, then there'll be time to do so. But we do have these bonds coming up on August 25th. Please take time to read about them. Information is being sent out by the city, and council members, I'm sure, will also be sharing information. I am happy to talk with anyone individually about what these bonds entail, why they are structured the way they are, and then what my thoughts are. So if you're interested, please let me know. I'm happy to talk to you more about it. I've gotten a few emails already and really appreciated the opportunity to set the record straight on some of the questions that had come through and to have a conversation about these bonds, especially the municipal complex renovations, which have been so long coming. So that's pretty much all I have, everyone. I know it's going to rain for the next couple days, so everyone be safe. Everyone mask up. Enjoy yourselves. Have a good night.
Thank you, Councilmember. Councilmember Perry.
I'll just say good night and be respectful of your time.
Thank you, Councilmember. Councilmember Patron.
I'll be fast too. I just first and foremost want to thank so many members of my ward who have sent such sweet, kind messages. And I know I can probably speak for several council members to say that we truly appreciate you and just how respectful and supportive you've been. So with that, I wanted to say thank you. And then also, I echo what Councilmember Biernan said. We will be having my brain's getting tired, but town hall for our ward for the August 25th bonds. I'm still working with the city staff because we're going to be using an online mechanism, some different platforms to be able to reach as many people as we can. And we also will probably do some mask up outside meetings as well. But I definitely look forward to fielding all the questions and having city staff there to discuss the different bonds. And I think that that's all I have. Thanks, guys. Good night.
Thank you, Councilmember Hall.
I'll keep it short as well. First of all, just want to publicly thank the Young family for their generous donation tonight and their commitment to scholarships so that we can provide more Norman children the opportunity to participate in youth sports. So thank you for that. Also want to just remind everybody that the last day to register to vote is Friday, July 31st. So got a few more days to get registered to vote. And the deadline to request an absentee ballot for the August 25th election is Tuesday, August 18th at 5 p.m. And also trying to consider ways to communicate in a broader fashion to Ward 4. I've really missed seeing you all in person. So hopefully we can come up with a creative solution to communicate about the important bond issue that's coming up. Other than that, thank you all for hanging in with us tonight if you're still watching. And I just want to personally thank all of the people who have been engaged the last few weeks and especially the last few days over this particular topic. It always is helpful to us to hear from you and to understand your point of view. So thank you for being engaged, and I hope everyone has a good evening.
Thank you, Councilmember Wilson.
Hey, I just want to say, first of all, I'm very tired. 9 o'clock is my bedtime, y'all. Thank you to Brandy, who wished me well from Ward 1, and all the people who have commented, sent me texts, emails, private messages, yelled out the window of their cars they're driving by. Kind words. It's important because in case you haven't heard, August 11th will be my last council meeting. August 13th is my official end of service to Norman in this capacity. I will be resigning my seat because we are in the process of buying and selling our current house and buying another house in another ward. It sort of accidentally happened. I was going to probably do this towards the end of my term. Sorry, my brain just died. But the time was right and we found the right house, and it's a good seller's market right now for our current house. So because of coronavirus and the businesses being all over the place, it's just time for us to move on. So I have enjoyed my colleagues. I won't say much more than that. I really appreciate each of you. This was a 7+ hour meeting, almost 8-hour meeting. These happen regularly. So if you think that these council members that make $50 a meeting are just, I don't know what people think that we do here, but these are dedicated folks that really care about the community. So I appreciate you all. Good night.
Thank you, Councilmember Foreman.
Councilmember Peacock and I were invited by the park superintendent to do a Sutton Wilderness cleanup, and that will be August 8th from 8 to 10 a.m. I know it'll be hot, but I would encourage everyone to come join us, come meet two of your newest council members, and we could talk about bond issues and other things facing the city. Other than that, I'm too tired to think of anything else. So everybody have a beautiful night.
Thank you, Councilmember Holman.
So in the 7+ years I've been on council, I've never taken more than 3 days vacation before. And so this past week I took 9 days off work and didn't get on Facebook or Instagram. And I drove 5,000 miles and visited 5 states I'd never been to before. So 5 of the least populated states in the country too, I might add. So lots of nothing for miles and miles and miles. It was wonderful. So just what I needed actually to get re-energized and face the many challenges we all have ahead of us this coming year. So I'm glad to be back in Norman and back to work though. So do want to mention that Community Planning and Transportation Committee on Thursday at 4 p.m. City of Norman YouTube channel. We're going to talk about a couple items, one being cottonwood trees. Our city forester has some information about an issue that involves those particular trees and what we might be able to do to remedy the situation that is impacting some residents. And then we're also going to talk about something that I've seen in a lot of other cities some have been doing it long before COVID-19. And we've briefly talked about it before here in Norman, but especially since COVID-19 and reduced capacity for restaurants and businesses, a lot of cities have been changing policies or working on ways to allow businesses or restaurants to use parking spaces that are outside, of course, to expand or to, instead of parking spaces, using the parking spaces for outdoor seating for restaurants specifically. In some states, indoor seating is completely banned altogether, and they're only doing outdoor seating. So that's something I wanted to look at though in Norman. And so we had that item added to the agenda so we could at least talk about if there is any policy change that would be needed and what we could do to help out our businesses, our restaurants specifically that are being impacted by reduced capacity indoors. And I'm all for less parking in general. So if we can make better use of parking spaces, I'm for that. And hopefully it seems to be in other cities a way that's helped businesses deal with the COVID-19 issue as well. So that's going to be on the Thursday CPT meeting at 4 p.m. Anybody can tune in. And then I will also be looking to have a ward meeting in regard to the upcoming bond election. We're talking about doing a virtual meeting. I'm thinking about trying to do one potentially at Reeves Park, outdoors, of course, and then maybe just something where I'm there, maybe somebody from staff is there, and we just ask your questions and we'll do our best to clarify anything or about the process, about any of the projects, anything like that. So stay tuned for that. And outside of that, I just appreciate all my colleagues, city staff, and all the residents of Norman, as others have mentioned, that have really reached out. It's been really overwhelming. People that I don't even know that have reached out to me, that don't live in my ward, that have reached out to show support and just say they really appreciate, maybe they haven't always agreed with me or something, but they really appreciate the dedication and the time that we spend doing this job. So that's all I got. Thank you all. Good night.
Thank you, Councilmember. Councilmember Peacock.
Yeah, like Councilmember Foreman mentioned, just see everyone August 8th at Sutton Wilderness.
All right. Well, thank you all for your work tonight. City staff, you're amazing as always. To the Young family, thank you for that transformative gift. And I think the one thing I've got going on right now, check out Pioneer Library System. I'm doing book club with the mayor again, fighting that summer brain drain. It'll be a virtual format, so we'll do the best we can. And I'm trying something tomorrow that I actually asked our new council members and no one took me up on it. Instagram Live. Don't worry, guys. I'm working on a Facebook Live. I'm talking to Annalise. Get to know the new council members. But tomorrow at 3 p.m., you may have heard about this Vote 16 project. while I wish it could claim that it was my idea, because I think anything that gets more people voting and paying attention to local government is a good thing, I can't. But I am interested in learning more, and I'm always impressed by the intelligent young people we have in our community. So I will be interviewing Elliot on Instagram Live tomorrow on my Instagram page at 3 p.m. He's also partnered with League of Women Voters, who I think that's Sunday at 2. It's around social media. And then Councilmember Bierman will, I think, address that in oversight. But just to clarify, that would have to go through resolution to the Charter Review Board and then voted on by the people. So just wanted to clarify that for everyone. But I appreciate all of you. Another 8-hour meeting in the books. But we do good work here, and it's an honor to serve this community. So with that, this meeting is adjourned. Good night, everyone.
Bye.
Good night.